All right. All right. We're back. I hope everyone had a good weekend. Mine was decent. It was hot. Um, Great up. Good to see you. And Kevin, I'm never late. I always arrive precisely when I mean to. That might be the only Lord of the Rings quote I can make. Just was never really into it. 3 cents. Good to see you. And Great Duck, I mean, my leg does have Bluetooth. I really don't ever connect to it because there's no reason to. Plus, I don't think this one actually has an Android app. I think it's iOS only. So I've borrowed my mom's cell phone, but it really doesn't have any functionality for me. Like there are other ones that you can switch modes, like between biking mode or, whatever, but not this one. So the reality is, Bluetooth for this one is just getting it set up, and that's not software available to me. And yeah. Um, so Kova, good to see you, and you, Dante, and you, Luna Knights. And so over the weekend, I did a lot of thinking, which, as you know, is a dangerous thing. But I was thinking about that inverted video, the security camera from the Sally port. And the thing is, I still don't think there's much evidentiary value in the video from the Sally port, if any, if I'm being honest. Because the reality is, we've already seen that the taillight was already broken. It's plain as day at 8 a.m. We have testimony that it was already broken. It's just, to me, it's an incontrovertible fact. What I do worry about is, even though it's really nothing, it doesn't have any evidentiary value, does it damage the jury's trust in the prosecution, in Lolly, in the investigation? Because either, oh, so you're trying to pull one over on us, or are you so incompetent you don't notice this? But it was pointed out, and I seem to remember this. I haven't gone back to confirm because, as you know, I'm trying to treat myself as a juror, so the jurors don't over the weekend get to say, oh, hey, I have a question about this. Let's go back and rewatch it. But it was pointed out that Trooper Sergeant Buchanan tried to say it was mirrored. It just didn't come out right. Because he said, I do remember him saying something to the effect of, the door's on the other side. As in, the door from the station into the Sally Port. And I seem to remember him saying that. Of course, that might be me remembering what I was thinking, because I didn't say anything about the mirrored video that day, because I didn't notice that it was mirrored, but my brain, something wasn't adding up. Something wasn't adding up. Because when I saw the door on the left of the video, I was confused. Because remember, way back when we saw the still photos of the evidence bag of the solo cups, the evidence bag, I believe it was with Sergeant Lank. So we saw the evidence bag, we saw the tail light. So the evidence bag was behind the passenger side. Pointing out the rag on the floor, the door was to the right. And then all of a sudden it was on the left. And it didn't add up to me, but I think I kind of wrote it off as have they moved it? And once again, I didn't say anything because I was trying to process it. But then where I got really confused, and once again, I didn't say anything because I was trying to process it. And, when you're trying to do 4 things at once, something's going to miss out, and the processing is what missed out. Because, paying attention to the video, paying attention to the chat, paying attention, thinking of what I'm going to say, and then trying to process what I'm seeing all at once, you get a bit of an overload. And yeah, that's what I'm claiming happened. But the second video we got from the Sally Port that wasn't mirrored, but it was really dark, hard to see. And that's when I almost said, wait, is something mirrored? Because that one wasn't. But it just didn't add up with the other video. And yeah. So, but like I said, to me, the big danger for the prosecution is they lose credibility. And the problem is, once again, there's really not much, if any, evidentiary value. The, reasonable doubt, well, you've got all the other actual relevant, very highly relevant evidence, but you have a doubt about something that doesn't even really matter. But if you don't have trust, you might doubt the other evidence, and that could be a problem. We'll see how Lolly fixes it. But, as a very bad juror, I did watch the Yellow Cottage Tales yesterday, where he once again interviewed attorney Kevin Mahoney, the Boston criminal defense attorney. He's interviewed him a couple times. I read Kevin Mahoney's blog article because he said pretty much what I'd been trying to say. And, he's a very well-respected, much more experienced attorney than I am. He knows Boston. He's friendly with Yannetti, or at least was. We'll see. Because they're both part of the defense bar in the Boston area. It really is a relatively small club. But watching Mr. Mahoney yesterday, he was saying the same thing I've been saying all along. And I believe he described the mirrored video as a nothing burger because he didn't see any evidentiary value in it. He is of the opinion that Karen's goose is well and truly cooked. He just looking at the evidence, it's it's there. People who disagree just aren't watching the same trial. And and Attorney Mahoney also agrees with me that Jackson and Yannetti are playing a dangerous game. He says, as I have said, they very easily could find themselves facing discipline, if not outright disbarment, for their actions in this case. I shouldn't even just say trial, but in this case. And it's wild to me. If Karen Reed had come to me with $250,000, like Jackson is alleged to be getting, and said, I want you to pro hoc in and, represent me in this murder trial and, give me a vigorous defense. It's like, sure. But if she says, I want you to, do this, what I consider unethical, and, I'm not getting disbarred for $250,000. To even get me to consider it, you're looking at least 8 figures. But it doesn't make sense to me. It doesn't make sense to me. And yeah. Surrender monkey. That probably would be more normal, but yeah. And that, if it wants to show the comment I'm trying to push. So the verdict, well, the Free Karen Reed crowd, the true believers will either say, it's a conspiracy or a miscarriage of justice, it's illegitimate. But a lot of them are just going to move on to the next cause, the next conspiracy. And when you say Karen Reed, they'll say, Karen who? I was never part of the Free Karen Reed movement. And just, nothing to see here, move on. And that's it. People formed their opinions before the trial started based off of misinformation and incomplete information, and there, a concerted effort to intimidate the witnesses. But despite all of the threats, the witnesses haven't changed their stories. It's, so surrender monkey, I would absolutely not be disbarred for Trump. My friend always, incredulously asks how does he keep getting attorneys? They don't get paid. And I say, I don't like him, but if he ran out of attorneys and he called me and said, "Joe, I want you to be my attorney in this case," I'd do it, but there'd be conditions. First off, it would be a $10 million upfront payment. And the contract would have to specify that I set the strategy, I am the lawyer. It would have basically a non-disparagement clause with liquidated damages, just for my own safety, because, assuming we lose, that's a dangerous position because, you don't want the mob set on you. And yeah, and that initial $10 million payment would have to be, in the contract. It's non-refundable. It's, you're not paying for a result, you're paying for actions. So yeah. I think I did 3 cents. I think I saw the butt slap. Can't remember. But yeah. So yeah. But either way, today we are still on the cross-examination of Sergeant Buchanan. The day starts with arguing the motion, which I'll leave it up to you guys if we watch it or not. Technically speaking, as a jury, we shouldn't watch it, but like I said, I'll let you guys decide. My understanding is today is a little fiery. We're taking a little trip to the charming Lincolnshire village of Scunthorpe. My American, audience won't necessarily get that. My British audience will. Surrender Monkey. But yeah, I'm told we're going to Scunthorpe today. I don't know the context, but in the Masshole Discord, Turtle Boy Watch, there's someone posted, Turtle Boy did a video titled "It's Over" or something like that, and comment both sides saying it's over today. I don't have context for that. I don't know what it means. I just have a feeling today's going to be eventful. And frankly, I have a feeling that the prosecution rests this week, because we're finishing up with Buchanan. We're going to have Trooper Proctor today. We've got some experts. We've got a crash reconstruction expert. We've got the medical examiner. We've got the Celebrite expert or experts. I don't know. And then I think we're pretty much on to the defense. And we might have a Lexus expert. Sorry. We might have an automotive expert. But we're getting close. We're getting close. And I'm getting close. But so I don't see answers. I should have put up a poll, but do we watch the motion? Do we watch them argue the motion, or do I zoom past it and go straight into it? My mom has not been watching the trial. When I describe it to her, she finds it all ridiculous, but yeah. Even though I went to Durham, I never made it to Hartlepool. Does Oswald Twistle have something to do with St. Oswald? Obviously been to his tomb, because that's in the Durham Cathedral. But I was counting on someone to make a joke about that. Kfar? I'll let Grey Duck make the lewd joke about you being in and out. I haven't watched it, JT Davis. It's been a while since I've seen a GeoWizard video. But his attempted straight line mission across England was a while ago, wasn't it? Or is this a brand new video? Because I remember seeing him talk about it, but I haven't seen it. So, and I'm not surprised, Kfar. I thought a frauditor also got shot recently. I don't know. I saw something. I don't know. So you did your charity work at Oswald Twistle or at Hartlepool? I certainly wouldn't pronounce Hartlepool anywhere near correctly if I hadn't lived in Durham. But yeah. Okay. Well, that's probably about the time I heard him talk about it, but it's been a while. He kind of pops in and out of my algorithm, so yeah. But and you guys still haven't given me guidance, but I guess that means we're going to watch it. It's not a sidebar. They just haven't called the case quite yet. It's just
find it in the Commonwealth map.
Trying to get right at the right spot is difficult.
It's open to be seated. 22-117 Commonwealth versus Karen Reed. Counsel, and Your Honor, just for your information, at this very second, FTR is not running. Ms. King is the official anyways, and she's on the record.
Okay. All right. Good morning. So we're here on the Commonwealth's renewed motion. Can we turn off one of those air conditioners, please? The Commonwealth's renewed motion for reciprocal discovery and the motion to exclude the defendant's newly provided expert, Dr. Marie Russell. I will hear you on your motion, Mr. Lally.
Morning, Your Honor.
Oh, I'll hear you, Ms. McLaughlin.
Essentially, the Commonwealth is just seeking that the defendant produce what the Commonwealth is entitled to under Rule 14 and what every criminal defendant in the Commonwealth of Massachusetts must produce to the prosecution. It was not until the day prior to trial on April 15, 2024, that the defendant provided notice of all their experts. During jury empanelment, the Commonwealth filed a renewed motion for reciprocal discovery, and the defendant was ordered within a week to produce the expert opinion testimony that the Commonwealth is entitled to. We are now entering, I believe, week 8 of the trial. The Commonwealth has not received any intended expert opinions, anything that those experts, any written reports, opinions, or anything that those experts have based their opinions on. Essentially, the defendant's strategic decisions not to retain their own expert, but rather rely on the U.S. Attorney's Office investigation does not alleviate them or relieve them from their Rule 14 obligations. As it pertains to Dr. Marie Russell, the Commonwealth did not receive notice that she's an intended expert until about week 6 of the trial on May 21st. And it wasn't until May 30th that the defendant provided a brief synopsis of what her expected testimony would be. Essentially, and looking at the balancing tests set forth by the case law, the Commonwealth was extremely surprised by this disclosure. And further, the Commonwealth would put that the defendant's delayed decisions to produce reciprocal discovery is in bad faith. It is intended to ambush the Commonwealth and conduct a trial by surprise.
And that's not how trials are supposed to be done. You have to disclose your experts. And this is frankly unprecedented as far as I'm concerned. The defense in a state prosecution relying on experts from a entirely inappropriate federal investigation, parallel investigation, that it's just wrong. It's ridiculous. They're not the defense's experts. These federal experts, frankly, should have told the defense to pound sand. You want us to testify for you? You hire us to perform an analysis. You don't get to piggyback off of Uncle Sam. But
we are still receiving reciprocal discovery. Over the weekend, we received additional photographs that the defendant intends to use. The Commonwealth is extremely prejudiced by these delayed disclosures. So looking at all the balancing factors, exclusion of Dr. Russell is really the only remedy that's appropriate, given that we are in week 8 of the trial. The Commonwealth cannot seek a continuance. The Commonwealth has their hands tied with how to effectively prepare for cross-examination of that witness, as well as all the other witnesses. We don't have any materials. We don't know what the experts' precise opinions are and what they were testified to. And it's essentially, it is in bad faith, and there's no less severe sanction. So the Commonwealth would move to exclude Dr. Russell. And at this point, we're essentially just seeking the reciprocal discovery that the Commonwealth is entitled to be able to effectively prepare cross-examination of these witnesses so late in the game. Thank you very much.
Who's arguing this for the defendant?
There's no mic at council table, so I'm going to go to the podium with the court's permission. We need to be heard on this.
That's why we're here, Ms. Tinetti.
Thank you. I'd like to start with the most outrageous and false assertion that the Commonwealth made in its motion.
Can I just ask you, that there's no jury here, can I just ask you how long this is going to take?
Between 5 and 10 minutes.
Okay. Because I don't need...
The most outrageous and false. Fuck you.
The hyperbole.
I need to make my argument in the way that I think is most effective for my client. I will keep this brief and succinct, but I have points to make that I need to put on record.
Okay, and I'm the person...
Maybe if you followed the rules, you wouldn't have to put this on the record.
You are trying to convince, correct?
I understand that. The Commonwealth, in a public filing, wrote the following on page 3 of its motion. Quote, during a pretrial hearing on February 15th, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Yannetti indicated no, and that the defense was not pursuing such claim. I was astounded to read that for 2 reasons. First of all, it is false. It is a lie. Second, the Commonwealth has knowingly lied about something where it's easily verifiable that they lied. We pulled the tape from February 15th.
I don't have that.
I'm sorry?
I don't have that in my motion.
It's on page 3, Your Honor.
I have the Commonwealth's renewed motion for reciprocal discovery, a motion to exclude defendant's expert, Dr. Marie Russell. I don't see your name at all, Ms. Giannetti. I'm on page 3.
Sorry, it's not page 3, it's page 4. My apologies. My name is right there on page 4. It says exactly what I just argued to the court. It's about the 5th line down. Starts during a final pretrial hearing on February 15th, exactly as I said.
Okay.
All right. We pulled the tape from that February 15th hearing. Here is what was actually said. This court asked me the following, quote, while we're talking about DNA, Mr. Yannetti, do we need to be concerned about canine DNA? Where do we stand with that? I replied, no, I think this is the only outstanding DNA issue. The court then replied, okay, so all right, we're not dealing with canine DNA. And I said, no. There is nothing in there, contrary to what the Commonwealth has represented to this court in a public filing, that I said there was no canine involvement. There is nothing in there, contrary to what the canine represented to this court and to the public, that the defense was not pursuing such a claim.
You said no canine DNA. You said no canine DNA. If the prosecution misunderstood what you were saying and took no canine DNA to mean no canine involvement, that's not a lie. That's a misunderstanding.
Can you imagine the nerve of the Commonwealth to spin that into...
This is the
Fuck
hyperbole I
you.
don't need. Could you please get to the point?
Your Honor,
We've got a jury coming in 15 minutes.
I understand, but this is my integrity has been attacked. There have been allegations of bad faith that has been attacked, and I need to defend myself and my client. We were only discussing at that time whether canine DNA was still outstanding, and I succinctly replied, no. And they've spun that, or tried to spin that, into a claim that we're somehow waiving our right to argue that John O'Keefe's arm injuries were consistent with the dog attack. And I ask you, have they no shame? I'm sure it's not lost on this court.
Well, fuck you. Maybe if you follow the rules and give the discovery that you are required to give, it wouldn't be an issue.
That this false...
And you have no integrity. You have no integrity. You have demonstrated over and over and over and over again. You have no integrity.
Filing by the Commonwealth comes on the heels of their nefarious attempt to pass off an inverted video, a false video, before this jury hearing this case. Never once during the direct examination of Sergeant Buchanan did they inquire or mention the fact that the video...
Can we please, all right, I'm going to stop you. Please direct your comments to Rule 14 and the reciprocal discovery obligations that the defense has. That's what this motion
is. All. Look at the shiny monkey. Look at the silly monkey. He's not discussing the issue. He's not discussing the issue. The issue is Rule 14, reciprocal discovery.
No, you have a speech you want to make, Mr.
It's
Yannetti.
not a, Your Honor, most respectfully, it's not a speech. It's
Okay,
a
so...
defense of being alleged to have committed bad faith.
So you've moved on from that. So please just focus on Rule 14, and let's do it in two separate parts. So you've changed. You're not calling Frank Sheridan,
No,
right?
we are calling Frank Sheridan.
All right. So you've got a new medical, Dr. Russell. We'll do that part of it separately. Tell me about what you've provided the Commonwealth on Chris Van E.
They've gotten his CV and they've gotten the substance of his opinion from us. And they've had that for a long time. And the court, I believe, has already suggested that voir dire will be done prior to this testimony.
All right, so it's starting to look like we might need a whole day of voir dire, and I'm trying to avoid that. So is the Commonwealth satisfied that when did you provide anything recently since the filing of the Commonwealth's motion, Mr. Yannetti?
Not on Mr. Van Eden, no.
What does the Commonwealth have on Mr. Van E?
Page 2, the first full paragraph. We do not know what his opinions are. It says he'll testify regarding his opinions and conclusions about reconstruction and EDR data obtained in connection with this case. He'll testify to chronological data derived from the EDR, including key cycles and triggering events from the time period in question. I have no understanding or information about what chronological data he's going to testify to, what his ultimate opinions are.
I mean, Linz, first of all, welcome. I wouldn't be happy either. Yannetti is a putz. He's all bluster, no, all fart, no shit.
Anything beyond that relatively vague synopsis that does not comply with Rule 14.
Okay.
Similarly, what's outlined in the rest of the motion, that's all the expert evidence the Commonwealth has received from the defense is contained within the Commonwealth's motion.
Okay. So the defense needs to provide, I'd suggest you listen, the defense needs to provide what chronological data Mr. Van E relied upon and exactly what his opinion is. All right, by the close of business tomorrow.
That's fine.
All right. Now, regarding the 3 experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired
Yet
by the federal
you
government.
still have
and
to
they
provide the discovery if they're going to be your witnesses. Just because you didn't hire them doesn't absolve you of your obligations.
provided a report to us pursuant to the TUI request, and it was
Yes.
specifically outlined that,
And hello, Lisa.
that they could not prep with us for trial.
So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here when
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
And you have not complied with your Rule 14
We
obligations.
can't, Your Honor. We can't.
So you can't, but you haven't. So I'm
Well,
left.
if you can't, then you can't call them. You say you can't, then you should have hired your own experts. You should have hired them. Just because the federal government hired them doesn't mean you can't hire them. You're just trying to subvert the rules, piggyback off of the federal government's teat. But you don't get to do that to subvert the rules, to get out of your own obligations. That's it. To me, if you don't follow the rules, if you're just calling Uncle Sam's experts, they're not your experts. As far as I'm concerned, at best, you can call them as a lay witness. But as a lay witness, they can't give their opinions. They can't give their opinions. Anything they could testify about frankly, is hearsay. And that's not going to work. So, if you want to call them as expert witnesses, you have to follow the rules for expert witnesses, even if it was the federal government that hired them. You're not following the rules, you can't hire them. Yeah, should have spent that Turtle Boy money on, instead of buying Turtle Boy, Alexis, should have paid for an expert witness yourself. It's just, this is bad faith.
With you haven't complied. So we need to get everybody here for voir dire. They can testify in voir dire, right?
Yes.
We need to do that well in advance of their
Okay,
testimony.
that's fine, Your Honor.
All right.
Yep.
And now tell me about this ER doc. Is she an ER doc? I haven't seen her. She's not a pathologist,
Well,
correct?
she's a pathologist, but she has a lot of experience in an ER, which is why she has the experience of having seen dog scratches and dog bites and dog attacks.
All right. So this is not somebody that was involved in the federal investigation, correct?
Correct.
All right. So you need to provide immediately. I want a voir dire.
So, your whole argument, Your Honor, the feds hired them, we didn't, so we can't provide the required discovery. But we're not going to provide the required discovery on our expert witnesses either, who were not hired by the feds. Fucking hell. Follow the rules.
Of her this week. So we can get her here Wednesday, and we want the other folks up here from Pennsylvania this week as well.
We'll make those calls.
So we need to pick a day. Has not spoken to these witnesses from Pennsylvania about the nature of their opinion. You must want it too, to be able to question them. How long do you expect the voir dire of each of these witnesses to take? I went and told the jury last week, last week, that we were going to get them this case by the end of the month based on your representations, which included voir dires. It looks like at least a day of voir dire hearings here.
Yeah.
Yes.
And if it's a day of voir dire hearings, frankly, I'm not going to watch it. I'm just going to be honest. I don't want to watch a full day of voir dire. Frankly, the jury doesn't get to see it. I'm not going to. If they testify, we'll see. If they don't get to testify, oh well.
At least with regard to the, of course, at least with regard to the ARPA witnesses, that's my co-counsel's bailiwick. He anticipates that unless there are, a substantial number of objections during the voir dire, he anticipates being able to accomplish that between 45 minutes to an hour with each of those three. With regard to Dr. Russell, we anticipate a half hour. Oh, I'm sorry, there's only two from ARPA, that's right.
You're only calling two? Which two? Are you calling the two that are certified as accident reconstructionists?
Drs. Richler and Wolf. Yes.
Okay. We seem to have lost courtroom audio. So I can only imagine that Lolly got up to say, everything Mr. Yannetti just said is bullshit. He needs to follow the rules. Otherwise, we win automatically. Thank you, Your Honor. And now I imagine Yannetti's about to stand up and say, fuck you. I set the rules because I'm David Yannetti. Don't you know how special I am? Don't you know that I am the court? I am the law? And besides, haven't you seen me slap Turtle Boy's ass? That pretty much means we win. So, and the judge is saying, I hate all of you. Why do you make my life such hell? Mr. Lolly, step it up, show some passion, object a little bit. Don't let Jackson steamroll over your witnesses. Jackson, take out your heel lifts. You're not fooling anyone. And the bad rug isn't either. I imagine that's what she's saying. And now the fan is saying, I'm going to be noisy and try and keep the room slightly cool by recirculating air. Wait, no. Now I'm just hallucinating. So, time to fast forward. Until we find the jury.
Yay. All persons having business before the Honorable Beverly Code, Justice of the Norfolk Superior Court in Floyd County of Norfolk. Run in, give your attendance, and you shall be heard. By the State of Commonwealth of Massachusetts. School is now open. You may be seated.
22-117, the Commonwealth versus Karen Reed.
Good morning, James. We all met here at 8:30 to try and streamline things. And as a result of what we did this morning, it looks like there'll be some day this week that we will all meet to go through things that we need to go through, but we will excuse you. I just don't know quite yet when that will be. We'll know by the end of the day. And also on the 21st, originally we said we'd be off for the 21st, but again, you know that we don't want to take up any more of your time than necessary. So we will meet on the 21st, but just in the morning because I have a long-standing afternoon that we cannot cancel. So the 21st will be a half a day. So we'll let you know more as the day progresses. All right, I do have to ask those questions. We will always able to follow the instructions and refrain from discussing the space with anyone since we left on Friday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, read anything about this case since we left here on Friday? Thank you. Everyone said no. Shook their heads. Thank you very much. Can we get Sergeant Buchanan, please?
And
The flash drive that
it's still Jackson cross-examining Buchanan, so yeah. And I think you're underestimating the jury. Of course, I could be wrong.
I did.
All right, Mr. Jackson.
So when we left off on Thursday, we were discussing the Sallyport video that was introduced by the Commonwealth on Wednesday during direct examination. Do you recall that?
I do.
When he introduced that video, Mr. Lally asked you several very specific questions about the video, including if you recognize the video in general, correct?
Yes, you did.
And you said you did.
I did.
He also asked you whether you recognize any individuals in the video at a particular time where he paused the video and you used your green laser pointer to point out a couple of individuals that you recognize. Do you recall that?
I do.
And in that pause, you indicated at that time on Wednesday that you recognized Trooper Proctor and what you thought was yourself, the person slipping at the front of the SUV, correct?
I indicated that Trooper Proctor and myself were in the video, and there was an individual slipping in the front of the vehicle.
And you then on Thursday, you corrected that to make sure that we were clear about it. The person slipping was actually the tow driver, not you, correct?
That's what it appeared, so yes.
Okay, I'd like to take a quick look at that with the court's permission at 4:46. May I publish
Okay.
that?
Yes.
This is 4:46. It's the same video that you were shown by Mr. Lally. We're at runtime about 5:37 and 05 p.m.
And remember, the defense is trying to insinuate that the security video has been sliced and diced and stuck back together with crazy glue, and there's bits missing. It's been edited. And the unfortunate truth about security video is it sucks. It really does. And my understanding, once again, I'm a lawyer. I studied finance. I'm not a video expert. I'm not a technology expert. But my understanding is with digital security video, one of the drawbacks is basically you're recording on a loop. And some places it's a 24-hour loop, some places it's a 30-day loop, some, it just depends. And if you realize there's something, you better get the copy of the security camera before it's looped over. One of the problems with looping over is you're putting it on the hard drive and you're re-recording over the hard drive. And Vince, who is late, could probably explain this a lot better than I am. You're really not all that late. You've just had my opening monologue, and then we ended up watching the motion hearing. So we're like 1 minute into the actual testimony. But so one of the problems, though, with rewriting over the hard drive the looping video is you get corruption of the files. You'll get artifacts. You'll get basically sometimes it'll look like there's a ghost just because someone was walking through the frame a month ago and it fucked up writing over that. And yeah, so and that's it. They're usually dirty. They're old. They're, they're not always the most up-to-date cameras. That this isn't super high resolution. Compare it to the waterfall video, which was higher resolution than this, but it was in grayscale, black and white. So which do you prefer? This Sally Port video or the video from the waterfall? CF McCarthy's was the best video. It's just, yeah. And okay, so yeah, it's tape that would have the quality degradation. That's true. Like I said, I'm not a expert at this. It's just you expect hard drives to fuck up, to degrade. They can be rewritten a whole bunch of times, but at some point it doesn't. And that's it. That's what I was trying to describe. The data corruption, data loss, you get the little buzz. Either way, something can happen, and it's not corruption, it's not video editing, it's just the foibles of cameras, of recording, of hard drives. Computers, as wonderful as they are, really suck sometimes. So, the defense is trying to scream conspiracy about it. But what they should be screaming is technology. So.
I'm sorry, I said runtime. I meant time of day. Thank you. As a matter of fact, the time of day would be most easily seen right down here, although it's pretty small from where you're at. If you can't see that, please let me know.
I do not see that, no.
Okay. Your Honor,
I don't see it.
I'll hold off on that question, and I may ask the court for relief in just a moment. If we can play this for just a quick second, and I'll ask you, Mr. Bates, if you can pause it. Go ahead and pause there. Okay, Sergeant, this is the basic.
Exactly, Lynn's method limitation. I like that. I like that.
Video, the point at which it was paused when Mr. Lally asked you to identify the individuals in the video, correct?
I believe it was a different time, but I'm not sure.
Do you remember using your green laser pointer, pointing at the person in the back and identifying that person as Trooper Proctor, and then pointing at the person in the front screen right, mistakenly as you? You remember that?
I remember indicating where the individuals would be, yes.
Okay, and so do you have the green laser pointer with you?
I do.
Could you point at the location where you see Trooper Proctor?
I do not know specifically right now if that is Trooper Proctor behind the vehicle, but when...
See, Vince, I told you you'd be able to explain it better than I could.
Mr. Lally asked me to indicate where we would be, it was in this location here.
You're indicating toward the rear of the SUV.
Correct.
On Wednesday, and I just want to draw your attention back to your testimony on Wednesday, you used the laser pointer and pointed at two different individuals. Person toward the back, and you identified him as Mr. Proctor, as Trooper Proctor, correct? On Wednesday.
I indicated that Trooper Proctor and myself would be in the shot in the rear of the vehicle. And then I indicated that I'm wearing a olive drab baseball hat, and Trooper Proctor is wearing a winter style knit black hat.
Isn't it true that on Wednesday, the question you were asked from Mr. Lally is, Ms. Gilman, from Mr. Lally, Ms. Gilman, if you can just pause there for a moment as the sergeant's almost falling in the video, and the court said, keep your voice up, Mr. Lally. Do you recall that?
I do not recall that, no.
Do you remember Mr. Lally saying, Sergeant Buchanan, with reference to any of the individuals you see in this video, do you recognize any of those individuals? And you responding, I can recognize Trooper Proctor and myself. And you used the green laser pointer in doing so.
Yes, I did.
And that was on this area, may not be to the frame, but this is where the video was paused when you made that identification, correct?
It was approximately at this time.
Okay, so you were then asked after you identified, and at that time you did identify Trooper Proctor, and again, mistakenly, yourself, correct?
I directed the laser to the area where we would be.
Okay, and Trooper Proctor is the one toward the back of the truck.
I Again, I cannot tell you which individual. There are multiple individuals there. I do not know at this point in time where it's frozen if that's exactly Trooper Proctor. I know we were present at that location, and I know what he was wearing for a headdress and what I was wearing.
All right, so you have to move along from this point.
Then why did you, one more question, Your Honor, then why on Wednesday did you indicate very clearly the person toward the back of the SUV was Trooper Proctor? If you don't know, why did you say that on Wednesday?
During the frozen frame, I could tell there were two individuals back there, and I was at one point in time in that location with Trooper Proctor.
That appeared to be Trooper Proctor in the back of the car.
From where the video is frozen right now, I cannot
Move
tell.
on.
So you're changing your testimony.
Move
Wednesday.
on.
Objection.
Are you changing your testimony?
I am not changing my testimony now.
Okay, next question, Mr. Jackson.
You then asked whether the video was true and accurate as in terms of its depiction of what you saw, what you observed in Sallyport that night, correct?
I indicated the video is true and accurate to the location.
And you were then asked whether or not, in looking at that video, watching it, either you or Trooper Proctor approached, manipulated, touched that right rear taillight at any time, and your answer was never, correct?
That's correct.
And while you testified, this is the video that was displayed for the jurors, correct? But it was this orientation, the front of the truck facing right, the rear of the truck facing left, correct?
That's correct.
And for all appearances, it would appear that the right rear taillight of the SUV is the one facing the jurors, if you will, facing the viewer, right? From appearances. You didn't know anything different.
Can you rephrase that question, please?
Sure. Just from the
And I don't know specifically, a year ago, roughly 10 months.
appearance of the video as it is now, the appearance of the video looks like the right rear taillight is the taillight that's facing the jurors, facing the viewer toward the rear of the truck, correct?
As it is frozen, correct.
And on Wednesday, I want to move through this relatively briefly, Sergeant. On Wednesday, you did not mention that this video was inverted, did you?
It was not brought out, no.
Not brought up by, I mean, that's a passive way of saying it. I'm asking you directly. Did you mention that this was an inverted video?
Not on Wednesday, no.
On Thursday, Mr. Lally finished his questioning on Wednesday, then came back on Thursday. You continued on direct examination under questioning by Mr. Lally again to start the day, correct?
That is correct.
And during that testimony on Thursday morning, you also, under direct examination, did not mention that this video was inverted, did you?
Did not know.
And then it was my turn to ask you questions. You recall that?
And once again, the video really doesn't contain any evidentiary value because the taillight's already broken. We have already seen the taillight broken. Frankly, we saw that it was broken as Karen was pulling out of John Reed's driveway or John O'Keefe's driveway at 5:07 a.m. Now, the Free Karen Reed crowd says, oh, it was clearly red, but there was white where there shouldn't have been. It was broken. It was very clearly broken at 8 a.m. when the Canton police lieutenant showed up. Excuse me. So, for the defense, they're trying to insinuate, oh, you inverted the video so that we wouldn't notice that you were behind the passenger taillight, trying to make it look like you were behind the driver's side taillight instead. But you inverted the taillight so we would think, so we wouldn't see you behind the passenger taillight so that you could break it then and there and rush the broken fragments to 34 Fairview, bury them under 18 inches of snow, all while the search team is already there searching. Unless they have a TARDIS, it's not happening. It's not happening. The fragments are already there under 18 inches of snow. This doesn't make any sense. It doesn't make any sense. So I do have the benefit, though, Anne, of the rules of evidence don't apply to me. I can't, I'm not asking questions. I'm making statements. And so Lolly at this point can't argue. Hopefully he makes these arguments in closing arguments, because that's when he gets to make arguments. Hopefully on redirect, Sergeant Buchanan, what time was this video? It was 5 o'clock, whatever. Sergeant Buchanan, are you familiar with what time the CERT team was conducting the search of 34 Fairview? They arrived at 4:45 or 4:20 or whenever. I don't remember. Either way, it was a little before the Lexus arrived at the Sally Port. So Sergeant Buchanan, could you have spirited the taillight fragments from the Sally Port and placed them under 18 inches of snow right under the CERT team's nose as they were searching? No. And it's just, it's all ridiculous. It's just, they're now into the Chewbacca defense. Well, the look at the silly monkey portion of the Chewbacca defense, where it's, look over here, look at this completely irrelevant bit. Don't look at the actual evidence. Look over here, look over here. Keep your attention over here. But it's all irrelevant.
I do.
And then I began asking you questions about the accuracy of this video. And at that time, for the first time, you said it appears that it is a mirror image. It's an inverted video, correct?
I advised you that it is a mirrored image at that point, correct?
Would you agree with me now, as you sit here, that this video, as we're looking at it, is not a true and accurate depiction of what you viewed in that Sally Port that night?
We are.
I would not agree with you, no.
Do you believe that what the jurors are seeing right here is true and accurate surveillance footage of the Sally Port that night?
Yes, it's just mirrored.
Which means what's left is right and what's right is left, correct?
Correct. If the jurors were actually standing where the camera is recording, which it's recording all accurate depiction of activity and events taking place, the back of the vehicle would be on the right and the front of the vehicle would be on the left, but all activity is accurately depicted in the video.
So in point of fact, everything in this video, every bit of it is reversed, correct?
Mirrored.
It's just a mirror image.
So it's not accurate, is it?
It's an accurate depiction of what is taking place.
Sergeant Buchanan, if I were to ask you, was being identified by 5 witnesses.
Asked and answered. He's already answered you. We get it. It's mirrored.
On a tattoo on that person's left arm. And then you go show that witness, or those series of witnesses, an inverted version of a photograph of that person with the tattoo appearing on his right arm. And those witnesses all say, no, that's not the guy. I remember the guy. The guy had the tat on the left arm. Would you think that that's an accurate depiction of the person with the tattoo?
Objection.
Sustained.
Argumentative.
Do you agree with me that an inverted video is not accurate? It's inverted by definition, right?
It's an accurate depiction of the events taking place.
You've reviewed this video in its entirety, you testified, correct?
Yes.
About how long would you say this video is in its runtime from start to finish?
I did not take note of the length of the video.
All right. I'm going to ask you, Mr. Bates, if you could, with court permission, can you just pull the cursor back to the beginning of the time of day for this video? And pause it there. Can you see, and this is not an eye exam, can you see the timestamp on the lower left-hand side?
No, I cannot.
Your Honor, with court permission, I could do this.
I'd like to see it sidebar.
All right, it's in blue. Bottom center. I hope she's chewing Jackson out, ripping him a new asshole. And by ripping him a new asshole, I don't mean David Yannetti. It's, yeah, it's move the fuck on. We get it. It's mirrored. You could ask, why is it mirrored? Because that's the way we got it from the Canton police. That's how that camera records. I don't know. KFAR, it's, I really don't know. Like, I can't see how this is ingratiating the defense to the jury. Like, be aggressive if you have to be aggressive. Ask the questions you have to ask. But being a dickhead just for the sake of being a dickhead doesn't do your client any favors. It doesn't look good in front of the jury. Of course, you know, everyone who's talking about, oh, the jury's eating this up, the jury hates this, it's like, who knows what the jury's thinking? The jury is made up of people. Of course, you know, there shouldn't be any free Karen Reed people on the jury because, you know, that's what voir dire is for. But you know, considering they shouldn't have preconceived biases, you know, they shouldn't be, you know, buying into the conspiracy coming into this, they, you know, I don't see how this is playing well to them. To me, they are playing it up for Brandon. I mean, no, the defense to me is they're playing to the camera. They're playing to the free Karen Reed crowd, their audience. They seem to be forgetting that Turtle Boy and company are not their intended audience. The jury is, the judge is. There's a grand total of 13 people that actually matter, that you get your message through to. And being a douchebag probably doesn't help get that message through. It looks great to the free Karen Reed crowd, which maybe that's the crowd that Karen has paid them to play to. But if that's what they're doing, like consciously, they're doing her a big disservice.
You are unmuted.
Jurors, sometimes lawyers have what we call stipulations. Rather than prolonging either testimony or calling an additional witness, lawyers agree as to certain facts. So what the lawyers have agreed to here is that this video begins at 5:30 and 23 seconds, 5:30 p.m. and 23 seconds, and it ends at 5:48 and 15 seconds. And the total runtime of the video is 5 minutes and 51 seconds. All right, your questions, Mr. Jackson?
No, I'm not simping for the Commonwealth. I'm just trying to analyze the evidence. And as I've said, I don't see much evidentiary value in the Sally Port video. It's a problem for the prosecution because it can make the jury think that, hey, they're trying to pull a fast one. But there's no real evidentiary value because we've already seen the taillight was broken hours before. The CERT team is conducting the search through 18 inches of snow simultaneously with the Sally Port video. So without the use of time machines, explain to me how they got the taillight under that 18 inches of snow right under the search team's nose. It doesn't make any sense. It really doesn't make any sense. So, you know, you're clearly not watching the same trial that I'm watching. But, you know, you do you. And Corrosive, good to see you.
Thank you for that, Your Honor. Sergeant Buchanan, given the fact that the beginning time, the time of day, is 5:30 and 23 seconds in the evening, and the end time of this video stops at 5:48 and 15 seconds, would you agree with me, without doing the math down to the seconds, that's about 17 minutes and 50 seconds or so?
In real time, yes.
In real time. The actual time of this video, the run time of this video, however, is only 5 minutes and 51 seconds, less than 6 minutes. You'd agree with that?
That is what's captured.
So that means that about 2/3 of the video is missing, correct?
It's not missing, just
If it's motion activated, it's not missing. It just means no one was there to trigger the motion activation.
not recorded.
It's not there.
It was never there.
I'm not saying it was ever there. I'm saying I don't know if it was ever there or not. Neither do you. I'm saying it's not there, correct?
It was never recorded.
Well, you don't know what has been when and wasn't recorded, do you?
Objection.
I'll let him answer that.
Do you?
I can only speak to what was turned over and what we received, and based on the evidence that was produced, the video that was produced is what we got.
I understand. So based on that answer, you acknowledge you don't know what may or may not have been recorded without your knowledge.
No,
Right. Did you notice that there were obvious portions of the video that in which individuals just seem to appear or apparate out of nowhere?
it's not a smooth recording of the events. When the motion triggers the recording, the video appears as if a person appeared in the video.
Apparation.
But that is due to the triggering of the recording.
Well, you don't know what it's due to because you're not an IT person who actually captured the video, correct?
Objection.
Sustained, ask that
Argumentative.
differently.
Sure. You're not the IT person, the technical person who captured this video, correct?
I am not, no.
You don't maintain this video system, do you?
I do not know.
You don't know the inner workings of how the video system was originally installed or how it operates, correct?
Based on my training and experience, I know that certain systems, due to the restriction of the storage of the system, they try to save the storage and trigger the recording only by motion or certain time parameters. So in this video footage, I could tell you that the video is triggered by motion to record.
How much storage did this system have?
I do not know.
What was the level of storage at the time that this video was taken? Was it 60%? Was it 99%? What was it?
Fuck
I do not
you.
know.
So you actually don't know, Sergeant, the inner workings of this system, do you?
Knowing that it's motion activated as opposed to knowing the size of the hard drive, fuck you.
I do not know all the inner workings of the system.
But you do know that there appears to be portions of this video missing and portions of this video in which people just seem to apparate out of nowhere.
It's not missing. It just was not recording.
Let's move to, I think it's 5:37. A few seconds. Okay, with the court's permission, can you play about less than a minute?
Yes.
Pause it. You see where the person that was
I think it looks good to the people he wants it to look good to. Unfortunately, I don't think it looks good to the jury. And that worries me that a defense attorney is playing it up to the wrong crowd. Like, even if I don't want him to win, it worries me because it makes my profession look bad. It's just not good. And yeah, yeah, that's exactly it, Grey Duck. Know your audience. Know who you're presenting to. It's, in Communication 101, you're presenting to your professor. If your best friend is on the front row and yucking it up, ignore him. He doesn't matter. He can only hurt you. You present to the professor. In court, you present to the jury and the judge. You don't present to the TV cameras. It's just, I don't get it.
Toward the back, the vehicle went in this video,
It appeared they went behind the vehicle.
which would be which area of the vehicle, the right or the left? In real life, not on this
Could
video.
be.
In real life, it would be the right.
But as I've said from the start, if they have to try this again, I really do think it's going to be in Boston. I don't see how they can retry it again in this county. It has to be Boston. I don't see any other way.
Rear portion of the vehicle.
Toward the taillight area.
That quarter panel, correct?
Let's go ahead and play it. Pause it. Did it appear that someone just seemed to appear out of nowhere toward the rear of the vehicle? Just now?
Due to the triggering of the motion,
I asked you why. I asked you if. Did it appear that someone just appeared out of nowhere in the back of the vehicle?
Okay, once again, fuck you, let him answer. Come on, Lolly, object.
that's what the footage represents. Yes.
Can you go ahead and play this?
I don't know any, but I'm not in Boston, so.
Did you see that the person walking away from the vehicle that you earlier on Wednesday identified as Trooper Proctor appeared to have a notebook, black portfolio in his hand?
Yes, I did.
And can you see from there, I'm going to ask you this, basically knowing the answer, can you see from there the time of day on the lower left side as that person leaves the screen?
No, I cannot.
Would you disagree if I indicated to you that was 5:38 and 7 seconds in the evening?
I would have to see it for myself. I cannot agree with you based on your statement.
I like that. Fuck you. I don't believe a word you say because you're lying scum. It may very well say that, but if I can't verify that, I will not agree with a single word you say.
You want to make me approach briefly?
Sure.
Gonna go up and try to get a stipulation. Ask Lolly, will you agree? Let the judge instruct the jury that that's what the timestamp is.
You are unmuted.
All right. So, Sergeant, we're going to ask you to go take a look at that, okay?
Thank you, Your Honor.
Let him get up from the stand and look
Please
closer.
don't speak until you're back in the witness stand. Thank you. All right, Mr. Jackson?
Thank you. Sergeant, did you have an opportunity to look at the time of day?
See, and I actually disagree. Like, if this were just a DUI hit and run, maybe they wouldn't. But the aggravation that the defense has caused, the damage the defense has caused, the harassment done by the defense, they absolutely would retry. Like, another thing I was thinking about over the weekend was basically, I've heard it said, I haven't seen it myself, so I can't verify that it's the truth, but I've heard that right out the gate, Karen was offered a plea deal of 3 years. which for a, DUI manslaughter is a pretty good deal. As I've said, I think DUI manslaughter shouldn't exist as a charge. It should be second-degree murder, because to me, if you kill someone driving under the influence, that's depraved heart. That fits second-degree murder. But judges don't like to admit it, prosecutors don't like to admit it, but there is the trial penalty. If you take it to trial, and you're found guilty, you're gonna get a worse sentence. Now, had she just played it straight and tried it as a DUI manslaughter case and done the some Puerto Rican guy defense, not engaged in all the conspiracy and mudslinging and harassment and witness intimidation and all that bullshit, even with the trial penalty, I could have seen 5, maybe 10 years. It's a lot of time, but she killed someone. Presuming, because in that hypothetical, she's found guilty. Like, I could see Lolly asking in that situation for 5 to 10 years. If she's found guilty a couple weeks from now, Lolly's asking for the max. He's absolutely asking for the max. And when he asks for the max, he's going to get up there and he's going to say to the judge, Karen Reed is completely unrepentant. She has shown no remorse from day one. As soon as the jury leaves the room every day, she's yucking it up and smiling and rolling her eyes, and she doesn't care that she killed someone. She has engaged in a pattern of harassment. She has impugned the integrity of this court, of the prosecutor's office. She has tried every dirty trick in the book, and frankly, added a few chapters to that book, trying to monkey wrench this entire process. And for all those reasons, she deserves to have that book, including her extra chapters, thrown at her. And I could see the judge going for the max or close to it, because this isn't, to me, just a DUI manslaughter case. Whether or not that's what she's convicted of, she still could be convicted of the second-degree murder. But it's this case represents so much more that to me, there's just no way they don't retry it if it's a hung jury. So, yeah.
That's the point that the video is paused right now.
Yes, I did.
What is that time of day?
5:38:07.
5:38 and 7 seconds, correct?
That's what he
correct.
said.
And remind me about how far of a drive in time is this location at Canton PD from 34 Fairview?
With no traffic, no adverse weather and road conditions, several minutes.
And the CERT team arrived at 34 Fairview at 4:30-ish, an hour before this. So where's the conspiracy?
4 minutes, maybe 5 minutes, depending which route you take.
Your Honor, I have a flash drive that I'd like to have marked.
Is this a different flash drive than we had on Friday?
It is, and I can explain it sidebar if the court wishes.
All right, are you just marking it or do you intend to show it?
I intend to show it.
I think even if she is found guilty, they're still going to go after her for the Turtle Boy type charges. I absolutely think they're getting conspiracy charges. Karen, Turtle Boy, you know, maybe Diaper Boy, whoever. I don't know who all the players are. I could see Jackson and Yannetti also. Papa Reed, the brother that works for Lexus, you know, if he gave Turtle Boy a Lexus as payment for the harassment, hey, that's an overt act in the conspiracy. Brother Reed is in on it. I could see them going after every one of them for the conspiracy.
With the court's permission.
All right, so we'll mark it for identification and then I do need to see you. Yes. Thank you.
And
Yes.
they absolutely are going after him. I mean, he has been charged. I just see him getting more charges because, frankly, he doesn't have conspiracy charges. He just has witness intimidation and those types of charges. But you can be charged for the exact same conduct with both witness intimidation and conspiracy to commit witness intimidation. That's not double jeopardy because those are two separate crimes. And I can absolutely see Turtle Boy getting those, and Karen and others. And frankly, if they have the communication that proves it, it's pretty easy to prove. I mean, Turtle Boy's admitted to it. He just says, yeah, I did it, but it's not a crime because I'm a journalist. So there's admissions. But it's also all on video. So, yeah. I mean, if they have the anonymous minions, that would be great. All right. Bye-bye, jury. Got to play the video in open court without the jury in order to, you know, admit it into evidence in order to publish it, because who knows what's on Jackson's thumb drive. Get something good. And I mean, I'm close. Like I said, I'm really close to at least on the DUI manslaughter. I'm real close. I want to see the accident reconstructionist. I want to see the medical examiner. But, you know, I'm pretty convinced it's her taillight. So I'm pretty convinced she hit him. I'm pretty convinced she was drunk. At least, is it 7 or 9 drinks? I can't remember. Either way, it's a lot. And that's at least, because I should say units at least, because we haven't seen the receipts. The receipts are evidence, that they're exhibits. The jury gets to see the receipts. We don't. But we know that they're exhibits. We know they were admitted. But the vodka tonics could have been doubles. And then, you know, pouring the shots into them, making them triples. They couldn't be doubles here in Utah because, you know, Utah. But yeah, I just, to me, there's probably enough for the DUI manslaughter. And like second degree murder, I'm thinking yes, but there's still a little more evidence I want for that. I want to know about the Lexus reverse system, the safety systems. And I think that's what it would take to convince me beyond a reasonable doubt on the second degree murder. Even if I think it is. So, and Sinclair Reed, good to see you. Missed you a few days last week, but you know, life happens. And yeah, that would be humorous. The YouTube strike to my channel would be less humorous, but it would be funny. So, BB, good to see you. And when I say Lexus information, Lexus safety systems, I want to know what it would take to back into someone. I want to know, how do you deactivate the automatic stop, and can the weather interfere with that? That's what I want to see. So well, the I hit him, that doesn't go to mental state, the mens rea to commit the crime. That goes to the actus reus, the action, what she did. So I hit him goes to she hit him, not why she hit him. And so if you get what I'm saying. So, because I hit him could also go to the DUI manslaughter. But I would hope she's not drinking, of course. Going to bars with her attorneys, I imagine she is. Of course, a case like this, you'd expect a bond condition to be no drugs or alcohol, especially since it is a DUI manslaughter case. But yeah, we'll see. I thought they were going to quickly come back and voir dire the video, but apparently not. So we'll skip forward. Hopefully on Jackson. And my understanding, Vince, once again, I don't know, this is just what I've seen. You can't permanently turn off the backup sensors and automatic stop. It resets every time you start the car. So that could be a problem for her. But once again, I want to hear that as testimony.
We're back session, seated.
Does council need to see me or are we all set?
I think we're all set.
Right ahead, Mr. Jackson.
Thank you, Your Honor. As a matter of housekeeping, I would ask for the admission of the last item that was marked by identification.
XX.
Ooh.
Was it YY? Ah, it was back again.
I did the
Okay.
same thing.
Well, damn it. I was about to say XX. Sinclair was right. It is naughty photos, but it's YY. So
All right. So that will now be what, Madam Court Reporter? Thank you.
well, and it's not the backup camera. Did she shut off the automatic stop? And the only reason I could see doing it here would be to hit someone. Like in normal practice, the reasons you do it would be, let's say you're backing into your garage and you don't have any clearance. You have to back up and kiss the wall. It's going to stop you before you back up as far as you need to. So you deactivate it and, take your, paint's life in your own hands, basically.
And with the court's permission, I'd ask to display that video. Yours?
Okay.
If you could move that to a runtime of 1 minute and 17 seconds. So thereabouts. And go ahead and pause that. Sergeant, do you recognize what's depicted in what's just been marked as Exhibit 542?
I do.
How do you recognize that?
So this is the reversed image. This is the mirrored security camera. I mean, that it's how the security camera should have worked. Once again, we don't know why it was mirrored. Could just be they fucked up setting it up. But this is not a true and accurate depiction of what was recorded. It's just an accurate depiction of real life.
It's an inversion.
Okay. Trying to think. Yeah, it is just in the mirror. I was trying to think. We were seeing the front, not the rear. So
Of the video provided from Canton PD Sally Point.
It's actually, and that inversion corrects the perspective. Would you agree with that?
I would.
Okay, so now we're looking at what we've always been looking at, but it's clear from the driver's side of the vehicle, correct?
That's correct.
And everything is properly oriented, is that right?
It's an accurate depiction of what is taking place.
Meaning right is right and left is left in this video.
The vehicle came from the right into the left. The driver's side is visible and is closest to the camera.
If you go ahead, thank you, sorry. If you go ahead and finish, just a few seconds, please.
that's probably it, Kevin.
You saw the person that was toward the back of the vehicle that you earlier on Wednesday
Except it's not in vertical, but
identified as moving toward the right. I'm sorry. Yes, the passenger side taillight area in this video, correct?
I observed the person walking that way.
Let's go ahead.
and I have a feeling we're going to have to go through all this bullshit all over again with Trooper Proctor.
Awesome. And you see the person toward the taillight area moving out of frame just now, correct?
I did, yes.
And that person had the that black portfolio in his hand.
That's correct.
I'd like to ask Mr. Bates if you wouldn't mind moving the cursor back to the beginning before the video, I'm sorry, before the SUV was actually in the Sally Port.
Why? How many times do we have to watch the same thing?
Do you see what's depicted in the video now at runtime, at the beginning of the video?
I see the still frame. I'm observing the still frame.
Okay, fair enough, fair enough. Can you see from where you are, sir, can you see the chyron at the bottom of the video in blue, indicating the date stamp and time stamp? You see that from where you are?
I see the blue color. I don't know what exactly it is.
Are your eyes good enough to see that that is completely inverted?
They are not.
They're not inverted?
They are not good enough.
That was a good answer to the bad question on my part. With the court's permission, would it be possible for the sergeant to approach the screen and take a look at that timestamp?
Can you do that, Sergeant?
Yes, Your Honor.
And yeah, the rumor is it's a fixed fee, 250 grand, which, the reality is, as much money as that is, for attorneys as experienced as Jackson and Giannetti, it's not outrageous. As I said, I figure 3 attorneys, 8 weeks, easily $1 million. Or you could say, though, Sinclair, he's charging by the snide comment. She's getting her money's worth there.
Were you able to, may I inquire? Yes. Were you able to see that timestamp?
Yes, I was.
Sergeant, did that timestamp appear to be inverted?
See, I'm thinking he didn't notice. Except if he did, then they'd be nitpicking that it wasn't as it was recorded. And so what Lolly needed to do was play it as it was recorded and bring it out on direct. Like, you bite the bullet, you get it out of the way, and yeah. So, and Alpha, good to see you. But as I've said, this video doesn't actually have evidentiary value to me. Because once again, this is after the CERT team is already at 34 Fairview. So, even if the conspiracy is, oh, you mirrored it so that you could break the taillight without us noticing, you can't put the taillight under 18 inches of snow an hour before this. And it just doesn't make any sense. It doesn't make any sense.
The blue writing appears to be backwards.
So in this version of the video, which has been inverted from the version shown by the Commonwealth, the timestamp also was inverted, correct?
What appears on the screen is inverted.
Thank you. I'd like to zoom in on, just with the court's permission, a portion of the middle of the video.
Okay.
Sergeant, I want to direct your attention to an area of the video right above the hand truck. Do you see that area?
I do.
You see that white object just above the snow line?
I see something there.
Oh no, it's the rag that we see in the still photos from when they had the red Solo cups there.
I do not know what it is, if it's an object or it's more snow.
Can you tell if that's a sort of dirty white rag?
I cannot tell what it is.
Thank you, Mr. Fish. We can take that down. We've seen a corrected version of that Sallyport video from that camera. There's also another camera on the opposite side of the Sallyport, isn't there?
There is.
And that one, for lack of a better phrase, that one came out pretty grainy. Would you agree?
It was dark.
Yes, it's not perfect quality.
The other view would show, given the fact that it's on the opposite side of the wall of this video, that actually would show the right rear portion of the SUV as it was parked in that sally port, would it not?
Yes, it would.
Let's take a look with the court's permission. This has already been marked as 446. I believe it was introduced last week.
Okay.
Display that.
Yes.
Thanks. I know it's very hard to see, Sergeant, but
And as I said, when I saw this video last week, it made my brain hurt a little bit because it didn't match up with the first. Because I was trying to do 4 things at once, didn't figure out why it hurt my brain. But it's because this one was in the right orientation, just very hard to tell because it's dark and grainy.
could you tell me, as the video is paused right here at the beginning of the timestamp, can you see the outline of the antique police car?
I can make that out, yes.
And it appears that there's no vehicle in the foreground this side of that antique police car, correct?
That's correct.
You also can see that this video is in fact not inverted. It's the correct orientation, right?
That's correct.
And obviously it's
She did, Sinclair, but that was before the kerfuffle over the defense expert witnesses.
pretty lacking in quality, but you can make out the fact that there's an outline of a vehicle there, correct?
Correct.
We can play, can I approach the screen briefly?
Yes.
If we could, with the court's permission, begin playing at this time, this is about 5:07 and 10 seconds. That's time of day. We can play for about a little less than a minute.
Okay.
God, that's terrible.
Sergeant, did you see what was depicted on the video that just ran from 5:07 and a few seconds until it was just paused?
I did watch the video.
And how much time would you estimate elapsed as we just watched that video in real time?
15 seconds, maybe?
Okay. And do you see something?
Very well
You see
could
something in
be.
the foreground that just sort of appeared there next to that antique police car.
It appears that the SUV has now pulled into the Sally Port and there's an individual standing behind the SUV.
Do you see what the time of day is on that timer?
I do not.
Can you see that it's paused at 5:50 and 46 seconds?
I cannot.
This is the last time I would ask that unfortunately, I cannot zoom on this, Your Honor, with the court's permission. The sergeant make one more trip to the screen to give us the exact time that this is paused.
Nah, Laserdisc would be much higher quality.
Last time, Sergeant, would you please?
Thank you, Your Honor.
Yeah, this definitely isn't the La Crosse, Wisconsin Sally Port.
What was the time? What is the timestamp where the video was paused?
5:50:46.
5:50 and 46 p.m. Correct?
That's correct.
So it appears that this video in about 15 seconds jumps 42 minutes to the 5:50 mark. Correct?
You didn't show him the timestamp at the beginning. You're being a dishonest weasel again, Jackson. You didn't have him look at the timestamp at the beginning. Just, oh, it looks like it jumped forward 45 minutes. What was the timestamp at the beginning? You did, Vince. Yeah. Because here's the thing. Remember on Buchanan's direct, with CF McCarthy's, they had to adjust the timestamp time to real time. because people screw up setting up the timer. There's time creep on clocks. There's all kinds of reasons. You know, this, as has been pointed out, looks like it's VHS. It's old. What if they set the time 20 years ago? It could very easily have 40 minutes of time creep. So they'd have to adjust it to real time. But instead of adjusting it to real time, instead of looking at the timestamp at the beginning, it's just look at the end timestamp and say, oh, look, there's 45 minutes missing. Only if you're a dishonest weasel. Once again, the police should have a better timestamp. They should stay up to date. You know, Waterfall was able to keep their security cameras on real time. CF McCarthy's was what 13 minutes off? But the Waterfall was accurate. Do we know maybe this one's real time and the mirrored image was fast? We should hear about the real time.
I don't know how much it jumps.
Well, from 5:08 approximately to 5:50 approximately.
We don't know that. We do not know that. You didn't have him check 5:08.
How much time is that?
Approximately 48.
42 minutes, right?
Excuse me, 42.
That's okay. And Ms. Reed's vehicle, which shows the right rear taillight portion, just appears, correct, at 5:50.
There's a vehicle that appears. There appears to be an individual standing behind the vehicle. It's not just a taillight that appears.
But Sergeant, the exact time that would show what Trooper Proctor was doing at the right rear taillight, that is missing.
Objection.
The
Argumentative.
exact time that would show what the person who you identified on Wednesday as being Trooper Proctor, that video is not there. correct?
Argumentative.
Sustained.
This video, Sergeant, you will agree, if that 42-minute period existed, that would have been the only video that would establish the actual condition of the taillight the moment the SUV arrived in police custody in that Sally Point, correct?
Objection.
You can ask that differently.
Is there any other video other than this one that would show the exact condition of that taillight as it pulled in to the driveway, to the Sally Point?
How would he know?
From that location?
Correct.
That is the video that captures that time frame.
And that's also the video that captures that area of the car, correct? Right rear portion of the car.
Correct.
At that 42 minutes, from when the car arrived until 5:50 in the evening, that portion is missing, correct?
It's not missing. It's just not recorded.
It's not there, Sergeant Pubic. I'm not splitting words.
Fuck you.
Splitting hairs. It's not there.
Fuck you.
It's gone.
Argumentative.
It's not on the screen now.
It's not anywhere, is it?
Argumentative.
That's all I have, Your Honor.
Thank you, Your Honor.
For the love of God, ask him about the real time on that video. Show the beginning timestamp. Show the beginning timestamp. Jackson didn't, because he's a dishonest weasel. And the jury instructions are vital.
Good morning, sir.
So how this video was played before the jury on Wednesday during your direct testimony, the condition of that video, the view of that video, that's how you received it from the Canton Police Department, correct?
That's correct.
But nothing was done to alter it, change it in any way, shape, or form from when you received it to when it was played before the jury.
Objection.
Sustained. You can't leave, Mr. Miller.
What if anything was done to alter or change that video, received it to the time that it was played before the jury?
Objection.
Ask it differently one more time.
As far as the condition when you received it, the condition when it was played for the jury, what was different?
There was no manipulation, alteration of the video between
I'll allow the answer.
when we received it from Ken Police Department, when I played it, and when it was played for you.
Now, as far as the cameras are motion activated, correct?
That's correct.
As far as the skipping that you observed at various points of the video, was that something that occurred once or more than once?
More than once, repeatedly.
And was it one specific portion of the video? And by that, I mean, was it only at the beginning or only in the middle or only at the end, or was it sort of throughout?
It's consistently happening when there's lack of motion. The video does not record because it's not triggered to record.
From the video, at least as far as you've seen, the one that you were shown on Wednesday and the one that you were shown today, or the portions that you were shown today, what, if any, difference did you note between the content of what's contained in the video?
The content of the video is accurate depiction of what's taken place. The only difference that I noticed today is that the version played was actually inverted from the original version that I received and which was produced.
Your Honor, with the court's permission, I would ask that the entirety of that 5 minutes and 51 seconds of video be played for the jury.
Okay,
May I have one moment, Your Honor?
yes.
Basically, the rule of completeness, it's if part of an exhibit is worth showing, the jury can see the whole thing. And frankly, they probably should. Especially at this point, this particular exhibit, they should see the whole thing. Take the mystery out of it. So watch how many times you see no one in the video. The absence of humans. It's doubtful. It's doubtful. Ineffective assistance of counsel is a very high bar.
And that area does play before the jury. That is when the vehicle was brought in by the tow truck driver from the flatbed from the driveway video into the Sally Port area, correct?
That's correct.
And that is true. It's available to the jury, but let them see it now. Take the mystery out of it now. Don't have them thinking about it now.
Sorry, I'm going to direct your attention to the person that just opened the driver's side door. That's the tow truck driver, is that correct?
That's correct.
Just ask you to take a look at the door, and in particular, the snow on the door when he closes that. It's going to be good.
It fell.
Sergeant, if I could direct your attention back to the ring video. I think it was video 153 from Exhibit 6. And you were shown that video on cross-examination and asked about any movement that you saw on the driver's side rear tire, things of that nature. Do you recall that?
I do.
And do you recall that portion of the video when it's alleged that Ms. Reed's vehicle came close to or made contact with Mr. O'Keefe's vehicle in the driveway? At that point, did you observe any snow coming off of Mr. O'Keefe's car when they came close to each other?
Objection.
I'll allow it.
I don't remember exactly if there was snow coming off the vehicle. There was snow falling, and that was captured by the ring video. I don't recall if any snow came off the vehicle.
So maybe quick.
Yep. It doesn't have evidentiary value other than chain of custody. That's really the only relevant information. is the chain of custody. Because we know the taillight's broken. But, you know, so what? They're congregating behind it. They're looking at the damn evidence. That's the interesting portion of the SUV. Of course, it's what they're going to be looking at. And that's a good point, Vince. It's where the door into the building is. So when people magically appear, it's almost like they walked out the door from the building into the sally port, and the camera picked them up. That's where the camera picked them up. So it's just silly. And unfortunately, well, I mean, fortunately, but unfortunately for us, Canton is not a large town. It's not a high crime, especially not a high violent crime town. So, you know, I think just the spending on surveillance in the Sally Port isn't the priority that it is in, let's say, La Crosse, Wisconsin, or, you know, downtown Boston, Main Precinct, or, you know, wherever, Gary, Indiana. And some of this, like, it looked like they were all congregated right here at the left tail light. There were 3 of them, and they were standing still. And then all of a sudden, you see them jump almost to where the garage door track is. It's because they were standing still, so the camera wasn't registering really. And then once they started moving, the camera's like, oh, fuck, there they are. And so that's what it looked like. And 1-800-Fraudbusters, good to see you. Thanks for joining us from Sweden.
Thank you. And Mr. Ross, we can have the lights back up.
And I'm putting that as 1963. Of course, I'm not great with American sedans. Sports cars, I'd get. Sedans, no.
Now, Sergeant, that video starts at approximately 5:30 p.m. on January 29th, correct?
Correct.
Is that before or after the ring video 153 from Exhibit 6 at 5:07 in the morning at Mr. O'Keefe's house when you can see the defendant's smashed jail?
Objection.
So the objection is sustained. Ask the question.
5:30 p.m. on January 29th. Is that before or after 5:07 a.m. When you observed the defendant's vehicle on the ring video at Mr. O'Keefe's house?
That is after.
And is that before or after you observed on the ring video the defendant, Ms. Roberts, and Ms. McCabe driving the defendant's vehicle and parking it in the driveway of Mr. O'Keefe's house?
It's after.
And is it before or after about, say, 8:22 in the morning?
All right, Ann, he's doing this just for you. and for the jury, too. But this is for Ann.
At some point when a Canton Cruiser parks in the driveway behind the defendant's vehicle?
It's after.
And is it before or after about 12:30 p.m. or so when the defendant and her father and her brother from the videos from Exhibit 6, the ring videos on 1 Meadows Ave, are parked in and around the defendant's vehicle and then leave with the defendant's vehicle to go to bed?
It's after.
And is it before or after the video that you testified about on Wednesday in regards to the surveillance video from the defendant's father's house in Dayton when that vehicle was being loaded onto the truck and you can see the tail light there?
John.
It's after.
Now, again, you had a conversation or an interview with the defendant on the afternoon of January 29th when you were indicted, correct?
That's correct.
And during the course of that interview, she made statements about her broken taillight and when that occurred, correct?
Objection.
Do you want the instruction or do you want to come see me at sidebar?
Oh, I mean, and well, number one, this is all sarcasm. Don't be calling Lolly. But if the free Karen Reed cultists can be flooding the defense attorneys with, videos of Colin Albert and photos of firefighter McLaughlin and Caitlin Albert, why can't you tell Prosecutor Lolly how to do his redirect? I mean, what's good for the goose is good for the gander. And of course, just stay away from the goose and the gander because, they're murder birds and they're terrible. They're vicious. I'd get a guard goose before I got a Rottweiler.
You are unmuted.
There's that too. But once again, don't contact the prosecution or defense. I haven't made the disclaimer in the trial that I normally make when covering the lawsuits, but this is an animal safari, not a petting zoo. You keep your arms and legs inside the ride at all times. Do not interact with the subjects. And yeah. And oh, there's a new lawsuit that I really want to cover. If only it weren't for the fact that I was so far behind on others. But the new baby reindeer Netflix lawsuit could be fun. It really could be fun. But we'll see if I manage to do that or not.
Now, Sergeant, between the version of the video that's you and the jury witnessed on Wednesday and the version that you just witnessed the entirety of right now, again, what, if any, difference as far as the depiction or
and actually, he missed one though, Anne. Lolly missed one, and this 507 was after the CERT team was already on scene at 34 Fairview. He forgot that part. But yeah, Alpha. I've got the complaint pulled up on my other computer. It could be fun, and it could, like, spoiler alert, it could hinge on, at the beginning. I haven't watched Baby Reindeer. It's on my list, but it says at the beginning, this is a true story. And that could be a problem for Netflix. Had they said, this is based on a true story, of course, this is a true story, Netflix is going to argue, well, that's literary license. We didn't name her. We changed things up. Just saying something's a true story doesn't mean it is a true story. Do I think she has a $170 million case? No. Do I think she has a case? Maybe. Do I think she'll win? Maybe. I really don't know. I haven't read the entire complaint. I just have it open. If I do read it, you'll see me read it for the first time because that's the way I roll. But I think she'll have a hard time. That's not to say she can't win, but I think she'll have a hard time. And especially, as Emily Baker says, a lawsuit is shade and allegations. So we have her shade and allegations. Netflix hasn't answered yet. And that very well could be it. Hey, I mean, fuck, it's Netflix. They might say, hey, come pitch a show to us and we'll make it. That's the settlement.
Or places between those two versions of the video.
Outside of it being a mirror image of itself, it accurately depicts any activity or action in the Sallyport.
And at any point in time that you were in the Sallyport area of the Canton Police Department garage, did you or Trooper Proctor ever go near, touch, manipulate the rear passenger side taillight area or the rear passenger side quarter panel of the defendant's vehicle?
We absolutely did not.
Don't say that, Vince.
Now, if I could turn you...
And we're even at 1 3/4 speed, so we're zooming a little faster. It's just there's so much.
To some questions you were asked on cross-examination about something that was reported to the chief medical examiner's office. Do you recall that?
I do recall that.
And some questions about statements that you had made to the OCME at approximately 10:41 a.m. on January 29th. Do you recall that?
I do recall that.
And you were asked some questions about reporting it as a possible domestic assault, correct?
That is correct.
And can you explain to the jury what led to that statement as far as what you knew at that time and why you would make those statements to the medical examiner?
The Massachusetts general law directs us, just as it gives the district attorney's power to and authority over all death investigations. That's the following section 4 of that chapter. Excuse me, following section from section 4, section 5 of that chapter directs all state medical and police.
Kevin, I'm so far from dinner that I have no idea.
Entities to work in coordination with the medical examiner's office. By law, we're supposed to work together on the medical legal investigations that the medical examiner's office conducts. We conduct the criminal portion of the investigation, they conduct the medical portion of the investigation. Thus, I contacted the medical examiner's office and advised them that what we had learned at the time. Up to that point, we had learned that the defendant stated that she hit him. We had collected, meaning the Canton Police Department had collected a broken glass.
So, Delete Laws is still in the dungeon. He's got 2 more months, I think. He's all but lost. I mean, I haven't checked in a few days, but the LVMPD case, it's over. It really is. The fat lady has sung, but it's over. It's over. The California case, at the moment, only Blue Bacon's defending it, and I haven't been following it, so I just, yeah. The second criminal case he's gonna lose. He's gonna lose. It's gonna be bad, and he doesn't stop. And yeah, the state just responded to his appeal. I haven't been covering that. I know he's controversial, but Merb has covered it. I haven't watched because, frankly, I don't care. So, yeah, that's basically the update.
So based on the physical evidence and the statements made by the defendant to the first responders at the scene at that point in time, I had communicated those facts to the medical examiner's office. That way they would document it, but also be prepared to investigate the case with the most up-to-date information available.
Now, at that time that you made that statement to the representative from the chief medical examiner's office, had you been to Good Samaritan Hospital and seen Mr. O'Keefe at that point?
I have not.
And had you obviously seen any of the injuries that Mr. O'Keefe had sustained prior to making that statement to the medical examiner?
I had not.
As far as the information that you received, you mentioned first responders indicating that the defendant had stated, I hit him. Who was the first responder that provided that information?
The Canton Police Sergeant Good.
In addition to that, did you or Trooper Proctor speak with any of the Canton fire personnel?
Yes, we did.
And who did he speak with?
I believe it was firefighter Fleming.
So firefighter Flamati, is that correct?
That's correct.
Now, after going to Good Samaritan Hospital and viewing Mr. O'Keefe's injuries, as far as what you would earlier report to the medical examiner, what if anything?
That would be hilarious, Nathan. That would be absolutely hilarious. An intellectual property lawsuit with Timex suing Delete Laws. That would make my day.
And change based on those observations as far as your opinion as to what had transpired.
Based on what I learned from observing the injuries, I could tell that the glass.
Objection.
I'm going to allow it. You can move to strike it, but I'm going to allow it.
Just trying to throw him off.
I could tell that the glass was most likely not the object, the weapon, which was used to cause the injury to the back of Mr. O'Keefe's head.
Thank you, sir. May I have a moment?
Yes.
Is he done?
Thank you, sir. I have no further questions.
Any recross?
Very briefly.
Okay.
In your
Jackson
report to
doesn't do anything briefly.
OCME, you said it was a glass to the face, not to the back of the head, correct?
I'm not sure how they wrote it down, but I would need to be refreshed on my memory.
Okay, fair enough. May I approach?
Yes.
Last sentence. Yeah,
Yes.
I'm sorry. Does that refresh your recollection?
Yes, it does.
What did you say to the, or what did you report to the OCME?
That there was a possibility that the decedent was struck to the face with a glass.
You also, with regard to the phrase, I hit him, or
Once again, though, that's initial reports. That's very preliminary. It's here's our initial working theory based off of almost nothing. Once we investigate further, we'll update you.
the Sergeant Good and or Flamati telling you that she said, Ms. Reed said she hit him. When did Sergeant Good tell you that?
It would have been during our conversations at the police department.
And when did EMT Flamati tell you that?
He never told me that.
So the only thing you were going on with regard to the phrase or the statement that you claim my client indicated, where my client indicated she hit him, is coming from Sergeant Good.
That information at that time was provided by the first responders from the scene.
And Sergeant Good then relayed that to you, correct?
At some point, yes.
Is there a single report memorializing that Sergeant Good reported to you that morning before 10:41 a.m., before 10:41 a.m., that my client made the statement that she hit him?
I don't believe so.
I want to shift gears real quick to the video. A couple of quick questions about that. When did you, and I'm talking about the higher quality video, the one that was inverted.
It's possible, but the defense hasn't. Well, they're not going to bring that up as a possibility because they don't want to admit that she hit him, period. And if he had slipped, if he were down, the taillight's too high. So
When did you receive that video? What date?
I'm not sure. It was at some point in either late April or early May.
After we had started this trial.
Objection.
Do you know?
I do not, Your Honor.
If after mid-April, correct?
I believe so. I'm strictly speculating.
Who asked you to retrieve that video?
I did not retrieve that video.
I'm sorry, that's a presumptuous question. At what point were you asked to secure the video, or were you ever asked to secure the video?
That video was never secured by me. I was not asked to secure it. I just was asked to review it.
it's
Okay,
probably
so who did secure the video
Proctor.
to your knowledge?
I do not know.
you're aware that it was, well, let me ask you a couple, that the Canton Police Department was recused from any investigation concerning this case, correct?
How is this within the scope for the recross? How is this within the scope? And besides which, he said he didn't say that they were recused from any action. They recused themselves from participating in interviews. But who would retrieve security camera video from the Canton Police? The Canton Police. So even if they're recused from any activity, they're still the ones that have to retrieve their own records because they have the records. We're at 1.35 speed.
At one point, we learned that the Canton Police Department, the decision was made way above my level, and I was advised by Detective Lieutenant Telly that Canton Police had recused themselves from the investigation as far as interviews go.
And you knew that that recusal
As far
was
as
because
interviews
of a connection
go.
between the Canton Police Department and the Albert family, correct?
Objection.
Sustained.
Did you know, or were you informed that the recusal was based on the connection between the Canton Police Department and the Albert family?
Objection.
So it's sustained for the same reason I sustain the Commonwealth's objection at sidebar, Mr. Jackson.
Last question. Who provided the video?
I do not know.
Canton Police Department, wasn't it?
You said
US
last
who?
question.
That's an entity.
Okay, what entity provided the video?
It came from the Canton Police Department.
Thank you, that's all I have.
All right, Sergeant, you are all set, sir.
Thank you, Your Honor.
Your next witness, Mr. Lally?
Yes, Your Honor. Commonwealth call Officer Nicholas Barrows to the stand.
Okay.
I mean, who else is taking video of the Canton Police Department Sally Port? The state troopers didn't put security cameras in the Sally Port. They didn't come in 15 minutes before the tow truck and say, we better put our own security cameras up here just to keep watch over this Lexus. They don't have access to the Canton Police servers, to their computers. In order to get a video from the Canton Police, you have to go to the Canton Police. Even if you're standing over the IT guy's shoulder as he's pulling the video, he's not going to give you access to his computer. He's not going to hand over his password and say, have at it. Go to town. That's not how it works. So, different trooper. Don't recognize his name. Was it Barrows, I think?
So, sir, do you ever see the court during the case, never answer the truth, the whole truth, and nothing but the truth?
It's Andrew Tate.
So, all right, whenever you're ready, Mr. Lally.
Thank you, Your Honor. Good morning, sir.
Morning.
Could you please state your name and spell your last name for the jury?
Nicholas Barrows, Barros,
And how are you employed, sir?
with the town of Dayton.
And what, if any, role or what do you do for the town of Dayton?
I'm a police sergeant for the police department.
And how long in total have you been a member of the Dayton Police?
In total, started in 2011, 14 years this December,
And how long have you had the rank of sergeant with the Dayton Police?
a year and a half.
Now, if I could direct your attention to January 29th, 2022. Do you recall that date?
I do.
And were you working that day?
I was.
And do you recall what kind of shift you were working on that occasion?
I was working the 8 to 4, the day shift.
And was that the only shift that you would work on that occasion, or how long had you been on shift by the time you came on for the 8 to 4?
That particular day, I was working from 8 a.m. to midnight. It was on a double.
Now, at some point when you first came in, with reference, if you could explain to the jury just briefly or in general terms, when you come on shift for the Dayton Police, what, if any, communication, well, first and foremost, what was your role as far as that particular shift was concerned?
I was the officer in charge that day from 8 a.m. to midnight. When I came in at 8 a.m., the outgoing shift, the midnight to 8 shift, had advised me that a resident had called the police station on a 911 call requesting.
And that's just it. Alpha, the medical examiner, you know, they're going to conduct their thorough examination, but the investigators, the state troopers, the detectives are going to say, this looks like it could be the mechanism based on the evidence we've found so far. And the medical examiners are going to pay special attention to either falsify that or, you know, say, yeah, that looks plausible. They're still going to conduct their entire investigation. They're still going to do their entire exam. They're still going to do their entire medical report. But it's that's what the defense has. They're taking normal things, normal investigations, normal practices, and isn't that suspicious? Well, no, not really, if you know what's going on. It's frustrating. And I did not hear that, Lens, but frankly, I try to avoid knowing what Andrew Tate is doing, other than the criminal case against him. Oh, he's been a malign influence on a generation of young men, and that's going to be a problem for the next decade. But and that's it. Like, I'm obviously not a medical examiner, but you know, they have best practices, but that they are able to conduct themselves, you know, as long as it's within the parameters. They can say, I want no outside information. I want to just look at the body, and then once I've conducted my initial examination, look at external evidence. Some will, you know, allow external evidence. It's just like, you know, I've been called the world's worst attorney, world's most incompetent attorney, because I didn't read the pretrial motions. But that's my process for when I know I'm going to stream a trial. You know, there's a judge, I believe in Michigan, that Law Talk with Mike did it yesterday. Couple others did it a couple days before. The guy that was banging his head and going crazy, but he's like, yeah, I'll plead guilty, but I didn't do it. And the judge basically said, I haven't taken a no contest plea in all my years on the bench. I'm not going to start now. She doesn't have to take no contest pleas. She can do guilty, not guilty. You know, if you're not going to admit it, let the state prove it at trial. That might be an abuse of discretion, frankly. You know, I had a prosecutor say to me, point blank, we don't do diversions in this office. They do a plea in abeyance, but they specifically said, we don't do diversions. But there's a statute on the books in Utah for diversions. My boss at the time got apoplectic, and he's like, well, in that case, we'll get her recused of abuse of discretion. It's like, that's too much effort. Take the plea in abeyance. It's the same result. But you know, the judge saying, yeah, I don't take no contest pleas. And in Michigan, they don't have the Alford plea, which is similar to a no contest plea, but it just, yeah. Even within, highly regulated practices, there's room for individuality. So
A ride to Brockton Hospital to meet his daughter due to her daughter's boyfriend passing away, and he needed a ride due to the snowstorm.
And then as your shift continues, what, if any, further contact or who, if anyone, reached out to you in regard to that earlier situation?
Later on, I believe it was around 2:30 in the afternoon, I received a phone call from the Norfolk District Attorney's Office with the troopers assigned there, and they had stated that they were going to come to Dayton to retrieve a vehicle that was involved in a homicide.
And did they give you a specific address as far as where they were going?
I believe the address was 345 Country Hill Drive in Dayton, North Dayton.
And with regard to that address, what, if anything, did you recognize between that and the earlier call that you were just speaking?
That was the address that came up on the 911 call when that gentleman had called earlier on the prior shift.
And at some point, did you come to find out who the residents were at that address on Country Hill Lane?
I did.
Okay.
Where did you find them to be?
It was the Reed residence.
All right. So Sergeant, I'm going to ask you to keep your voice up, and Mr. Lally, you too.
And the Reed residence was at a William and Janet Reed, is that correct?
Correct.
Now, as far as you received that call at about 2:30, do you know specifically who you spoke to around 2:30 in the afternoon?
Trooper Michael Proctor.
And as far as that earlier information that you were talking about with the 911 call, what, if anything, from that did you impart to Trooper Proctor?
I advised Trooper Proctor that we did receive a 911 call on the midnight to 8 shift about the resident looking to get a ride to Brockton Hospital.
And during that initial call, how was it sort of left as far as what, if anything, you were going to provide as far as assistance or with regard to the troopers on that first call?
On the first call, the troopers just had asked me if I could meet them at that residence as a courtesy since they were coming into my jurisdiction.
And what, if anything, did they indicate to you as far as where they were or when they felt they would be arriving in that area?
Trooper Proctor.
All right. So remember, the troopers in plain clothes driving their personal pickups, personal pickup, Sergeant Buchanan's truck, called ahead and said, "We would like uniformed local police officers to arrive with us at the Reed residence because it gives legitimacy." So
Advised me that they were heading, I believe, from Canton, and once they were about 10 minutes away, they would recontact me so that I could meet them at the residence.
And subsequently later in that afternoon, did you receive further contact from Trooper Proctor?
I did.
And do you know about what time that was?
I believe the first phone call was around 3 p.m. that he had called me and said that they would be there in about 10 minutes.
And upon receiving that call, what, if anything, did you do?
I had contacted, Trooper Proctor had asked me to contact our tow company to have them meet us at the residence as well. And I said once I hung up with him, I would contact the tow company and then respond to the address on Country Hill Drive.
Is there a specific tow company that the Dayton Police uses with regard to towing of vehicles within the town?
During that period, it was Diamond Towing.
And so did you contact someone at Diamond Towing in reference to responding to that address as well?
I did. I contacted the owner and he responded.
Now, as far as that area of Dayton, if you could explain to the jury sort of what you observed as you were coming down towards that residence on that day.
Okay, so when I responded to that address, that street is off of 138. When I turned onto Country Hill Drive, I was traveling west. When I arrived on that street, I observed a black pickup truck parked on the street facing east. I was flagged down by that black pickup truck by the driver and was told that they were the troopers that I had spoke to, Trooper Michael Proctor and the other sergeant.
Sergeant that left the room as you were coming in?
Correct.
And what identification did they provide to you in reference to them?
They showed me their ID and their badges.
And then from there, where did you proceed?
I had parked my marked police vehicle at the end of the driveway since it was a snowstorm and we could not get into the driveway. And then we walked up to the residence.
So when you say it was a snowstorm and we couldn't get into the driveway, can you expound upon that a little as far as explain to the jury why it was that you couldn't get into the driveway?
There was about a foot of snow in the driveway.
And as far as that snow that you observed when you arrived there, was that snow, how did that snow appear as far as, did it appear as if it had been shoveled or snow blown or untouched or how did it?
It was untouched.
Now, as you're going through the snow, and correct me if I'm wrong, but it's yourself, Trooper Proctor, and sergeant from the state police, or if anyone else is going along with you.
I had an officer that was field training with me that day, and he was with me as well. And we went up to the residence.
And as you're walking up to the residence, what, if anything, did you come upon as you're going towards, any door or getting closer to the home?
I remained at the garage. The two troopers went to the front door and made contact with the homeowner.
Now, as far as you were there specifically for a vehicle, correct?
Correct.
Did you observe a vehicle in the driveway at any time?
Yes, we observed a black Lexus SUV in the driveway.
And what, if any, observations did you make to the rear area of that vehicle specifically?
At first, I did not go up to the vehicle. I just remained at the driveway and waited for the troopers to come back. And once I came back, they were
Yep, it's snow and not the fun kind, unless you're a skier.
let into the house through the garage. I had walked in with them briefly and then went back out to the garage and remained with the vehicle.
And as far as at any point in time, did you have any conversation with anyone named Karen Reed that day while you were at the house?
I did not.
Now, with respect to you come back out to the garage, is that correct?
Correct.
And the troopers are inside the house, is that also correct?
Correct.
Now, at some point, do other vehicles come down to the driveway area of this residence that you were at?
I had contacted the highway superintendent after speaking with the troopers about how to retrieve the vehicle since the driveway was untouched and had about a foot of snow. I had made the decision that I would call the highway superintendent and see if that he would come and plow the driveway so that the tow truck would have access inside in the driveway.
It could just be, and we've gone from 1 1/4 to 1 1/3 speed. So a little faster. He seems perked up.
And just in reference to this driveway, just if you could, not exact footage or anything, but how close is this Lexus SUV parked in relation to the roadway? How long is that driveway?
It's got to be about 150 feet off the roadway, if not more.
Ooh, long
If
driveway.
you recall, from where you're standing at the point of the garage, was what part of the vehicle was facing you? Was it the front of the vehicle, the back of the vehicle, the side of the vehicle?
I was looking at the left side of the vehicle.
And at some point, did you make any observations of the right rear part of that Lexus SUV?
I did.
And what, if anything, did you observe about that area of the vehicle?
I saw that there was some damage to the right rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked and a piece was missing, but not completely damaged.
Hey, missing pieces of the lens. Another witness. He's Dighton police, not Canton, not Boston, not a state trooper. Dighton police. What's his motive to lie? Why would he be in the conspiracy? Why would he be involved in the cover-up? It doesn't make sense that he would lie that the taillight's already broken, that there are already missing pieces. It doesn't make sense. And Esty, good to see you. Thanks for stopping by.
And then beyond the taillight area of that vehicle, what, if anything else, did you observe as far as damage to the rear passenger side area?
Like a dent on the rear quarter.
And as far as the dent on the rear quarter of the panel that you saw, was that above the taillight, below the taillight, or something?
It's probably right in conjunction with the taillight in that same area.
And from the time that you made these observations of the vehicle, at any point did you go sort of physically up to the vehicle?
I walked up to the vehicle, correct.
And about how far away from the vehicle did you get?
5 to 10 feet away.
And as far as the sort of outside or exterior of the vehicle, you mentioned obviously there's about a foot of snow on the ground. What, if anything, precipitation-wise or weather-wise, was around or on the outside of the vehicle?
Just snow.
And in particular, in this area of the right rear passenger side of that taillight, was there any snow or ice or anything around that area that you observed?
On the vehicle itself?
Yes.
Yes, on the vehicle, there was snow on the vehicle.
And not to put words in your mouth, but sort of caked on there, is that correct?
I guess you could say caked on, correct?
So you'd reached out to the highway superintendent to have someone come out and plow the drive, correct?
Correct.
And do you know about how long it was between the time that you made that call and the time that the plow driver came out to clear?
Less than 10 minutes.
And the sort of clearing of the driveway and the process of that, do you know about how long that took?
I'd say another 10 minutes or so.
And as far as the time that the troopers went into the house, at some point the troopers obviously came out of the house, correct?
Correct.
Do you know about how long it was that they were inside of the house?
More than 30 minutes, less than an hour.
Now, at any point in time that while you were there, did you yourself or did you see anyone else touching or making any contact or manipulating or anything in that rear passenger side area of either the taillight or the dent?
I did not.
I can't either. It doesn't make sense. You know, that this is the first time I've seen you in here, SD. But if you've seen, you know, the replays of my past live streams, I've said from the beginning, you know, based on what I see, if I were defending this, I'd be using what I call the some Puerto Rican guy defense. Because, you know, everything goes back to South Park. And I'd be saying, well, yeah, obviously he was hit by a truck. He was hit by something, but it wasn't Karen. It was some Puerto Rican guy. It was a hit and run. We wish you would investigate and find who did it. But this whole grand conspiracy, it just doesn't make any sense. And if you're like, the defense doesn't have a burden of proof, the prosecution does. But to me, if you're going to come out, you know, both guns blazing, you know, your first statement in your opening is Karen Reed was framed, you're going to have to show me she was framed. Otherwise, you've lost credibility. And it just doesn't make sense. So I go some Puerto Rican guy. But that's not the way they went.
I'm sorry.
I did not.
Can I have a moment, John?
Yes.
Thanks, sir. I have no further questions, Your Honor.
Okay, cross-examination? All right, Sergeant Barrows, you are all set, so
Thank
thank you.
Good to see Miss Little earning her fat paycheck once again. Of course, what's there to cross-examine? Just like with Carrie Roberts, what's there to cross-examine? Yeah, I facilitated the tow. I showed up so that a uniform from the jurisdiction was on scene. I mean, the only real probative evidence was, yeah, the taillight was already broken. And you don't want to call more attention to that. So what shape was it broken? You know, how many pieces do you think it was in? That's not going to help you. So, frankly, I wouldn't have asked questions either. It's move on.
Do you want to call another witness or
And,
morning?
So the thing is that they really spent the first 3, almost 4 weeks, to me, disproving the conspiracy. So I kept comparing it to Shakespeare, to Hamlet. You know, in Hamlet, they have the play within a play. So I was calling it the trial within a trial, and they did the secondary trial first. But then I realized it's South Park once again. And it was the prosecution doing the Chewbacca defense. It doesn't make sense. The conspiracy doesn't make sense. And did they spend too long on it? Maybe. It's really been the last maybe 4 days of testimony that have really been about her guilt as opposed to disproving the conspiracy. or building the timeline. And what we have, once again, you say you haven't seen the whole trial, so we have video at 5:07 a.m. showing Karen Reed leaving the house, leaving the O'Keefe residence. We have the Ring video. The taillight's broken there. We have at roughly 8 a.m. dash cam video of the Canton Police Lieutenant, I believe, pulling in to do a welfare check, see if the niece and nephew are at home, take them, he pulls into the O'Keefe driveway right behind Karen Reed, clearly shows the taillight's broken. We have video evidence of Karen drinking at least, I can't remember if it's 7 or 9 drinks, at least, because that's assuming they're not doubles, over about an hour and a half period, and then driving to 34 Fairview. We have her taillight under 18 inches of snow, found, frankly, before the Sallyport video. We have the broken cocktail glass found under John. We have I hit him. So to me, there's a lot there that goes at least to the DUI manslaughter. I'm not there yet on the second degree murder, although my gut instinct at this point is that it was intentional, but it's not proven to me yet, because the comment of Karen was a babysitter with benefits. The real love of John's life was the mom. Can't remember the kid's name. Maya, I think, or Bella. I keep using those interchangeably. Can't remember. Doesn't matter. And the ex-girlfriend, the mom, love of his life, being used as a landmark to find 34 Fairview. So it's that might have started the fight that had been burning since Aruba. And then Brian Higgins' testimony doesn't help, that Karen was moving on, but still insanely jealous. So there's so much. And the thing is about the early witnesses, you've got to remember that the human memory sucks. Eyewitness testimony sucks. And the big problem with it is, if you don't know that you're going to be testifying about something 2 years in the future, 2.5 years in the future, you're not paying attention. So, when people are off by 15 minutes, that's human memory. And to me, that says it's not a conspiracy, because if it's a conspiracy, if they all got together and formed an alibi, they'd all be giving the exact same story. To me, that's what would be suspicious. So, and then it's just, who would you be willing to go to jail for a conspiracy? I mean, that's a good faith question from me. Who would you be willing to go to jail for? You know, if I'm Jen McCabe, I'm not risking jail for a brother-in-law, for a brother-in-law's nephew, for a brother-in-law's dog. You know, maybe for my kid, maybe for my parents, but I'm not risking prison. I'm not committing crimes to cover up someone else's crime. So it just, so much of the defense is, you know, ooh, isn't that suspicious? Isn't actually suspicious. You know, the Bryans not handing over their phone, there was no warrant. They, you know, they were under no obligation to hand over their phone. They, you know, look at the trauma caused to the McCabes because Jen McCabe was naive and handed over her phone, which is why I say, you know, shut the fuck up and get an attorney. If the police ask for your phone, say, fuck you, come back with a warrant. It's, you never know. So, you know, I'm not saying don't cooperate, but get a lawyer first. Submit a statement through your lawyer. And, you know, so you never searched 34 Fairview? There was no probable cause. There was no trail leading to 34 Fairview. There was no actual evidence that John ever went in. There's no path in the snow, no drag marks. It just, there was nothing. It's just the defense has, oh, you followed standard investigation methods? How very suspicious. So I just, to me, it's not there. And all of the evidence that we've seen points to Karen. And as I've also said from the start, the only evidence that matters is what's presented in court. So anything you've heard on media, you know, anything you heard before the trial, and I'm not saying you did, I'm not saying you believed any of it, but anything you've heard from Turtle Boy, from Karen on, you know, whatever, from anyone, doesn't matter. Only what the jury hears in the trial matters, assuming no jury tampering has gone on and, you know, no free Karen Reed people managed to get onto the jury. But, and that's a good point from Naven. If anyone wanted to frame Karen Reed, they'd all say, oh yeah, we looked out the window and we saw Karen hit John. Of course, then that brings the question, well, then why didn't you run out and try to rescue him? But to me, it's, you know, it's the lawn of a Boston police officer. Brian Higgins is an ATF agent. You've got law enforcement there. It's the world's worst cover-up to dump the body on your own front lawn. I mean, that's stupid. It's stupid. If I'm Brian Albert and I'm covering it up, I'm not dumping a body on my own front lawn and saying, yeah, that's good enough. That, you know, that's enough separation. They'll never suspect us. I'm dumping the body down a mine. I'm putting it in a river. I'm putting it in the ocean. I'm putting it in the forest. I'm putting it in the mountains. not on my front lawn. So it's just so much other stuff. And the thing is, unfortunately, you know, skepticism sells, conspiracy sells. I'd have 100 times the viewers if I were trying to sell the conspiracy, but I'm just trying to call it as I see it, as I see the evidence. And unfortunately, I think a lot of the law tubers are wrong. Of course, we'll see what the jury thinks, because once again, they're the ones whose opinion matters. So it just, yeah.
Recess.
Morning recess, but, Your Honor, if I could just, either before or after, I just need to address one thing with the court sidebar.
All right, so we'll send the jurors out. Jurors, why don't we take the morning?
All right. And we paused it right at the right place, of course. She's not smiling today, as they, well, maybe. Oh, there she goes. The jury must be out of the room. It took her a minute until the jury was fully out. Then she smiled. So disingenuous. All right, let's go right there. And like, I would have liked to hear from the state troopers first. Don't get me wrong. Part of the problem with that, though, is you've got to lay a foundation. So much of what the troopers have testified about, they needed the foundation from previous witnesses. And as I've said, you know, the whole Chewbacca defense, the sub-trial within the trial, disproving the conspiracy, to me, it might not be the order I would have gone in. Of course, I'm not a prosecutor, I'm a defense attorney, but in a way, I think it was smart of Lolly to go in this order, because he laid a solid foundation to build his case on. If he just went straight into the evidence of her guilt and then let the defense bring the conspiracy out, that might have damaged the case more than going in the direction that he went in. But, you know, all we can do is second guess Lolly. I don't know the evidence he has. I have specifically not read the pretrial rulings, and it could be that the pretrial rulings more or less dictated that Lolly had to go in this order in order to get the evidence in he needed to, in order to have the foundation laid to get the testimony he needed. And so it just, there's, you know, we can armchair quarterback all we want, but Lolly's the one that has the evidence and, you know, has built his case from it. And ooh, yeah, it could be using them as rebuttal witnesses would have been devastating. But, you know, and I don't actually know the Massachusetts rules for rebuttal witnesses, so I, can't comment on that.
Tori.
Going back to session, you may be seated.
And I know you're not doing this, but, people come in here and, oh, you're just simping for the prosecution. You're the world's worst attorney. You're dumb. And all I've tried to do is, my intention has been to treat this as if I'm a juror who happens to be a lawyer and just call it as I see it the best I can. And, I've done my best to, through my annoyance, call out where the defense has a good point. Because they have had a few. But I've tried to just be honest and, like I've said, my integrity is more important than having thousands of concurrent viewers. But
All right.
Ooh, and there is that, Adam. Prosecutions tend to bring cases they know they're going to win. Bad cases get dismissed. I just, as I've also said, I'm horrified at the thought of innocent people going to jail or even standing trial. And so I hope I hope she did it. Just because if she is factually innocent, I'm horrified at the thought she'd stand trial for something she factually didn't do. And so I hope everyone who is charged did it. And when I say did it, that doesn't mean they're guilty. That doesn't mean they're guilty. Because just because you did it doesn't mean you're guilty. I just hope they are. Well, hope they did it. Just because it's horrifying, the alternative. But yeah. And we've had all the speculation. Ooh, is the prosecution trying to avoid Trooper Proctor? Is the defense going to have to call him? Which I think would be dumb of the defense if the prosecution didn't call him, just because why would they give Lolly the opportunity to cross-examine Trooper Proctor? But he's the lead detective. Of course they were going to call him. And I wouldn't debate. I do think what I'd like to do is maybe have a discussion, like treat it as if we're jurors. Not necessarily law tubers, but have put a jury panel together and actually discuss the evidence and come to a verdict. Not a debate, but I think that could be interesting. And I've actually been thinking I should email Kate and maybe, I don't know if all of you are familiar with him, but Paul Carroll and one or two others, maybe get Kevin Mahoney, could be interesting. So he's got an evidence package.
Raise your right hand. You solemnly swear the evidence in the court during the case now hearing to the truth, the whole truth, and nothing but the truth.
Morning, Your Honor. Morning, jurors.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Good morning, sir.
Would you please state your name and spell your last name for the jury?
Trooper Michael Proctor, Proctor.
And how are you employed, sir?
I am currently assigned to the Norfolk County District Attorney's Office in the Homicide Unit within the Massachusetts State Police.
And how long have you?
Trooper, I'm going to ask you to keep your voice up loud.
See, I wouldn't get DUI guy just because he's not that. I don't think he's a good lawyer. I just don't think he could be objective on this since he's in the free Karen Reed camp. He's like actually in the Karen Reed camp. I just, it would be too hard for him to be objective, I think, at least in this one.
Loud, okay?
Yes, ma'am.
Thank you.
And sir, if you want, that microphone in front of you is adjustable, so how close or far away you want. How long have you been a trooper with the state police?
For over 10 years, and it'll be 5 years in September with the Homicide Unit.
Now, with reference to your work with the homicide unit, with the detective unit at the district attorney's office, what, if any, specialized training did you receive in regard to your work within that unit?
I've attended several homicide schools. I've also been certified in Celebrite software programming. I've also
I've attended homicide schools. I hope that's not schools on how to commit homicide.
in addition to homicide investigations, have worked within the narcotics unit on several different investigations there as well.
Now, with respect to your work with the detective units, as far as, do you have sort of an on-call system?
We do.
And can you explain to the jury sort of how that works or how those specific days for your on-call duties are assigned?
Sure. So a Sergeant Buchanan usually sets the on-call rotation. It's at random, and your on-call is from 7 a.m. to 7 a.m. Any unattended death, homicide, suicide, overdose, things of that nature that comes in during that time frame, you own it. That's your call.
Now, were you working in that capacity with the detective units?
And that's what really pisses me off here is the collateral damage. It's awful. And it really upsets me.
On January 29th, 2022?
Yes.
And at some point in the morning, did you receive a call in regard to a situation in the town of Canton?
I did.
And what, if anything, was that? When did you first receive that call?
Sergeant Buchanan called me at approximately 6:48 that Saturday morning, advised that Canton PD had a male party that was discovered in the snow outside of a residence, and he wasn't sure what had happened. It was originally given to me as a possible medical situation.
And based on that initial call and that initial information that you received, what, if anything, did you do?
And at that point, I knew I needed to gather further information, so I contacted Detective Lank from Canton Police Department to see exactly what transpired in the morning. He had informed me that a male party had been transported to Good Samaritan Hospital with some injuries. Detective Lank didn't have much more information, so I knew I needed to contact the paramedic at the hospital, the individual who's treating Mr. O'Keefe.
Now, before I get to that, if I could, I'm sorry. As far as Detective Sergeant Lank was concerned, was that someone that you called on your own, or how did you get his information, or why did you call him specifically?
I knew he was on
Compound.
scene, so I called Detective Lank.
So that was some information that you had received at some point earlier, and then you contacted Detective Sergeant Lank.
Correct.
And following that, you reached out to whom? I'm sorry.
Firefighter Anthony Flamati.
Maybe. They can sue Turtle Boy, Diaper Boy, basically the non-parties that harass them, they can. Potentially, there's litigation privilege for Jackson Yannetti, Karen Reed. It depends. But litigation privilege doesn't extend to witness intimidation, to crimes. And so, like, if it can be shown that it was a coordinated witness intimidation effort, I'd say yes, that would breach the litigation privilege. It's just without seeing how things were communicated, I can't say for certain, but potentially yes, but absolutely for like Turtle Boy and his ilk. So it's just, there's a lot of analysis that would have to go into that determination.
And with reference to that conversation, what, if anything, did you learn from that?
Firefighter Flamati informed me that
I'm going to allow it.
Firefighter Flamati informed me that Mr. O'Keefe had some injuries to his right arm, some abrasions to his right arm, some injuries to his eyes, a cut to the nose area, and he put a 10% chance of survival for Mr. O'Keefe.
And then based on that information, who did you call next?
I contacted Sergeant Buchanan, advised him that this sounds like it's more than a medical situation.
And what, if any, decision did you and Sergeant Buchanan come to with regard to what to do, or where to go, or what the next steps should be?
So there's a couple different steps. Number one, it was blizzard conditions, and we operate, Ford Fusions or Chevy Malibu. So we got authorization to use our personal vehicles that are four-wheel drive, and
that's true. That's why, as I said, I'm horrified at the thought of innocent, factually innocent people being charged, going to trial. That's why I hope everyone who goes on trial did it or did something to be there, that no one who is truly innocent, and that extends to my clients. I do my best to give zealous representation and zealous advocacy. I'm always trying to get the best outcome possible, but I hope I never have a client that didn't do something to be there. Once again, that doesn't mean they're guilty. That doesn't mean they committed a crime. Here in Utah, you have a loud argument with your spouse and the neighbor calls the cops. One of you is getting charged. It doesn't mean you committed domestic violence. Doesn't mean you're guilty, but you're getting charged. And I don't think that's right, but it's the way it is. But you still did something to be there. You had the loud argument. Doesn't mean you're guilty. Doesn't mean you're guilty, but you did something to be there. I would hope, I never get a client where the neighbor calls that in. Yeah, there's a loud argument going next door. You better get there before they kill each other. And it's a complete lie. And the neighbor's just getting back at my client because their dog peed on the roses. I hope I never get that client because, they factually didn't do anything wrong, but they're going to get charged. And so with Karen Reed, like I said, is she guilty? Maybe. I'm getting close. She might be. I think she hit him. Just because she hit him doesn't mean she's guilty. But it's a reason for her to be here. So I think she played a part in the mechanism of his death.
Meet at Canton PD and to speak with the responding officers.
And about what time was it that you and Sergeant Mechanic arrived at the Canton Police Department?
It was approximately 10 a.m. that morning.
And so, Trooper Proctor, if I could ask you, whereabouts were you at about 8:22 in the morning?
Home.
Had you shoveled out of your driveway at that time?
Not yet.
Had you cleaned up your car at that time?
No.
So you arrived at the Canton Police Station about 10 a.m. or so. When was it that you arrived in relation to Sergeant Buchanan?
Yeah, Canton PD?
Yes.
I don't recall if Sergeant Buchanan arrived first or myself.
But suffice it to say, sometime you both arrived around 10 a.m. Is that correct?
Yes, sir.
And where did you go with the Canton Police when you arrived there?
We spoke with the Sergeant Sean Good.
And what, if anything, did you learn from Sergeant Good?
Sergeant Good informed us that while he was on scene.
And I'm cynical too. Don't get me wrong. You know, you know, covering sovereign citizens and shit, and like, I'm naturally skeptical of the police. Watching all the body cameras, you know, the code blue cam with the lacrosse cinematic universe, most of the police body cams I watch, they're a lot more patient than I am. And it helps me tamp down some of my cynicism. Of course, then I see one bad video and it's like, fuck the police. But, you know, there are bad prosecutors, there are bad judges, there are bad defense attorneys, there are bad cops. And we need better mechanisms to root them out and get rid of them. You know, think of the district attorney in New York that ran from police just like a month ago. She needs to be removed from office. She's corrupt. She thought she was above the law. And she shouldn't be a prosecutor anymore. The you know, George Floyd, the Derek Chauvin shouldn't have been a cop. But you look at so many others where they're so patient. And you know, doing my internship at the U.S. Attorney's Office, it was the white collar division, so not violent crime, but people who lost their money, you know, lost their life savings to Ponzi schemes and shit. They're, you know, they're victims. They're devastated. And I've mentioned Yvette Rodier before, the, you know, a victim of the most violent crime herself, as the victim coordinator, victim advocate for the U.S. Attorney's Office. No longer there. She's somewhere else now. Can't remember where. But seeing her hold the victim's hands and, you know, just supporting them, it's like, hey, they care. It helps you to be a little less cynical when you see the inner workings, which is, I think, one of the great things about body cams. You know, when body cameras were first introduced, police fought them because all the talk was, it's going to catch all the dirty cops. It's going to show, you know, bad arrests, and it does. But so many of them show Karens trying to abuse the police, and the police really showing patience. Body cameras have been the police best friend. And it's I just, yeah. So trust me, I'm very cynical of police, of prosecutors, of you know, that there was that juvenile court judge in Pennsylvania that was basically selling juveniles into the private prison system. He's in prison himself now. So, and that's it. Like, I think there's a lot wrong with Florida, but I like their sunshine law. It, you know, it provides us with Florida man But, it's like, you know what? Here's all the transparency. And I like that. I like that. I can't answer that, really. I try to avoid sex crimes just because I don't want to cross-examine the victims. White collar crime can be so boring and technical, but I think that's basically where you do the Chewbacca defense and try to confuse the jury into acquittal. But yeah.
And he identified Kerry Roberts, Jennifer McCabe, Karen Reed. He also informed us that Jennifer McCabe was out early in the night at a waterfall bar in Canton with some individuals, and that she was the one who called 911 when they found Mr. O'Keefe in the snow that morning.
Now, with regard to the parties that you just mentioned,
I won't, Linz. But do you think that Ron DeSantis and Alan Jackson get their shoes from the same Lyft service?
prior to January 29th, 2022, had you ever met or were you aware of either Jennifer McCabe or Kerry Roberts, Karen Reed, or John O'Keefe?
I've never met any of them.
And at some point subsequent, did you have occasion to meet and speak with Ms. Reed?
Yes,
And do you see Ms. Reed in the courtroom today?
I do.
Just for clarification purposes, if you could identify as to where she's seated or an article of clothing that she's wearing.
She's seated between Mr. Jackson and Mr. Yannetti wearing a pinstripe sport coat.
Defendant identification, important. Always got to do that.
Just that's a record reflect identification.
Yes.
Now, after you speak with Sergeant Goods, did you speak with anybody else at the Canton Police Station?
No.
And where did yourself and Sergeant Mechanic go?
We then traveled to the home of Matthew and Jennifer McCabe.
Now, with reference to when I say you and Sergeant Mechanic, at how long a period of time was it that you were with Sergeant Mechanic on that date of January 29th?
From 10 a.m. approximately, we met at Canton Police Department until we returned to the Canton Police Department that afternoon around 5:30 in the afternoon. So all day. And we also had a debrief meeting with just the troopers in my office at Canton PD. So at least from 10 to 6, 7, because we also went back to the office with some evidence.
And so from that entire time, from 10 in the morning until later on in the night, other than maybe short drives in individual cars, were you essentially with Sergeant Mechanic that entire day?
Yes, we used Sergeant Mechanic's pickup truck that entire day. I left my personal vehicle at the police department, and I rode with Sergeant Mechanic all day and into the evening.
Now, from the Canton Police Station, where did you and Sergeant Mechanic go?
The McCabe's house in Canton.
And who, if anyone, did you speak with?
We spoke with Matthew and Jennifer McCabe, as well as Brian Albert.
And those interviews that you conducted.
So, Edwin, I took antitrust in law school. It's a very complex area. It was taught by an adjunct professor, probably the top antitrust lawyer in the state. And it comes in waves. Basically, there's a lot of antitrust work when Democrats are in office, almost none when Republicans are in office. But having a good grasp of economics was essential in that class, just because we basically so much of the analysis of antitrust was looking at the supply and demand graphs and the sort of what the anti-competitive nature took away from the expected sort of economic output or, total societal good. And yeah, it wouldn't make for exciting trials. That's for certain. I would have, if that professor had offered me a job and said, "Hey, come be my associate," oh, you bet your ass I would have taken that. That would have been fun. And adjuncts were some of the best professors I had, but also the worst professor I had in law school was also an adjunct. I hated him. My best professor was my bankruptcy professor. and he technically wasn't an adjunct, but he functioned as an adjunct. Basically, he was a practicing bankruptcy attorney, former bankruptcy judge. He basically, when they codified the bankruptcy laws in the early 80s, he was very heavily involved in that. Like, I won't say he wrote the bankruptcy code, but he helped write the bankruptcy code. Like, that good. And but he, even though he functioned as an adjunct, he was a full professor. So he was the best. Far and away. Far and away. I had other great professors, some adjuncts, some not, but he was great.
Were they how were they conducted?
One-on-one, Sergeant Buchanan and myself kind of rotated out Jennifer, Matthew, and Brian. So first we interviewed Jennifer, and then once that was completed, we had her step out, go to a separate room, brought in Matthew, and then the same thing with Brian.
And for the balance of the interviews that you conducted several interviews over the course of your investigation in this case. Is that correct?
Correct.
And for those interviews, as far as individually done, was that primarily what you did with each of the people that you interviewed over the course of the investigation?
Yes, each interview conducted was either with Sergeant Buchanan or another trooper, in one-on-one, with the exception of Julie and Chris L, that I believe were in the same room as us.
Now, with respect to, I believe you just answered it, but as far as each of the interviews that you conducted over the course of your investigation, was it at any point in time, was there an interview that you conducted just by yourself?
There was just one.
And who was that one that you conducted by yourself?
That took place just at the grand jury across the street. It was the Currans. I had some difficulty locating them, so when they appeared for grand jury, I interviewed them one-on-one by myself prior to their testimony at grand jury.
Who? The Currans? We haven't heard from them. Have we? I don't know who they are. So, and that's a systemic problem, though, Dante. It's the publisher perish is the saying for tenure track professors. And so basically that's what they have to focus on. But like I said, I had great tenure track professors, both law and finance. I had great adjuncts, both law and finance. I had great lecturers, finance, master's and undergrad. I don't think I had any lecturers in law school. Lecturers meaning basically they're not adjuncts, they're full-time professors, but all they do is teach. Like at the University of Utah, Marcy Butterfield is an absolute legend, and she teaches the introductory accounting courses, both financial accounting and managerial accounting, and she's universally beloved. No PhD, unless she's got one in the years since I've been an undergrad, but CPA, just great professor, great lecturer. She teaches it and you understand it, but that's what she does. No research, just teaching. And she was so good, and various others. Of course, had a lecturer that he taught everything, it seemed, in the finance department. He was boring, not great, but yeah. And yeah, this is the much ballyhooed Trooper Proctor, who seems to be a good investigator. He did some questionable things. My understanding is Lolly, takes the sting out of it by asking him on direct. And part of that is, I mentioned earlier, we're headed to Lincolnshire, to Scunthorpe, which the American viewers mostly aren't familiar with that because it's an English saying. Scunthorpe is a real city in North Lincolnshire. But yeah.
You had attempted to meet with them prior to them coming to the grand jury, is that correct?
Yes,
And they had not been responsive to that?
correct.
However, they were responsive to the summons, and so you interviewed them before they went into the grand jury, correct?
Yes.
Other than those, as far as Mr. and Mrs. Carden, every interview that you conducted was in the presence of at least one other trooper?
Correct.
Now, as far as you mentioned, one name that we hadn't discussed before at the McCabe household, a Brian Alberts. Prior to January 29th, 2022, had you ever met or were you aware or did you know Brian Alberts?
I never met Brian Albert until that interview.
Now, following the interviews that you conducted at the McCabe households, where did you go from there?
After the interviews at the McCabe household, Sergeant Buchanan and I traveled to Good Samaritan Hospital for two reasons. One, we knew Miss Reed was there receiving treatment for Section 12. And two, we wanted to view Mr. O'Keefe.
And when you arrived at the Good Samaritan Hospital, was the defendant, Ms. Reed, still at that facility at that time?
We spoke with the security staff at Good Samaritan Hospital. They informed us that Miss Reed was released.
I'll allow it, just to where you went.
That Miss Reed was released several hours prior to our arrival.
And do you know about what time it was that you arrived, yourself and Sergeant Buchanan, at the Good Samaritan?
12:47.
Maybe approximately 1 o'clock.
Hey, I was
And
13 minutes
You
off.
mentioned there was a second reason, and that was to view Mr. O'Keefe, correct?
That's correct.
And in your application, did you have a chance to view Mr. O'Keefe's body at the Good Samaritan?
We did.
And where was that within the hospital?
That was in the emergency room.
And when you went to where Mr. O'Keefe was, can you describe for the jury what, if any, observations you made of Mr. O'Keefe's body at the time that you observed?
The first thing I noticed on Mr. O'Keefe is he had abrasions on his right arm. On the top of his right arm is approximately 6 to 8, ranging from his forearm to his lower bicep. There was no injuries underneath that forearm. Both eyes were swollen and black and blue. He had a cut on, I believe it was his right nostril. Another smaller cut, I believe it was on his left eye. Those are the injuries that kind of jumped out to me.
At any point in time, did you make any observations of the back of Mr. O'Keefe's head while you were there?
I did observe blood on the back of the head. I wasn't able to tell if there's any significant trauma to the back of his head.
Now, from
And once again, to me, this sticks out because if he's in a fight, if he's beaten to death, you'd expect injuries on his left side as well. You'd expect defensive wounds. You'd expect, tissue under his fingers. Remember, we heard they took the samples, nail clippings. So you'd expect the telltale signs of a fight. They're not there. All we have is indications of trauma to one side of the body. And to me, that screams he was hit on the right side with an SUV, not that he was beaten to death. So
the Good Samaritan Hospital, yourself and Sergeant Buchanan, what, if any, items did you secure in evidence from the Good Samaritan Hospital?
So after we viewed Mr. O'Keefe's body, we observed a pile of clothes in the corner that hospital staff had cut off Mr. O'Keefe and kind of piled into the corner. The one thing that had jumped out to both of us was one sneaker. And it's fairly common in a motor vehicle pedestrian strike that.
Sustained. Next question. I'll strike them.
So that's being struck as non-responsive. I observed the clothing, and something that stuck out to me was the one sneaker, because yada yada, that's non-responsive. That's not answering the question that was asked. Lolly can ask, did you notice anything about the sneakers? Yeah, there was only one. What's significant about that to you? Well, in a motor vehicle accident, I often see that they're knocked out of their shoes because that's the type of force. So they'll be able to get to this. It's just this was non-responsive. And of course, his non-responsive answer is something I've been saying for a couple of weeks now, is it makes sense. I'd expect the shoe to be roughly where he was hit because he was knocked out of his shoe. It's that kind of force.
Fairly common, the observations.
As far as the clothing that you observed, can you describe the clothing that you observed?
Yes. We observed one black sneaker with a Nike logo, a pair of blue jeans, a belt, boxer shorts, an orange t-shirt, and a two-tone gray light kind of hooded sweatshirt type of material.
Now, Trooper Proctor, over the course of your career responding to unattended deaths or death investigations.
I mean, the thing is, you know, I don't know if you watch basketball games, and just the lateral movement that basketball players exert on themselves, like, you can't play basketball without having your shoes tight. You're not going to be able to move the way you need to. And people lose their shoes just because, you know, they are moving laterally side to side trying to defend someone, and they plant their foot and come to a real sudden stop, and their foot keeps moving while the shoe is on the ground. It's tight, and their foot slides right out just because of physics. Apply that to getting hit by a car. Let's, you know, pull a random number out of the air and say 24 miles an hour. That's a lot faster, a lot more momentum, especially when you consider the mass of a Lexus. A lot more force than a basketball player moving laterally. And if that shoe is firmly planted, if that foot is firmly planted, it's that force can easily knock you out of the shoe, even if it is tight. We don't know that it was tight. John, you know, when it was just out social, out bar hopping, he might have liked his shoes loose. I don't like it, but people do wear their shoes loose, that they have the laces loose. It doesn't make sense to me, but there are people that like it. It's fashionable. But to me, especially, as I said, since the shoe was found right up against the curb, to me, I think his foot was planted right next to the curb. And so that acted, to me, once again, this is me speculating, but it acted as sort of a stopper for the shoe to keep it planted as John went flying. Because, you know, it's enough force to throw him 8 feet onto the lawn. It's just, that's a lot of momentum. And as Alpha says, it's a low top. It's a lot easier to come out of a low top than a high top. So we'll see.
As a detective of unit, how many of those have involved situations where a pedestrian was struck by a motor vehicle?
Well, I've been in the unit, maybe 3 or 4, and then I've other experiences on the road.
And as far as the other experiences on the road, can you expound upon those as far as how many or over what time period we're talking about?
About 6 years I spent on the road, so maybe another 3 or 4.
And with reference to those pedestrian crashes, what, if anything, have you seen in those prior?
To me, Nikki, that, like, dirty how? Because we know the shoes off the foot when he's found. We know he's under several inches of snow. So to me, it's going to be dirty. It's sopping wet. The question is, did he leave his shoe and take a step? So, dirty on the sole of the foot as opposed to just wet, that could be interesting. And also, yeah, shoelaces, you tie them tight with wear. If you don't retie them throughout the day, they do loosen. Especially my experience, the sort of thicker laces really loosen, or dress shoes, like the little like really thin leather laces are impossible to keep tight. These look like they're slightly on the bigger side of normal laces for athletic shoes. So it's hard to say. And it's possible he crawled toward the house, but he was found on his back. So if he did crawl, he rolled over at some point. I kind of get the feeling he was thrown 8 feet by the force of the collision, landed on his back, and died there. We haven't heard from the accident reconstruction experts yet, so that's just my, headcanon, but we'll see.
Investigations in regard to sneakers or footwear of pedestrians involved in motor vehicle crashes.
Objection.
I'm going to see you at side boundaries.
And of course, we needed a sidebar about now. It's not going to be a long one, it looks like. So, and I think they are. I don't know if it'll be the black box, but based on the damage and the distance and yada yada yada, force equals mass times speed. We think this. So 4.5 hours, but at 1 3/4 speed. So it's, or 1 1/3 speed. So, yep. Well, I mean, maybe the FBI is swooping in to arrest Trooper Proctor as we speak. So maybe they've been waiting until this moment.
See, John?
Yes.
Now, with reference to your prior experience,
As I said, I'm a lawyer, not a scientist, but that's what I was trying to say. Momentum is mass times velocity. And I realized as I said speed that I should have said velocity.
with pedestrian crashes involving motor vehicles, what, if any, observations have you made on those prior occasions in regard to the footwear with respect to the pedestrians and motor vehicle crashes?
No.
In those experiences, I've observed one, if not both, pieces of footwear remained at the point of impact.
And so with respect to your observations of the clothing, there only being one sneaker on Mr. O'Keefe's property, what, if any, significance did that have to you as far as the sort of steps you took subsequent in your investigation?
That was just a little piece of evidence that Sergeant Mechanic and I picked up, that only one piece of footwear revealed the potential of a vehicle strike.
Now, in addition to Sergeant Mechanic is one of your
Casey?
supervisors within the detective unit, is that correct?
Yes,
And there's another one, a Lieutenant Brian Tully.
that's correct.
Now, with respect to the one sneaker that was found in Mr. O'Keefe's property, what, if anything, with regard to that, did you communicate to Lieutenant Tully?
Objection.
As to how it goes to the investigation,
Yes.
I'll allow it.
Sergeant Buchanan and I informed DLT Tully that there was one shoe at the hospital.
And with respect to Detective Lieutenant Tully, are you aware that subsequently in the afternoon that there was a search that was conducted in the area of 34 Fairview Road where Mr. O'Keefe was found?
Yes.
And are you aware of what, if anything, was recovered in the area where Mr. O'Keefe was found on that day?
I'll allow it as to the investigation.
Yes.
And what are you aware?
We were informed, Sergeant Buchanan and I were informed that CERT team and Detective Lieutenant Tully discovered a black Nike sneaker with a white swoosh logo that was a match to Mr. O'Keefe's shoe at the hospital.
Now, from these items of clothing, sorry, let me just look up the
The FBI coming. They're about to swoop in.
Trooper, in addition to the shoe that you've already referenced, what, if anything else, did you observe about what kind of clothing and the condition of the clothing that you observed in the hospital?
The clothing seemed was wet. It was pretty well saturated. The right sleeve had some like cuts to it, like tears to it. There's blood and vomit on it, if I recall. Those were the observations I had made of the clothing. They had been cut to rendering first aid as well, the pants area.
Now, subsequent to viewing these clothing items at the hospital at a later time, did you have occasion to observe surveillance video from a variety of places on the evening of January 28th into the early morning of January 29th, depicting Mr. O'Keefe?
Yes.
And what, if anything, did you note with regards to the clothing that you observed at the hospital and the clothing that you observed in the video?
So the videos I reviewed at CF McCarthy's bar and the Waterfall bar were the same clothes Mr. O'Keefe was wearing that Sergeant Buchanan and I had secured at Good Samaritan Hospital.
More fads.
Now, Trooper, I'm going to ask you some questions just in regard to securing these items specifically as evidence, but in general terms as far as...
Don't insult Trooper Proctor like that. He may deserve some insulting, but not that.
Securing items and evidence within your unit. How is that accomplished? How is that done? What do you do with items that you deem of evidentiary value that you then secure?
I mean, we have not heard from the accident reconstruction expert yet. So it's, once again, I think they're just, they have to go in the order they go in to lay a foundation. And I think for the accident reconstruction, they need the foundation. So not hearing from the medical examiner would be weird. Not having heard from them yet, to me, isn't weird. I'd expect to hear from the lead investigator before the medical examiner. So
generally, if we take an item for evidence, we'll put it in a brown paper bag, document it, time, date, who secured that item, address, where it's discovered, and then we'll bring that back to our office, to the evidence room that is has triple retention. It has an actual key, a key card, and an actual access code, and only 3 members of my office have access to that room, the 2 evidence officers and Detective Lieutenant Tully.
And at this time of January 29th, 2022, who was assigned as the evidence officers who had access to that room?
So that'd be Trooper David Achico and Trooper Jeffrey Kukowski.
Did either yourself or Sergeant Buchanan have any access to that evidence storage?
No.
Now, with reference to these items that were seized and say items that were seized subsequent during the course of your investigation, did they go through that same sort of evidentiary storage process that you were speaking about before?
Yes.
Now, with reference to, in addition to the clothing items, at some point did you come into possession and seize Mr. O'Keefe's phone?
Yes.
And do you recall where it was that you received or retrieved Mr. O'Keefe's phone from?
We were received at the Canton Police Department.
And was that prior to you going to the Good Samaritan?
After, I believe.
So following the Good Samaritan, where did you go from there?
So after the Good Samaritan Hospital, Sergeant Buchanan and I traveled to 345 Country Hill Drive in Dayton.
And why did you go to that location?
That was the residence of Miss Reed's parents' home. And having a brief conversation with Miss Reed on the phone, she informed us she was at her parents' house.
and so retrieve
So you had
Alexis.
called Ms. Reed, spoken to her, and informed her that you were coming there to speak, correct?
Correct.
And just as you had done with Ms. McCabe, Ms. McCabe, you spoke to Ms. Reed within her home?
Yes.
And who, if anyone else, did you reach out to on your way there with regard to local law enforcement as you were driving to Dayton?
We contacted the Dayton Police Department just for a couple of reasons. One, it's a common courtesy if we're in another town.
Jiggly meat bags. An accurate description, I think.
We just kind of give the local PD a heads up, but also we needed to coordinate a plow truck and potentially a tow truck as well.
And why did you need to coordinate those?
At the time, there must have been at least a foot of snow on the ground, more. And it was a dead end cul-de-sac, so which was made it difficult to navigate. So we requested the plow to clear a path for Sergeant Buchanan and I to get down the roadway, as well as clear the driveway of the residents, so the tow truck could pull into the driveway.
Now, as far as the drive from Good Samaritan, that's in Brockton, is that correct?
Yes.
As far as the drive from the Good Samaritan Brockton to,
Except the snow wasn't deep at the time. It had only just started snowing. Remember, we're using the rule of thumb, roughly an inch an hour. It started snowing roughly at midnight, assuming he was struck at 12:30. There's less than an inch of snow. By the time they're collecting the vehicle, there's 18 inches of snow, but it's been 18 hours, roughly. So there's a lot more snow now than when he's alleged to have been struck. So
the defendant's parents' home in Dayton. About how long a drive was that, and how would you describe the weather conditions along the way?
Yeah, with the weather conditions were whiteout, high winds, blizzard conditions. We had to travel very slow. It was almost about an hour to get there.
And when you arrived there, you're in Sergeant Buchanan's truck, is that correct?
Correct.
And where did Sergeant Buchanan position the truck in relation to the house at 345 Country?
From what I recall, Sergeant Buchanan went down the cul-de-sac and turned around, and he actually had to let me out first because of the high snowbanks, and then he parked kind of along the snow, pointing essentially to Mr. Reed's house.
And at some point, did members...
And to me, Anne, the impact on the right side of his head, since that, most of the injuries are on the right side of his body, are from being struck. The left side injuries on the head, to me, those are from striking the ground. Because to me, it sounds like there are injuries to the left side of his head, but less severe. So it just, to me, it makes sense. He's hit on the right side, strikes the ground on his left side, falls onto his back. And the thing is, I don't think we need a weather expert. Just, we've implied a rate of roughly an inch an hour, but we've heard from the witnesses, yeah, there was a blizzard. And so we don't need an expert for that. We've heard, when John was found, there was between 4 and 6 inches of snow, which implies the rate of an inch an hour. We hear, later in the afternoon, at 5 o'clock when the search team is searching, there's about 1.5 feet of snow. It's been about 18 hours. So it just, to me, you don't need the expert. You have the witness testimony of the conditions they experienced. And to me, that's enough, because the reality is the weather plays a part as far as the search, as far as finding John, as far as covering up evidence, but you don't need an expert. It's not an element of the crime itself. So I don't think we need the expert. Who knows? They might have one on the witness list. I don't think they do, but
of the Dayton police come along and join?
Yes.
And do you recall who those people were?
I believe one of the officers' last name was Barrios.
And had you ever met that officer before?
No.
Now, with respect to the home, had you and Sergeant Mechanic approached the home at any point prior to the Dayton police showing up?
I can't recall if, no, they had arrived first before we approached the home.
And when you approached the home, you went, what did you traverse? How did you get from the street to the home?
We walked down the driveway, and then we observed Miss Reed's Lexus parked in the driveway, the front of it facing one of the garage doors. That's when we observed the broken taillight on the right side of the vehicle. We then proceeded to the front door. The snow was about up to our waist, and knocked on the door and was greeted by Mr. Reed.
So as you're walking up the driveway towards the home, you see Miss Reed's vehicle. Is that correct?
Yes.
And that's a vehicle that you later subsequently found to be registered to.
It's possible, Nikki, but where does the taillight come from then? Because it just, to me, there's evidence he was struck. The weather might have played a role in that, but I don't see it. Because there's the broken taillight, there's the scrapings of the clothing had taillight. So it's just, there's too much there for me to think it's just he slipped. It's possible, but I don't see it.
Ms. Karen Reed, is that correct?
Correct.
May I approach?
Yes.
So I'm showing you documents, 4 pages in length. Just ask you to review that after I'm finished. And do you recognize that document, sir?
Yes.
What do you recognize it?
The Registry of Motor Vehicles, it's the certified document for Miss Reed's Lexus.
Is that the plate information that's contained in there? Is that the same plate that was affixed to Miss Reed's vehicle on that day?
Yes.
And that also details sort of the history or how long she's had possession of that vehicle. Is that fair to say?
Correct.
Going back to, I believe, 2021. Is that correct?
Yes.
May I approach, Your Honor?
Yes.
Call will seek to introduce and admit as the next exhibit.
No objection.
Now, with respect to Ms. Reed, at some point you go into the house. Is that correct?
Yes.
And how do you enter into the defendant's parents?
So Sergeant Mechanic and I, after we knocked on the front door, Mr. Reed directed us around the corner, opened up the garage door for us, and invited us in.
Now, if I can take you back to, I'm sorry, just as far as when you're coming up the driveway and you're passing by the defendant's vehicle, you mentioned some damage that you observed to the right rear passenger side area. Is that correct?
Yes.
Can you describe to the jury what it was specifically that you observed as far as damage to that area of the vehicle?
Yeah, the right rear taillight had large pieces missing from it.
So you proceed inside the home, and where is it that you're directed, and where is the defendant?
We're invited into a large living room area. Miss Reed is seated on a couch, and her parents, William and Janet, are present for the.
The thing is, the vehicle was seized, but if she doesn't pay the car payments, she takes the hit on her credit. So sucks, but there you are. And daddy pays.
Conversation and kind of standing off to the side.
And that conversation goes on for approximately how long?
Approximately half hour, 40 minutes.
And when you terminate that conversation, you come back outside of the home. Is that correct?
Yes.
And where is the vehicle at this point?
That is being put on the tow truck.
Now, in addition to the defendant's vehicle, what, if anything else, was taken and seized as evidence from the defendant on that one?
After confirming the phone Miss Reed was holding was in fact hers, we told her we were seizing the phone and we'd be writing a search warrant for that.
Now, during the course of the conversation that you and Sergeant Mechanic had with the defendant that afternoon at her parents' home in Dayton, were there some questions in relation to contact information for other people that were at bars or different establishments the night before?
Yes, we asked Miss Reed specifically for some of the friends that Mr. O'Keefe was with at CF McCarthy's. One person in particular was Michael Camerano. So we observed Miss Reed enter the passcode on her phone, retrieve Mr. Camerano's phone number for us, provide it to us, and that just further confirmed that was her cell phone.
Now, through your training experience, when a cell phone is seized from a person, what, if anything, is it that you do with regard to that cell phone to preserve the information off?
Well, first thing we do is we put it in airplane mode, and then we give it to a cell phone expert in our office, Trooper Nicholas Garino, and he essentially tries to access the data in that phone once a search warrant is obtained.
Now, as far as putting that cell phone in what you described as airplane mode, what is the purpose of that?
It's to avoid if someone wants to go on a tablet or a laptop and access the information on their phone, and they can start deleting stuff off their iCloud. This prevents that.
So you secure the phone, you secure the vehicle on the tow truck, and then where did you and Sergeant McKenna go from there?
We follow the tow truck from the address in Dayton to the Canton Police Department. We're secured in the Sallyport Bay.
And if you know approximately what time was it that you arrived at the...
So, of course, he says something that I want to make a point about when I have food in my mouth. But airplane mode. Remember when Delete Laws was arrested in Ironton, Ohio? His phone was seized, put in evidence. He was trying to access it remotely to tamper with the evidence. Yeah, put it in airplane mode. So
Again, police department had secured the defendant's vehicle in the Sallyport.
So we left Dayton around 4:16 p.m. and arrived in Canton at the police department at approximately 5:31 p.m.
And with reference to the Canton Police Department's Sallyport garage, why was the vehicle taken there?
I wasn't part of that decision, but it's my understanding that it was a heated facility. The other options were, I believe, the barracks in Milton, but that's not large enough to house a vehicle that size, and it's not heated.
And in regard to the heated, what was the sort of purpose or utility of storing it in a heated setting?
Miss Reed's vehicle was covered with snow and ice at the time. It was transported from Dayton to Canton.
And with regard to the Sallyport garage area of the Canton Police Department, at some point were you inside that area?
Yes.
And what, if any, observations?
the problem with that, though, Nikki, is well, for starters, the taillight fragments weren't only found in the plow debris. They were found in untouched snow. But there was no unrelated taillight, because remember, the taillight plastic, apparent plastic, well, it was all plastic, apparent plastic. The only unexplained plastic piece was the large, flimsy piece. I don't know what that's from. I don't know if it was, the protective film over the taillight. I don't know what it was. But as far as glass goes, there was the broken drinking glass and there was unidentified glass, but that was on Karen's bumper. It wasn't found on the road. It wasn't found on the grass. It was on Karen's bumper. So two different things. But the only taillight fragments found match Karen's. So the only unknown plastic, well, there's also the plastic straw, but the only unknown plastic was the flimsy, and that's it. Alpha speculated last week. It's a takeout container. Is what it looked like to him. So it doesn't look automotive at all. It doesn't look automotive at all. It's, did they take a takeout from the waterfall? Did they take leftovers? It's just, we don't know what that is, but it wasn't taillight. It wasn't random taillight from a different car. It wasn't taillight material, period. And the random glass on the bumper, we don't know what that was either. Was it something internal that was broken, like inside the broken lens? contained internally within the housing. I just don't know. Don't know. So, and that's it. It could have been, it's a blizzard, the wind's howling. That looked, real light and flimsy, but it was a sail. So it could have blown on the scene. We don't know. We don't know. But it doesn't negate the fact that Karen Reed's taillight was found under 18 inches of snow. It's just there.
Observations did you make as far as the temperature or the heating within that facility?
I don't remember the exact, I couldn't put like a ballpark on temperature, but it's certainly warmer than outside.
Now, as far as the vehicle was concerned, either on scene, either in Dighton or at the Sallyport garage, or at any point in time that you were in the presence of that vehicle, what if any contact did you have? What if anything did you do or observe Sergeant Mechanic to do with regard to that damaged area you described on the right rear passenger side?
Yeah, Sergeant Mechanic and I never touched any part of that vehicle.
And as far as the moving it from sort of the tow truck into the Sallyport area, how was that accomplished?
The tow truck driver removed it from the tow truck and pulled it into the Sallyport bay.
Now, as far as prior to leaving that Sallyport area of the garage where the vehicle was, what, if anything, did you and Sergeant Mechanic do with reference to securing that vehicle or coordinating it off in any way, shape?
We tried to set up a perimeter as best we could using caution tape, just kind of sectioned it off with caution tape.
Now, at some point, you leave the Sallyport area, Canton Police Station, and where did you go from there?
We had a debrief meeting. So there's other troopers. There's troopers at scene on 34 Fairview Road. There's other troopers conducting interviews. So at the end of the night, members of my office met in a conference room at the Canton Police Department to exchange information as far as what everyone had learned throughout the day.
And as far as that meeting is concerned, that's just troopers from your unit, from your office, is that correct?
That's correct.
And so there were no members of the Canton Police Department that were present for that, is that correct?
No, correct.
And do you know why that was?
They had taken a step back from the investigation. They weren't going to participate in any interviews or anything of that nature.
And how was that communicated to?
So once again, they're not interviews, they're not conducting interviews, the Canton Police, but that doesn't mean they're completely out of the investigation, as Jackson has tried to allude.
You and Sergeant Mechanic.
The best of my recollection was that debrief meeting that we were informed that essentially Canton PD would be taking a step back from the investigation, and that now this is just solely a Norfolk State Police investigation.
So before we get to sort of the debriefing and all that's covered in that, as far as when you're on call, you get a call for any kind of sort of homicide or unattended death or anything like that. You then become what's called a case officer for that investigation. Is that correct?
Correct.
And can you describe for the jury sort of what the duty or the role is of the case officer vis-a-vis the rest of the members of the unit?
So essentially, a case officer is more of a facilitator. You kind of delegate out tasks, coordinate interviews. The case officer isn't the sole decision maker. I have supervisors. I have that we bounce ideas off of. I get feedback from. I also keep them updated. It's a collaborative effort in each investigation. We're a small office, so when a homicide comes in, everyone essentially drops what they're doing, and we all work on it together. So it's a collective effort to work on these cases. And essentially, the case officer is just kind of the record keeper of all the reports that come in and video that comes in. But when it comes down to decision-making time, it's a group effort.
Now, with reference to that collaborative effort that you were just discussing in this sort of debriefing meeting, so there were other troopers doing other things or other tasks throughout the course of the day of the 29th, correct?
Yes.
And so what was sort of the purpose of or not specifically what was discussed, but in general terms, what was discussed during the course of this debriefing?
The taillight piece is found at 34 Fairview Road by CERT. The one sneaker found at 34 Fairview Road. Interviews conducted, and then Sergeant Mechanic and I have shared everything we had kind of learned throughout the day as well.
And that debriefing meeting, if you know about how long approximately did that take in this case?
I can't recall, maybe half hour.
The thing is, though, they weren't forcefully recused. They didn't have to. They were just trying to avoid even the appearance of bias. And they felt not doing interviews was the way to do it. But once again, they didn't have jurisdiction anyway. It was the state police. But the locals still assist. And yeah, it's just, to me, it's not a problem because they weren't investigating Canton police officers. They weren't, there weren't actual conflicts. They were just trying to avoid the appearance of a conflict. And avoiding interviews, they felt, was the way to do that. And that was their decision. You know, frankly, if the state police thought that it was a problem, they could have said, you know what, you guys are completely out. We're going to handle it ourselves. But they didn't see a problem. But once again, from the start, you know, they investigated it like a normal DUI manslaughter. They didn't investigate it like it was going to become a conspiracy a year down the road. And so they just went about their normal practices as normally as they could.
So following that meeting, where did you go?
Sergeant Mechanic and I had secured some evidence, the clothing from Good Samaritan Hospital, the additional sneaker found at 34 Field Road, as well as the taillight pieces discovered at 34 Field Road, and Mr. O'Keefe's cell phone and Miss Reed's cell phone. And him and I transported those to the office in Canton.
And when you transported them to the office in Canton, what, if anything, did you do with those items?
The two cell phones were given to Trooper Nicholas Garino, and the clothing was laid out on top of butcher paper to dry out in our evidence intake area. And then the bag taillight pieces were set aside in the evidence intake processing area. Sergeant Mechanic and I didn't have access to the permanent evidence locker area, so we just secured them in the temporary intake area.
And that leads me to my next question. As far as the area that you're talking about with regard to the clothing items and the other items that you secured beyond the cell phone, that was in a secure area of your office, is that correct?
Correct.
And by secure, I mean restricted access to the troopers within your unit, correct?
Correct. It's a key card, and it's also equipped with an alarm.
Now, following that, as far as these items of evidence and other items of evidence received throughout the course of an investigation, how is it that they go, or what, if anything, is done, if you know, between the time that they go from this temporary storage area to the permanent storage area?
Yeah, I'm not an evidence officer. I never have been. My understanding is once it's in the evidence processing area, it gets put into the permanent evidence room that only, like I said, two troopers and a detective lieutenant have access to. And it's the evidence officer's responsibility to process that material when they see fit.
Now, sir, if I could turn your attention to February 1st of 2022, were you working in regard to...
So who did process it 6 days later once it was dry? If it wasn't Trooper Proctor. That would be nice to know.
this investigation on that date as well?
Yes,
And at some point, did you have occasion to go back to the Canton Police Department, specifically in the Sally Port Garage area?
I did.
And what was the purpose of you going out to the Sally Port Garage on that?
Pursuant to a search warrant, we were processing Miss Reed's Lexus SUV.
And when you say we, who, if anyone else, was present with you, or who, if anyone else, did you contact in reference to the processing pursuant to that search warrant of the defense?
So we had a chemist from the State Police Lab, Miss Maureen Hartnett, as well as a trooper from Crime Scene Services, Trooper Zachary Clark. And then later in the day, the accident recon team, Trooper Joe Paul, had arrived as well.
Now, if I could just ask you a couple questions in regard to Crime Scene Services section. Can you describe for the jury sort of what their role is in regard to investigations that you do and how they're sort of contacted?
So in any scene, if it's required for it to be documented, Crime Scene Services will arrive. They'll document.
Pulling a KFAR here. And at 12:30ish, Karen drove from 34 Fairview back to the O'Keefe residence. She left at 5:07, drove to Jen McCabe's house, and I can't remember if they hit the road again or if Carrie Roberts found them there. Doesn't matter. From there, they said, you're in no condition to drive. So at roughly 5:30, 5:45, Jen McCabe drove with Karen in the Lexus back to the O'Keefe residence, parked it in the driveway. They all three piled into Carrie Roberts' car and drove to 34 Fairview. The taillight, the testimony is the taillight was already broken by the time Jen McCabe drove it. She wouldn't have backed it into anything because she didn't back it into the driveway. She pulled straight forward. And then I believe Karen Reed's father drove it at, we'll say noon. I don't know exactly, 10 noon, whenever, from the O'Keefe residence to the parents' house. And then it was from there towed to the Canton Police Sally Port. So that is my understanding of the entire sequence of the movement of the vehicle as alleged by the prosecution through its witnesses. So we don't know. It's at 10:30. The only information that Sergeant Buchanan had was, I hit him, and I hit him could mean, I punched him, I threw the cocktail glass at him, I hit him with the car. We don't know. It's at some point they determined the evidence was the car. Because at what point did they find out about the broken taillight? I don't know. But it's the thing is, first impressions don't have to be your last impression. You process the information, you process the data as you acquire it, and alter your working theory based on the evidence as it comes in. So, and by the time they went at 3:30 to the Reed residence, they had decided it was probably a vehicular incident because they had a warrant to seize her SUV. So sometime before then, they had put it together. But it could be that, what time did they go to the McCabe residence and speak with Jen, Matt, and Brian Albert? That's probably about the time they started thinking, oh, it's probably that. Because, based on the initial scene, they don't have a lot of information. But once they interview Jen McCabe, 11 o'clock, 12 o'clock, and she says, she pointed out the broken taillight to us, and it was broken at 6 in the morning, and they say, oh, well, that changes our theory. Or hearing from the ER doctors, yeah, this is more in line with a motor vehicle strike than, a physical assault. So it's just throughout the day. Throughout the day, they take in the information. And so when did they decide that's what it was? I don't know. I don't know. But and I'm trying to answer your question, and the answer is I don't know when they decided. But based on the timeline that's been provided, I'm guessing it was probably as they were interviewing Jen McCabe is when they had their first inkling that that's what it was. Because the first police, contact with the SUV was at 8 o'clock, but he was there to check on the kids. So we got the dash camera of the taillight being broken, but he wasn't there to look at the taillight, so he probably didn't notice. It just, the dash camera happened to pick it up. But I can't remember when they first spoke with Carrie Roberts, but pretty much the first thing they did was go to the McCabe residence. They went there real quick. And like I said, I can't remember if that was 9, 10, 11, noon. But I'm guessing their interview with Jen McCabe, the taillight's broken. Karen pointed it out to us in John O'Keefe's driveway. Yada yada yada. I'm guessing that's about when they revised their working theory. So
Document the scene with photographs. In more serious situations, in a homicide, for instance, they'll actually take video as well as dust fingerprints.
Now, with respect to this particular investigation, there were a number of different areas or different times when crime.
And that's true. The first time they saw it was at Karen Reed's house because Karen's dad drove it from the O'Keefe residence to the Reed house at roughly 10 a.m. Once again, I haven't written down the timeline, but roughly they release her from the hospital. They go to the O'Keefe residence. They're there for 15 minutes. She walks out with a box of something and they drive off with it. So first they see it is at the Reed residence, at her parents' house. But by then they had already obtained a warrant to seize it. So they had decided, they had convinced a judge that there was probable cause to seize the SUV by that time. And that probable cause probably came from their interview with Jen McCabe at her house at, 11-ish, whenever. So
Crime Scene Services was contacted to document, correct?
Yes,
And that would include a Good Samaritan when you observed injuries to Mr. O'Keefe.
correct.
That would include the autopsy that was performed on Mr. O'Keefe.
Yes,
That would include February 1st in the Sally Port garage when the search warrant was executed on the defendant's vehicle.
correct.
That would include subsequent searches that occurred at Fairview Road. Is that correct?
Yes.
And with respect to each of those instances, if you know, was it ever the same trooper from Crime Scene Services section that came out and memorialized each of those respective areas?
There was a different trooper each time.
And is that something that you or any member of your unit has any control over whatsoever as far as who shows up from Crime Scene Services to memorialize or document a scene?
No.
I think it's more or less been proven they couldn't have, Anne, because when the officer, when the Canton lieutenant was there at 8 a.m., it's all on dash cam, so he didn't. No officers were at the O'Keefe residence between then and Karen taking the SUV to her parents' house. And once again, it was towed directly to the Canton Police Department and arrived at 5:07 or 5:10, whatever. But the search team, the search and rescue, was already at 34 Fairview before the SUV arrived at Canton, or at least they'd been activated. I can't remember exactly, but it just, they couldn't have got it under 18 inches of snow, and it just, the timeline doesn't work without a time machine, at least not to me.
Now, with respect to the search warrant execution on February 1st, what I want to ask is between the time that you were in the garage on January 29th, 2022, and the time that you're there for the search warrant execution on February 1st, had you been in that Sallyport area of the Canton?
And to me, once again, that's the defense trying to portray normal police activity as suspicious. It's, things don't make it to the lab immediately. It takes time. And so long as they can show the chain of custody, yeah, it sat in the evidence room for 4 days as we were gathering more evidence so that we could take everything to the lab all at once. You know, it's so long as they have the chain of custody, it's not suspicious. But as I said, you know, from Trooper Proctor, we had you know, they laid the clothing out to dry on butcher paper in a secured room, but Trooper Proctor didn't tell us who picked it up, who bagged it. And if they can't answer that, it could be a problem. But and I get it, that's what I'm answering. The collection date and the drop-off date at the lab, so long as there's a chain of custody, so long as they document where it is in the meantime, doesn't matter. Unless it's perishable, of course, then it matters. But, you know, if it says collected 129 and they take it on 2/3, but they have it documented as being in the evidence locker until that, you know, in that time, it's not suspicious. It's just they haven't had time to bring it to the lab yet. That's just normal. It's normal. And Taylor, good to see you. I think this is the first time I've seen you. And yeah, I don't get the conspiracy. I really don't. So so if it's collected on the 29th, it should be dated the 29th. Or at least it should be documented that it was collected on the 29th. But if it's bagged on the 3rd, you should mark that it was bagged on the 3rd. So long as you have it documented that it was collected on the 29th. Because every step along the way should be documented. Every step needs to be documented. So if the bag says February 3rd, because that's when it was put in that bag, so long as they have it documented from the time they found it, that's fine. It's fine. That we've seen. They haven't documented it that we've seen. So remember, we don't get to see everything. Lots of stuff gets submitted as an exhibit, but not shown. It just gets authenticated. It's in as an exhibit, and the jury gets to see it. We don't. You know, we haven't seen the bar receipts. They're exhibits. The jury gets to see them. They get to see, oh, Karen ordered triple vodka sodas. Interesting. But we don't get to see them. They're just exhibits. So they didn't document it that we've seen yet. We still might see it. We might get the custody sergeant, you know, the evidence custody sergeant, to testify to the exact chain of custody, because that's their job. Just because we haven't seen something yet doesn't mean we won't. That's the thing about trials, is you've got to wait till everything is in. Got to wait till everything is in. So, and once again, we saw the evidence tags, but if their procedure is to tag it with the date they bag it, as opposed to the day it's found, so long as it's all documented, it's fine. What would be suspicious to me is if they don't use their standard procedures. You do the standard procedures in every case, even if it's weird to me, you're going to have less problems than if you do things weird in this case that you don't do in every other case. So if this is their evidence documentation process, if this is their normal process, it's fine. It's fine. So I'm just, like I said, we haven't seen all the evidence yet, and I'm going to wait until we see all the evidence.
Station at any time in between?
No.
Now, with respect to the taillight area on the passenger side of the defendant's vehicle, what, if any, differences or what, if anything, do you note sort of between your observations of the taillight on the 29th versus your observations on February 1st?
Yeah, the only difference from the 29th to the 1st was snow and ice had melted from the taillight.
So as far as the condition of that particular taillight, was it in essentially the same condition that you observed it on the 29th when you observed it on the 1st?
Yes, it was still broken and large pieces missing from it.
But as far as the broken status of it and the pieces that were missing, was it any more broken or any more pieces missing from it when you saw it on the 1st versus when you saw it on the 29th?
No.
And with respect to the
Vince, there's still a lunch break, so.
taillight housing for that vehicle on that particular day, what, if anything, happened with it on that day, if you know?
The state police chemist, Ms. Hartnett, had it removed, which she brought to the lab herself.
So she had it removed it herself, and then physically took it with her when she left the lab?
Yeah, it was with the assistance of a Canton police officer who had an auto body shop, so he's kind of well versed in cars, so he was able to assist the chemist with removing the housing unit.
Now, at any point in time on that day of February 1st, 2022, did you come into contact physically or otherwise with that tail light? Did you handle it in any way, shape, or form?
No.
Your Honor, if I may, with court's permission, I would request to.
They very likely would, and you know, if they had evidence that the chain of custody wasn't there, that's what I'd do. So at this point, what they've done is, you know, oh, how suspicious that you follow your standard procedures, is how I've seen it. How I see it, though, isn't how everyone sees it, obviously.
Publish. Give me one moment, John.
He has not. As far as physical evidence, we saw him bring an evidence bag and place it in front of the witness stand. So it's not with him, it's in front of, with the barrier between him. But it hasn't been touched yet, other than him bringing it into court.
I may have one moment, John.
Yes.
My apologies, John. With court permission, if I could publish a portion of Exhibit 34,
Okay.
the Sally Port video. Ms. Gilman, if I could have from February 1st, 2022. At approximately 9:12 a.m.
And Mark has been here from the start, so he knows what I've preached from the start. Got to wait till we have all the evidence. The prosecution hasn't even rested its case yet. In a normal trial, it's the defense begging the jury, wait until we have our say. Don't make up your decision when the prosecution rests. Wait till we have our say. This is the odd case where day one, people have been shouting, the prosecution hasn't proved their case. It's a sham. It's a conspiracy. And, you know, even if at the close of the prosecution's case, you'll hear me saying, wait until the defense. Wait until the defense has presented their case, and then, you know, wait until closing arguments are finished. Because, you know, the jury should make up its mind off of the entire trial, not half or 2/3 or whatever. So
You can just pause it right there. Okay. Now, if I may, it may be easier and more visible with this particular video with the lights on.
Okay.
Right up.
Sure.
and once again, dark,
Um,
horrible
Directing
video.
your attention to what's up on the screen as Exhibit 34. Do you recognize what's depicted on screen?
Yes, that's the Sallyport area, Canton Police Department, and Miss Reed's Lexus kind of roped off with yellow caution tape.
And this is the execution of that search warrant that you were speaking about before, as far as your presence and some of the other members of the state police and state police lab that you were talking about.
Correct.
And this is going to be because run from here. So while this is going, if I could just ask a couple of questions as far as people within this video, do you recognize anyone in this video?
Yeah. Myself with the camera taking photographs of the vehicle.
And, you know, either side can demand the entire video. You know, it's the rule of completeness. The jury can watch the entire video, but, you know, not all of the video is going to be interesting or relevant or, yeah.
Now, with reference to this video from Sallyport.
Oh, so this is when they're conducting the examination. Since, as Vince points out, the snow is gone. They're lifting the tailgate. So this isn't the 29th. This is later. They are examining. I assume we'll see them remove the tail light. I hope. I'm hoping if we get to see the evidence bag, the solo cups, the problem is they might be just out of frame. Like just slightly out of frame. Although the other mirrored view might show it. I don't know. But yeah, this might have the solo cups just out of frame.
In police departments, what, if anything, did you learn over the course of this in regard to how that video is recorded or how it's, what, if anything, sort of activates that video?
Objection.
Ask it differently.
As far as this video is concerned, is this one continuous time frame that we're looking at, or how is it?
Objection.
Sustained.
My understanding, it's motion active.
You can
I'm sorry.
You can ask it differently.
I'm not sure there's anything said.
I'll strike if there was anything. But Mr. Lally, just ask a question, please.
With respect to this video, as far as the recording is set up, how is that activated, or how does it record?
Objection. Same question.
Yeah. How does he know that? It's sustained.
Have you watched
no
this
foundation.
video or other videos from the Canton Police Department, Sally Port Garage?
Yes,
What, if anything, did you note with regard to timing? As far there's a timestamp on the video, is that correct?
yes.
What, if anything, did you note with regard to the timestamp on this video or the other videos that you observed with regard to how time moves?
Basically.
The timestamp on the video tends to pause, indicating it's motion activated.
It tends to pause. I'll strike out.
It's going to run to about 9:24.
It can be difficult to ask a non-leading question sometimes.
Ms. Gilman, you can take that. Thank you very much. Now, Trooper, with regard to that tail light that was then taken by Ms. Hartnett to the lab, is that correct?
Yes,
And at some point that was returned to the custody of the state police, your detective unit.
correct.
And do you have that tail light housing with you today in court?
I do.
All
And,
right.
Your Honor, with the court's permission, if the trooper could retrieve that.
Okay.
Yeah, Coach Honor.
Yes.
Because remember, as I mentioned last week, the pictures are evidence, they're exhibits, but so is the taillight. And who is going to get the taillight admitted? The trooper. Now, I theorized that it was going to be Sergeant Buchanan, but Trooper Proctor instead.
Be easier that
Ooh,
recognize, sir. Do you
unboxing
recognize that?
time.
Yes,
What do you recognize that?
I recognize that to be the housing unit.
And as far as you're recognizing the housing unit, is there any sort of denotation or anything on the outside of that box indicating what's contained therein?
There's a State Police Crime Lab sticker with the number associated with it. It also indicates fragile and evidence tape that is initialed and dated as well when it's sealed up. And it's the sticker also says passenger side TA, indicating tail light.
Thank you, sir. Your Honor, with the court's permission, I would seek to admit and introduce that as an next exhibit.
Do you want it out of the box first, Mr. Jackson?
We could just take a quick look.
Sure.
With the court's permission,
Yes.
Uh-oh. He got scissors past security. Ooh. And I believe it's been indicated that the classic cruiser is used for parades and such. Ooh. Careful not to drop it. Yeah. Yep, that's a tail light.
Thank you, sir. Trooper, you can go ahead and put that back in the box. Thank you very much.
And pull it out. Trooper, you can put that back in the box. It's like they don't need to meticulously examine it. The unboxing literally was to get it into evidence as an exhibit. It's, yep, it matches the photos you've seen, the prior exhibits. We're good to go.
Put it on the bag. We need to mark that, and we're going to mark it twice, folks. We're going to mark the bag within the box, and we'll mark the box as well. Thank you.
I'm sorry, Trooper, if you could hand that to Madam Clerk.
I'm sorry, hold on. So it's gonna be 544 and 544A.
You know, require is the A, the light, and the 44's bag.
We're not even putting it like on the light because it's broken.
It doesn't have to be sterile. It just has to be uncontaminated. Because remember, the dog DNA expert, animal DNA expert, I should say, testified the standard practice is to store it in paper because you store it in plastic and it can mildew or mold, or you can have problems. So
we're putting 544 on the bag, 544A on the box.
Understood. Thank you.
You put that on the bag, please, sir.
pretty much, Naven. But Trooper Proctor said a naughty word.
544A, thank you.
Trooper, with respect to that item that's just been marked as evidence, is that essentially the condition that you observed it in both on January 29th and February 1st?
Yes.
Yes.
Your Honor, with the court's permission, if I could ask just.
Well, the thing is, sterile would connotate like completely like out of an autoclave. Like, to me, so long as there's no foreign DNA, no fingerprints, no foreign substances, no contaminants, that's what you need. Because paper isn't sterile. There's a reason they don't use paper in an operating room. But it's the right material for their job for this purpose.
To publish what's been marked as Exhibit 147.
Okay.
Greyduck gets me.
Trooper Proctor, do you recognize what's up on the screen that's been marked as Exhibit 147?
Yes,
What do you recognize that to be?
that is the right taillight of Miss Reed's Lexus SUV. You can see large pieces of it are missing.
Again, is that the same condition that you observed it both on February 1st as well as January 29th, obviously minus the snow and ice?
Yeah, minus the snow and ice, sorry, yes.
Thanks. Just going to take that down, Mr. Officer. You can have the lights back up. Thank you.
And that's a good point, Nikki, that I forgot to mention. The evidence is, well, at this point it's processed. So with this paper bag that it's in, it's already been processed. So barring a retrial and having to conduct new tests, it's keeping it secure, keeping it clean. It doesn't have to be sterile, but upon collection, it does go into the paper bag so long as it's dry. Remember, the clothing, they waited until it was bone dry, laid it on butcher paper, still paper, but laid it on butcher paper to dry, and then they bagged it. So between collection and processing, it does go in paper. But you'll notice Trooper Proctor handling it, he was wearing gloves. He's still trying not to contaminate it. But once it's been processed, the risk is still there, but it's a lot less because you've gathered the biological material or swabbed for it at least. You've dusted for fingerprints. You've processed it. So, and yeah, most of that should be red. There's the white reverse light, but none of that is on the side. It's only on the direct rear of it. And it was broken as well. So, but yeah, all of that silvery white area, the shiny reflective surface should be covered with a lens. So
Now, if I could turn your attention to February 3rd of 2022. In the morning hours of that day, where did you go in regard to this investigation?
Sergeant Mechanic, Trooper David Achico, and myself went to 34 Fairview Road along with Trooper Evan Brandt from Crime Scene Services to essentially dig out the snow in pursuit for more evidence.
Now, as far as you mentioned, as far as dig out the snow in pursuit of other evidence, what, if any, tools or implements did you and the other troopers bring with you in order to effectuate that on February 3rd?
We just had kind of standard snow shovels.
And with respect to that, as far as going back to 34 Fairview Road, and let me clarify as far as that's concerned. Prior to that date of February 3rd, 2022, had you been to 34 Fairview Road at any point in time in the course of your investigation?
No.
So that morning of February 3rd, that's the first time that you went?
Correct.
Now, with respect to, how many times did you go to the area of 34 Fairview Road over the course of the next sort of days and weeks in regard to potential recovery of items?
So February 3rd, I retrieved items on the 8th, the 11th, and 18th, and we was out there on the 10th with Sergeant Mechanic as well.
Now, as far as any of those occasions that you just described, that you went to the area of 34 Fairview Road, on any of those occasions, were you by yourself?
No.
And with respect to those other occasions, what type of people, who was with you? I know you've mentioned on the 3rd, but beyond the 3rd, those other occasions that you described, who was with you?
So you'll notice there was some red still in it. And so long as it's documented, once again, if they had to, and remember, this is so long as it's documented, if they had to remove a certain piece to, check for a manual fit to the reconstructed lens, that's so long as it's fully labeled and documented and all that. It's there. It looked to me like there might be a little less red in the actual physical taillight as it is in the courtroom than in the pictures. I didn't get that good a look at it and didn't have the pictures to compare, but it's possible that just in the bag it was loose enough that carrying it into court jostled it loose and that piece of lens is in the bag. I don't know. I'm just, once again, speculating, but and that's a good point. Missing pieces, well, we know there are missing pieces. there's dust, there's, undefined bits. Duplicate pieces would be a much bigger problem than missing pieces, though. So, yeah.
On the 18th, I believe it was Trooper Chico, based on the handwriting on the evidence bag, kind of recognized his handwriting. And the other 2 dates, I don't recall who was out there with me.
Now, with respect to items that were located, starting with the 3rd, do you recall specifically what, if any, items were located on the 3rd?
We've located a black drinking straw, consistent with the one seen in the waterfall video of Mr. O'Keefe walking out of the bar holding the glass. We located his hat that had the American flag that was deep underneath the snow. As we were digging, we discovered that. We further discovered other pieces of plastic as well.
Now, as far as these return trips on successive dates to 34 Fairview Road.
And so there you go, Nikki. Pieces recovered on February 3rd. That explains pieces labeled on February 3rd. Now, I can't remember, like I said, I don't remember if the pieces found on the 29th that afternoon, if they were labeled the 29th, or if, they ended up bagged on the 23rd or on the 3rd and labeled the 3rd. I don't specifically remember that. But this explains the February 3rd labels. So they haven't with Trooper Proctor yet. I don't remember from the technician that put them together what they were labeled, because that was long and boring. There were a lot of labels with a lot of dates. So they eventually were combined in order to put things together. But remember, the evidence bags of the lens, there were multiple, and we went through all the labels, all the dates, all the signatures, and it just went on and on and on and on. So, and I don't remember the dates on them, frankly. The jury gets to see them, though. So we'll see.
What was the reasoning behind that, or what was sort of the plan in reference to why were there so many different dates that you returned to 34 Fairview Road with other troopers?
So after the 29th, it was close to 2 feet of snow that had fallen. And in the days and weeks that had followed, the temperatures ranged from 30 degrees up to 60 degrees. And there was about a half a dozen days mixed in of heavy rain. So as the snow started to melt, more evidence started to present itself.
So there were items that you recovered on the 3rd, and then items you recovered on successive dates that weren't visible or you didn't see on the 3rd, correct?
Correct.
Now, if I could, keeping you on February 3rd, you mentioned that there was a Trooper Evan Brent that was present with you during the search on that day as well.
Yes.
Now, in addition to going to 34 Fairview Road, where else did yourself and Trooper Brent go on that particular day?
We traveled to One Meadows Ave, Mr. O'Keefe's residence.
And is that the first time that you had been to One Meadows Ave, Mr. O'Keefe's residence?
Yes.
Now, with respect to that residence, why is it that you and Trooper Brent went there on February 3rd?
We wanted to document Mr. O'Keefe's vehicle to show that there's no damage to it, as well as the garage doors.
And why did you want to document that?
During the review of Mr. O'Keefe's ring video, particularly the one above the garage that displays the driveway, on the 29th at approximately 5:07 a.m., Ms. Reed's pulling her vehicle out of the garage door, backing up towards Mr. O'Keefe's vehicle, and comes extremely close, if not slightly hitting the vehicle. So we want to at least go document that there was no damage to Mr. O'Keefe's car.
And Your Honor, with the court's permission, if I could publish that for the jury as far as what's been marked as Exhibit 6, video 153.
Okay.
All right, and we've seen this before.
Trooper Proctor, with regard to this ring video, how was this obtained, if you know?
So we first observed it through Mr. O'Keefe's cell phone on the Ring app, and then I wrote a search warrant for Ring itself.
And as far as the videos that you received from Ring, did they match
Wait, so they did see this one locally and then subpoenaed it. So that tells me this one wasn't erased. But we, other than the opening argument for the motion, we haven't really heard from Yannetti today. Only Jackson. So
What was on the, or what was viewable being the Ring app on Mr. O'Keefe's cell?
The videos on Mr. O'Keefe's app, yes, it was what Ring produced, matched.
So as far as any videos that were present that you received pursuant.
And that's what he just said, Nikki. But in the past, we've speculated that the reason they subpoenaed this one was maybe there had been evidence tampering. But him saying it was viewed on John's phone tells me it wasn't evidence tampering. So that's the reason I just brought it up, confirming that it was viewed like that.
Pursuant to the search warrant for any videos that were not present, that was consistent with what you observed on Mr. O'Keefe's app on his phone.
Yes.
Now, Ms. Gilman, if you could press play through here.
And once again, there is no broken glass right there, or plastic, I should say, lens. Nothing behind John's car.
Now, Trooper Proctor, with regard to this video, you've seen this before, is that correct?
Yes.
Now, the point from this video, are you able to discern who the operator of that vehicle is?
Based off the attire, Ms. Reed driving.
Now, with respect to when that vehicle, the defendant's vehicle, if you could, there's a laser pointer out there in front of you on the desk. If you could, I would just ask you to draw the jury's attention to what many vehicles you observed in this video and whose vehicles you believe them.
So right there, it's Mr. O'Keefe's vehicle and Ms. Reed's vehicle.
Now, as far as when those vehicles come close or come into contact with each other, as far as Mr. O'Keefe's vehicle is concerned, what, if anything, do you observe like on Mr. O'Keefe's vehicle at the time?
There's some snow. You can see on the back window here, the bumper and the windows here is starting to be covered in snow.
And as far as when that vehicle comes close to or makes contact with Mr. O'Keefe's vehicle, what, if anything, do you observe the snow come off of the car at that point?
I do not know.
Now, with reference to the back area of Mr. O'Keefe's vehicle, specifically in the area of the ground, as far as that area on the ground, what, if anything, did you observe in reference to the red pieces or 8 pieces of taillight or plastic or glass or anything in that area that you observed on the screen?
So this area here is, you can see the white snow. There's no red pieces of taillight, which would show up in the contrast of the white snow.
Just going to be running from there for a moment. Now, as far as the damage area that you were discussing previous that you observed in the January 29th in the Sally Port, February 1st in the Sally Port, and then the item that was just marked as evidence, what, if anything, do you observe in the right rear passenger side taillight area of the defense vehicle from this video?
You can see the inconsistent lighting. If you compare it to the left versus the right, there's a gap right there.
And that's it. As we discussed, yes, there's still red, but this tail light doesn't match this tail light. They look different. They look different. So, and that's it. If it's that light a tap, they're grazing bumpers because bumper height is roughly the same because of regulations. So they tap bumpers very lightly. It takes a lot more force, like the bumpers would have to compress in order for the light to break. Unless it's, transferred momentum, but I wouldn't see that happening because, there's the brake, that there it's not a continuous surface. You've got the plastic pieces of body or sheet metal or whatever, and then it just, to me, it wouldn't have made contact. So, and it's not flush, but I think the bumper protrudes considerably more. So I just don't see it breaking, especially since nothing has fallen. Absolutely nothing has fallen onto the ground.
What you observed from that video, does that appear to be consistent with what you observed on January 29th at Kent Police Department, February 1st, and in the item of evidence that was just one?
Yes.
Okay. Ms. Cummins, you can take that down. Mr. Ross, we can have the lights back on. Thank you. Now, sir, you proceeded to One Meadows Ave for the first time on February 3rd. Is that correct?
Correct.
And Trooper Brandt from crime scene was with you and took some photographs. Is that correct?
Yes.
May I approach?
Yes.
Trooper, I'm showing you a set of 10 photographs. You those look up when you're finished.
These look like the stills taken from the ring, I think. From what I could see.
Trooper, just generally speaking, do you recognize what's depicted in those photographs?
Yes.
And what do you recognize them to?
The first picture is the front door of Mr. O'Keefe's house, and it's also Mr. O'Keefe's Chevy Traverse.
Okay,
And
never mind.
Yes.
I'm up to introduce and admit as the next 10 exhibit.
Okay.
Okay.
It's about damn time, isn't it? But the problem with that, though, Nikki, is no plastic seen on top of the snow right after the defense might be alleging it broke, as opposed to no plastic seen at 34 Fairview after it's been snowing on top of it for 6 hours. So you've got different variables in those. They're different equations. I wouldn't expect to see the plastic on top at 34 Fairview because you've got 6 hours of snow. You've got 6 inches of snow roughly that have fallen in between. Whereas in that video, in the ring video, it's instantaneous. She hasn't even pulled out of the driveway yet, so there isn't enough snow to cover it. Not enough snow has fallen to cover it. It just isn't there. Just isn't there. But that's the thing. It's been snowing since midnight. Karen, like, we're arguing her backing into Johnny's vehicle isn't what broke the taillight, because if that broke the taillight, you'd expect the taillight pieces to fall right on top of the snow. And yes, that's at 5 a.m. They arrive on scene at 34 Fairview at 6 a.m. And assuming John was hit at 5:30, that's 6 inches of snow that has fallen on top of the ground. And it's the thing. I don't know if you live somewhere that snows. We have people that never see snow. I'm here in Utah. You know, my house can get 1.5 feet of snow, and a mile away gets 2 inches. We've heard the wind is blowing. He lives on the other side of Canton. They're different elevations. It just, snow is weird. Snow is weird. We have video of 34 Fairview, and yeah, it's only an hour later, but there's a lot more snow at 34 Fairview than what we appear to see at John's house. But that also could just be a matter of perspective, because the ring camera we're viewing from a top-down angle, and it's dark, so we're not seeing the shadows completely. So that might be several inches of snow, and it's just appearing that it's only an inch or two, just because of perspective. Whereas at 34 Fairview, we have the dash cam, and we have the eyewitness testimony, and we have photos, and we have a lot of evidence that it's roughly 6 inches of snow. And it just, there's so many variables. And Dante lives in Utah as well, and yeah, as I've said, my house, I have on at least 3 occasions had over 3 feet of snow overnight. The airport, the all-time one-day record, I think, is like 11 inches. That's a difference of 350 feet elevation. Now, because the Great Salt Lake, we've been in a massive drought, and I'm convinced that Farmington Bay is the part of the Great Salt Lake that provides lake effect to my house. And it's been dry. Antelope Island has been a peninsula for too long. I think they reported it's finally an island again, but only just. But so the lake effect, instead, I haven't seen static in here recently, but it's been slamming him in the Ochre Mountains. It still hits the Cottonwood Canyons real hard. And I realize Utah, we have mountains. Our topography plays a huge part in our snow, whereas Canton is relatively flat. Although Fairview, there's like a 60-foot elevation change between Crestview and can't remember the other cross street. But either way, the top and bottom of Fairview, according to Google Maps, there's about a 60-foot elevation change. But like I said, we have friends out mouth of the Cottonwood Canyon, so not even in the canyons. There have been times where we've had an inch of snow, they've had 2 feet. As a kid, I went to elementary school closer to downtown, so down the hill, I'd leave for school and think, why the fuck aren't we having a snow day? But either way, it's going to be a fun day because we've got 18 inches of snow. Get down the hill, there's 2 inches. It's just snow is weird that way. And it's Surrender Monkey, my brother's corgi, is funny in snow. So yeah, it's just, that's it, microclimates. So, but once again, as I said, it could just be the camera's perspective. The ring camera is higher up, so it's harder to tell how deep the snow is. Either way, we do know it's 6 inches of snow at 34 Fairview, roughly, 4 inches, 6 inches, whatever. That's enough to bury evidence. Whereas in the instant it might have broken, it would be on top of the snow, however much has fallen. So it just, to me, it wasn't broken in that collision. It was broken at 34 Fairview hours earlier in order to put it all the way at the bottom. So
It's 5:45 to 5:57.
Thank you.
And Your Honor, with the court's permission, if I could just have permission to publish just a few of those photos for the jury.
Okay.
and it also, even if ignoring the snow, none of the lens was found at 34 Fairview. None of it was found at 34 Fairview. It was, at the O'Keefe residence. It wasn't found in the driveway. It was only found at 34 Fairview.
Stillman, if I could have photograph 7752. Mr. Proctor, do you recognize what's up on the screen? It's not marked as exhibit 546.
Yes, Mr. O'Keefe's Chevy Traverse vehicle.
And with respect to this particular foreground here, if you could describe to the jury what we're looking at there.
So that is Mr. O'Keefe's driveway. You see 2 garage doors there that lead into the house. And above those garage doors is the ring camera.
Now, with respect to the rear of Mr. O'Keefe's vehicle,
You're pushing your lot.
viewing a video from exhibit 6 from the ring video, video number 153. If you could, using that laser pointer, direct jury's attention to where it is on this vehicle that's the contact, if any, between this vehicle and Mr. O'Keefe's.
It would have been in this general area here.
As far as your observations on that date,
What's the, hold on. Okay.
Our swamp cooler isn't swamping. It's hot. It's hot. We only had to turn it on like 3 days ago for the first time this year. And the water pump isn't turning on. And it's frustrating. And they could, and I don't know. I don't know if they're, well, I mean, from their assertions earlier today, it's not their experts, it's the Fed's experts. And did the Feds have the experts look at that, or did they try to determine if it could, have been from striking a 6'2" well-built man? I just, I don't know. I thought this would be a shorter sidebar, but yeah. Looks like it's almost done though, so I just hate scrolling, especially when it gives me white screen. And
You are
Oof.
unmuted.
Sure, but when you were in the driveway of Mr. O'Keefe's residence on February 3rd, 2022, you had occasion to make observations of Mr. O'Keefe's vehicle, is that correct?
Correct.
And what, if any, damage did you observe to the driver's side rear area of the vehicle?
I didn't observe any significant damage or any damage.
As far as the entirety of the vehicle, that was all photographed on that day by Trooper Frank, is that correct?
Yes,
And memorialized in those photographs that were just sent to you, is that correct?
correct.
As far as your observations on that day or in those photographs, what, if any, damage did you observe to Mr. O'Keefe's vehicle?
I did not observe any damage.
And Dr. John?
Yes.
So there's another 8 photographs that I placed before you. Have you had a chance to review those?
Yes, sir.
And do you recognize what's depicted in those 8 photographs?
Yes.
And what do you recognize those to be?
Taylor, you'll be glad to know we've had Chloe in the chat. I'm not going through puberty again. I just need a drink, apparently. But we have had Chloe in the chat on 2 separate occasions. And Chloe assures us that she's enjoying her time on the farm in Vermont.
More photographs of Mr. O'Keefe's vehicle as well as the garage doors.
Madam Mayor, approach.
Yes.
I want to see you introducing the next case exhibit.
No objection.
I don't know that Chloe would have standing either. And that would be a problem. Chloe's owner might have standing, but
It's 555 and 561.
Thank you.
Your Honor, with the court's permission, if I could publish just a few of those to the jury as well.
Okay.
Ms. Gilman, if I could have. Photograph 7779. And Trooper, do you recognize what's depicted on the screen now? It's 559.
Yes.
And if you could describe to the jury what we're looking at in 559.
The rear bumper area of Mr. O'Keefe's vehicle,
That's on the driver's side or passenger side?
the driver's side.
And what, if any, damage did you observe in that area of the vehicle on February 3rd when you were there?
No damage.
except Grey Duck, you count this one here and the spare in my closet, I've got 3. So I've got 50% more standing than you, if you look at it that way.
With respect, Ms. Newman, if I could have photograph 7780, that's my answer. And sir, do you recognize what's up on the screen and what's now been marked as exhibit 560?
Yes, those are the 2 garage doors of Mr. O'Keefe's house.
And what's contained up on that screen, is that a fair and accurate portrayal of what you observed in Mr. O'Keefe's garage doors on February 3rd?
Yes.
And with respect to those garage doors, what, if any, damage did you note or observe on those garage doors at any point when you were there on February?
I did not observe any damage to the garage doors.
Ms. Gilman, you can take that down. Now, Trooper Proctor, subsequent dates following February 3rd, specifically February 8th, 11th, and 18th. Did you have occasion to return to 34 Fairview Road on those days?
I did.
And you had mentioned a little bit about sort of changes in the weather. What, if anything, sort of evolved as far as the weather was concerned between the dates of February 3rd when you were there and February 8th, 11th, and 18th?
Yeah, as I mentioned, the weather pattern had kind of fluctuated from 30 degrees up to 60 degrees with a handful of days of heavy rain mixed in. So that caused a lot of snow to melt as well.
And with respect to each of those respective days of February 8th, 11th, and 18th, what, if anything, did you observe or recover, you and the other troopers that were present on those days?
Yeah, there's further evidence that was originally buried under the snow because of the warm temperature and the rain and the snow melting kind of revealed itself. More pieces of plastic clearing red.
Now, with respect to the residents at 34 Fairview Road, each of these times that you were at the residence, including February 3rd, where in relation to the house were these items observed and recovered by you and the other troopers on those respective days?
So if you're looking at 34 Fairview looking at the front of the house, it's to the left side of the property, between like the flagpole and kind of the fire hydrant, that general area, the front and left of the property.
Now, with regard to these three subsequent dates, as far as February 8th, 11th, and 18th, these items that were observed and recovered on those dates, where were they in relation to the roadway? Where were they in relation to the hydrant, the flagpole, other sort of markers in the
His tie could have been bought at the Durham University campus store. Just those colors are Durham University.
I don't specifically remember exactly if they were around the flagpole, because the CERT team had came and shoveled an area around. So,
And by the way, you know what that means. If he's wearing Durham University colors, it means conspiracy.
that stuff had melted first because there was a lot less snow, and then they created more piles. But as far as the general area was by the flagpole and fire hydrant, it wasn't like on the other side of the property. It was in that general area.
And just with respect to those items, were they generally found, or were they specifically found either on the grass or the roadway area?
Grass.
Asphalt or grass is basically what
I'm sorry, grass area.
And with regard to each of those items that were recovered on those three successive dates, as far as February 8th, 11th, and 18th, did you bring
I'm
those
in
items
on
to
it.
the report today as well?
I did.
Yeah, Coach Ron.
Yes.
Oh,
You recognize that
another
bag,
I
sir?
do.
When you recognize that,
unboxing.
Andy?
It's an evidence bag containing 3 smaller evidence bags.
And with the court's permission, if you could.
So this one's open, and containing 3 smaller evidence bags. So it's going to be the same one containing the lens fragments that Sergeant Buchanan did last week.
Hold on a second.
Thank you.
I apologize.
Go ahead.
With the court's permission, may the witness remove the 3 smaller bags from the large bag?
Yes.
Pretty much. And Pete put on his gloves. Look at it as ASMR. I'm sure there are some psychos out there that enjoy that sound and, actually seek out videos of it. But not me.
Trooper, if I could just, in succession, if I could ask you to please open the bag with respect to February 8th first. And before you do that, I apologize. With respect to that bag, what, if any, indication is there as to the contents there?
It says taillight, 1 large piece of plastic, color red, 1 small piece of red plastic, and 1 piece of black plastic, located 34 Fairview Road, front lawn, left side.
Thank you, sir. If you could please remove those. Thank you, sir. You can place those back in the bag.
And you can see the little evidence tags on each of those pieces. And remember, the dates on these bags are going to be the date that they were put in these bags. There'll be a chain of custody, because remember, the evidence geek, the lab geek, did combine bags because she labeled each piece based on the bag number that they came to her in, and gave each a sub number as well. But in order to fit everything together, she had to combine them because, just because they came in one bag didn't mean they didn't fit with a piece from a different bag. So, this is labeled February 8th. If another bag is labeled if they're all labeled February 8th, that's just when she bagged them after putting them together. But each piece that she assembled, each puzzle piece will have a label saying this is what it is, and there will be documentary evidence that it was found at this time and put in this bag and yada yada.
I'm also seeking to read the next exhibit.
No objection.
Exhibit 563.
And they do a lot of
Sir, if I can ask you
things. They
to retrieve the bag that's marked, retrieve the bag of items that were seized on February 11th. And if you could read to the jury what the description is in regards to that evidence bag.
So it's 2 on the 11th. This one is described as glass fragments.
ugh.
You can't tell how many pieces. It's been taped over. The second bag from the 11th says 3 pieces of clear plastic, 5 pieces of red plastic.
And with the court's permission, may the witness remove those items from the bag.
All right.
Small bag in here containing the glass. Cut that open as well.
I think that's sufficient.
All right, so Madam Clerk, are you moving to introduce it?
Yes.
Madam Clerk, any objection? We can go ahead and
I
open
want to
it.
object, but I don't know what's that.
Go ahead and open it.
Yes, Your Honor.
Defense saying if it's not open, we don't stipulate to shit.
All right. These items appear to be just further on sealed up and wrapped up and
Do you want him to open everyone, Mr. Jackson?
Yeah, approach.
Yes.
I can't step on.
No. I'm guessing this is going to turn into lunchtime.
All right, so
No,
go,
I
are you sure?
don't need a motion.
Or no.
No objection.
Is that a number of how many small pieces?
How many pieces are in there?
1, 2, 7.
The smaller bag will be 564.
Are you saying even Jackson is in on the conspiracy? Ooh, it goes deep.
Thank you.
The brown bag will be 564 and
Thank you.
containing 7 pieces.
Interpret, if you could, the other bag from the 11th, if you could open that up and remove those items.
And we're like, as I've said, I'm not downplaying it. It's so long as it's documented, and like I said, we don't get to see all of the documentation, but so long as it's documented, how it's packaged now isn't necessarily how it's been packaged all the way through. So
could put those back in that. Your Honor, call motion to introduce in the minutes the next exhibit.
The 565.
Lastly, sir, with regard to the fact from February 18th, again, if you could read to the jury what's indicated as far as the contents therein.
Several pieces of red and clear plastic.
Your Honor, with the court's permission, may the witness read
Yes.
the items.
And notice all the little individual stickers that indicates
Sir, if you could
all
turn those
the
items to the back.
individual pieces.
Your Honor, call motion to introduce the minutes of this exhibit.
No objection.
Exhibit 566.
Here's the original bag.
Now, Trooper, with regard to each of those items from February 8th, 10th, and 11th, excuse me, 8th, 11th, and 18th, those are all items that you recovered from the front lawn area of 34 Fairview Road, is that correct?
Correct.
And what was just displayed to the jury is that essentially the condition that they were in when you recovered them on those respective dates.
Yes.
Now, if I could turn your attention just briefly regarding the search warrants in regard to the ring video from Mr. O'Keefe's house. Was that one search warrant or more than one search warrant that you did in respect to those ring videos?
There was a second search warrant for the ring videos for Mr. O'Keefe's house.
And if you recall, what was the general time frame that was asked for in that warrant as far as from what date to what date?
The second one, I believe, was
They absolutely do Grey Duck because it's her job to label it. So to make it an exhibit, she puts the sticker on it. So that's what she's doing.
January 30th to the 3rd or the 4th, I believe.
Was the first one essentially from the 24th to the 29th?
Yes.
Now, with respect to the video that you received in regard to the first search warrant to Ring, what kind of information did you receive from Ring as far as what beyond sort of the video itself? What, if any, other information did you receive as far as accounts or activity or anything like that?
It was just confirming that the user account was under Mr. O'Keefe's email.
Nope.
And
It's the court reporter. It's the court reporter is the record keeper of the trial, and that's exhibits as well. So that's her job.
And there was an Excel file where you kind of have to transcribe. So that each video has about a 17-digit number associated with it, unique identifier. You take that 17-digit number and you got to convert it using these Excel files to get the date and time.
Now, with respect to what you received pursuant to the search warrant from Ring, was there any kind of activity log? What I mean by that, what, if any, information did you receive as far as what sort of devices or how many different devices were able to access that footage?
Yeah, I wasn't able to obtain
That she is, Casey.
activity log of who was using the device, what device was accessing the system. Something, if someone logged in, was not provided with any record of who was logging in on what day or time.
Now, are you familiar with the term, this as far as videos are concerned, or electronic devices, what's referred to as a digital footprint?
Yes.
Now, with respect to some of these, or the Ring videos in totality that you received and that you also viewed pursuant to the app on Mr. O'Keefe's phone, were there certain time periods where you would have expected to see video in which there was no?
Yes.
And can you describe for the jury sort of when those time periods were?
So the Ring camera above Mr. O'Keefe's garage, pretty sensitive. So
They absolutely do, Linz. It's evidence. It's an exhibit. There's as long as it's admitted as an exhibit, they get to examine it. In some trials, you'll see them, hand the gun to the jury and pass it around. and it's there. You know, they get to handle it in the jury box as the witness is testifying. You know, it's in its evidence bag, but they get to handle it there. And so yeah, they'll get to see it. And Nikki, I have not been following the Young Thug trial. I've been aware of it. I've seen, like, primarily, I think it's been lawyer, Peter Tragos, covering the interesting bits. But that's just too big, too cumbersome, too many co-defendants. I just can't keep up with it. There's too much. If I were doing a secondary trial right now to follow, I'd be doing Rise of the Moors in Massachusetts, or the Owens versus Eckert, I guess, went to trial today. Law Talk with Mike streamed that, but yeah,
It does not have Miss Reed arriving back at Mr. O'Keefe's house around 12:34 a.m. is approximately was when she should have arrived. The only video, there's a gap from approximately 11:45 p.m. on the 28th to about 5:07 a.m. on the 29th when Miss Reed's backing out. It never has her pulling into the garage. And there's also a second video of Miss Roberts, Miss McCabe, and Miss Reed looking at the broken taillight in the morning.
With any follow,
or at least an expected video, because it would have triggered because we know the Lexus was parked there. We have testimony from Carrie Roberts and Jen McCabe that they examined the broken taillight there, but it presumably would have had to trigger the camera. Based on all evidence, it would have triggered the camera, but it's not there. Sounds like evidence tampering to me. But, as I said, I thought the backing out video was part of the evidence tampering, but I was incorrect.
Follow-up or inquiry did you make of Ring in regard to those missing videos?
I've inquired several different times as far as if the video is deleted, is there some type of a record?
That was his inquiry. But next question, I'll allow that.
Now, as far as that term that you used before, as far as a digital imprint, can you explain to the jury what you understand that term means?
Essentially, digital footprint is if a video is created, it's going to leave some type of a record in the archives.
And what, if any, information did you receive from Ring as far as their videos system is concerned in regard to the digital footprint?
Not what anybody told you, but what you received.
That if a video is deleted.
The objection sustained. We're going to strike that.
Upon your further inquiry of Ring, were you ever able to obtain any video from those specific sections where you anticipated video would be?
No.
That's interesting, Darcy. And I don't, I seem to remember, I think it was in the Young Thug trial, lawyers being arrested earlier as well. And to me, that's fuckery. You arrest the lawyers, you're probably looking at major due process violations. So the hearsay is that they were told it was deleted. So that's out of court statement made for the truth of the matter asserted. It's the Ring representative told us it was deleted. You need to get the Ring person. They can testify. Yeah, it's kept in the ordinary course of business and it was deleted. So that's what it would take to get that in. Of course, can't unring a bell. It's struck. The jury still heard it. Just like, all of Jackson's snide comments, his sustained objections, the jury still hears them. So, yeah. But, yeah, Nikki, it's lawyer, that's Peter Tragos and Papa Tragos. Can't remember his name, but
Now, sir, if I could turn your attention to 24. Do you recall that date?
I do not, sir.
At some point over the course of your investigation, were you made aware of forensic evidence in relation to the taillight housing that was introduced earlier as an exhibit?
Yes.
And with respect to that, at some point, did you have occasion to meet with a Sergeant Brian Gallerani of the Needham Police Department?
Yes.
And where was that?
In the DA's office.
And
so it's confirmed Vince doesn't like Irish guys, but he likes Greek guys.
if anyone else
Also, behave.
Involved in this investigation, as far as yourself, was Sergeant Mechanic with you there as well?
Yes.
And what, if anything, did Sergeant Gallerani do with respect to yourself and Sergeant Mechanic on that date in January of 2024?
Sergeant Mechanic and I voluntarily provided our DNA for comparison testing.
And again, taking me to my next point, that was a voluntary decision that both you and Sergeant Mechanic made as far as availing yourself or availing of that particular testing.
Correct.
And as far as the testing or this, how that was, or can you describe to the jury sort of how that sample was collected or how it was conducted?
Essentially, it's just a swab of the mouth under the tongue with it's basically just like a little pad on a stick, and he gets swabbed, and that's how the DNA or saliva is collected.
And as far as those samples that were collected from both yourself and Sergeant Mechanic on that particular day.
Are you saying that's how the pig DNA ended up on John's sleeve? It wasn't from eating pork chops?
Where did they go from there as far as you know?
It was my understanding, went to the Bodie lab.
Of course, John being a police officer too, pig jokes work both ways.
Virginia.
I'm sorry, but I should have asked just prior to that, as far as when they left from the room that you were in with Sergeant Gallerani, did you take those swabs, or did Sergeant Gallerani take those swabs, or where did they go?
Sergeant Gallerani took possession of those items.
Thank you. Now, sir, with reference, over the course of your investigation, you interviewed a number of different witnesses, correct?
Yes.
And from the witnesses that you, were there witness interviews that were conducted outside of your presence in the sense that you weren't there for those particular witness interviews?
Yes.
And each of the interviews that you're aware of, whether they were conducted by you or outside of your presence, were done, with the exception of the current, done with more than one trooper present, correct?
Correct.
Now, with respect to those witness interviews that you were present for, from the witnesses that you spoke with, along with other troopers that were present with you, who, if any of those witnesses, had you met, or did you know prior to the interview that you conducted?
Yeah, so all the witnesses that I interviewed, the only individuals that I know or met prior to this investigation was Julie and Chris Albert and Colin Albert.
And how is it that you knew Julie Albert, Chris?
None of whom were on the scene with John O'Keefe. Colin was never in the same place as John O'Keefe at the same time that day. Chris and Julie Albert parted ways with John O'Keefe at the waterfall. They did not go to the brother's house, 34 Fairview. And notice he said, the only people who were interviewed who I knew were Chris, Julie, and Colin. I'm guessing he's about to say other people interviewed him. Well, interviewed them, and each of those interviews had at least two troopers or two officers or whoever.
For Albert and Colin.
So my sister, Courtney, her friend growing up, Jillian. Jillian's sister's Julie. My sister got to know Julie Albert, Julie Daniels, her maiden name, through her friend Jillian. Julie married Chris Albert. So my sister got to know Chris through Jillian and Julie. And then years down the road, my sister had Julie babysit my nephew. Julie would come from time to time and pick up my nephew from school. So that's how they kind of became friendly. And on occasion, they would be over at my sister's house, or at my parents' backyard, Julie and Chris and their kid Colin, and I would happen to be there.
Let me ask it this way, as far as, where did you grow up?
Canton.
And did you graduate from Canton High School?
Yes.
And as far as any of the witnesses that you interviewed, even the Alberts that you were just talking about, Christopher, Julie, and Colin Albert, were they around the same ages as you or went to high school with you at the same time?
No.
How much older than you would Julie and Chris Albert?
At least 10 years.
And as far as Colin Albert, what's the age difference between yourself and him?
At least 20.
Fair to say around this time of January 2022, do you know how old Colin was or what level of school he was at that point?
Senior high school, I believe.
Is that something that
17.
you learned through this investigation or something that you knew independently?
Something I learned through this investigation.
Now, obviously, you grew up in Canton and your sister did as well.
Yes,
And your sister's name is Courtney, is that correct?
correct.
And what is the age difference between yourself and your sister?
She's 2 years older than me.
And how close are you and your sister?
She's probably one of my best friends. We talk about 5-6 times a day about anything and everything, as far as like mostly our children.
I don't talk to my sister 5 or 6 times a week usually.
And she has, how many children does your sister have?
You got 2,
And about how old are they?
10 and 7.
And you have children as well?
I do.
And how old are they?
2 and 4.
Now, with respect to the conversation that you have with your sister about 5 or 6 times a day, how do you have those conversations? Is it via voice call or in person or text or if you know?
Everything, FaceTime, phone calls, text messages. We're always kind of keeping each other up to date on mainly our kids.
Now, as far as Julie and Christopher Alberts, when did you interview them in relation to this incident?
Sometime in February. I'd have to look at my report for the exact date.
Sometime in, say, early to mid-February?
Yes.
And with respect to them, who, if anyone else, was present with you when you interviewed?
Sergeant Buchanan.
And do you recall where the interview took place?
Yes, I was at their home.
Now, prior to this date that you went over to interview Christopher and Julie Albert, had you ever been over to that house before?
No.
Had you ever been over to?
Okay, so he
any home?
did interview Chris and Julie, but once again, with Sergeant Buchanan.
Where Christopher and Julie Albert had resided then or previously prior to that date?
No.
Had Christopher or Julie Albert, to your knowledge, ever been over to your house?
No.
Now, with respect to Christopher and Julie Albert and Colin Albert, will throw him in there as well. How would you sort of describe your relationship with them prior to January 29th, 2022?
I classified as acquaintances.
All right, Mr. Lally, why don't we take our luncheon break?
Whew. About time.
You are muted.
Carrie Roberts,
Okay, thank you, Ron.
but the testimony was from Jen McCabe. So Jen McCabe testified that Carrie Roberts said Karen was a babysitter with benefits. And it was the defense that opened the door to that. So, yeah. Ooh. All right, are we getting instruction before lunch? Or are they just zoomed in on Karen for no reason? Either way, we're going to keep moving on. Vince, I've seen that, his week-long series attacking Jen McCabe, and that's gross. I've seen his thumbnails. I haven't watched, but that's gross. It really is.
Okay.
So, and I mean, I think the jury had left the room, but I got tired of waiting for her to break character.
You are unmuted.
So, because we need to get through this. It's a long week. Yeah, it's just, it's gross.
Goes back to session, you may be seated.
Bring the witness in, please.
Be mindful to step up and just remember your phone.
So jurors, before we begin, Mr. Lally, as you approach the podium there, when I tell you that I strike something from the record, I know I've told you before, that means you're not to consider it, okay?
They still heard it.
Go ahead, Mr. Lally.
Thank you. Good afternoon, sir.
Good afternoon, sir.
So, with reference to, before we broke, we were talking a bit about,
So a good caprese sandwich is delicious. My absolute favorite. Like, this is my favorite meal. It's the best thing to eat. You take it's an open sandwich, you know. You take a slice of German rye bread, proper German rye. I put butter on it. My family, some put butter, some put mayo, some put mustard. I don't like mustard. I put butter. The Dutch store here in Salt Lake has this beautiful garlic salami. So put some garlic salami on it. Put some Schinkenwurst on it. Havarti cheese. Fresh sliced tomatoes straight from the garden. And salt and pepper. And that is absolute heaven.
Julie Albert and Christopher Albert, correct?
Yes.
And how would you describe your relationship, if any, between Julie Albert and Christopher Albert prior to January 29, 2020?
Loose acquaintances.
People that you knew through your sister, is that correct?
Correct.
Now, with reference to the occasions that you had said where you may have been at the same place at the same time at a family function or something like that, over what period of time are we talking about, and about how many different instances of that occurred over those years?
Like I mentioned, they had never been to my house. So it was either at my sister's home or at my parents' house. Over the course of maybe 10 years, I might have been at the same function half a dozen times.
And at those times that you were at the same function a half a dozen times or so, how much interaction did you have with either?
So, Linz, we have a few very good German bakeries here in Salt Lake. Fosen's is very good. My Oma would disagree, but she's cranky. Funny enough, the Russian store sells really good German bread. But yeah, Fosen's is really good. I do have a good recipe. It's just, it takes so long to make good homemade German rye bread. Like, between all the kneading and resting, and it's a 10-hour process.
Christopher Albert or Julie Albert, or even Colin Albert at those functions?
Just casual conversation, be cordial, and just typical conversations, you know, how's it going, things of that nature.
Now, with reference to these experiences or relationships, or lack thereof, that you had with Christopher and Julie Albert, what, if any, conversations did you have with your supervisors, as far as superior officers within your unit, in regard to
I explained the connection with my sister to the Albert family.
And who did you explain that to?
That would be Sergeant Mechanic, Lieutenant Fanning, and Detective Lieutenant Tully.
All right, Trooper, I'm going to ask you to keep your voice up, maybe approach the microphone a little closer.
And just with respect to those disclosures, what specifically did you tell either Sergeant Mechanic or Lieutenant?
Vince, what did you do? Vince. My hand wasn't on the mouse. It wasn't on the keyboard. This was a Vince problem. So everyone yell at Vince.
What any conversations did you have with your supervisors as far as superior?
Damn, I'm good. Damn, I'm good. Look how close I got it. We're like in the same paragraph. So, of course, it helps that it's right after lunch. So,
Your officers within your unit in regard to.
I explained the connection with my sister to the Albert family.
And who did you explain that to?
yeah,
That would
Vince.
be Sergeant Mechanic, Lieutenant Fanning, and Detective Lieutenant Tully.
All right, Trooper, I'm going to ask you to keep your voice up, maybe approach the microphone a little closer.
And just with respect to those disclosures, what specifically did you tell either Sergeant Mechanic, Lieutenant Fanning, or Lieutenant Tully?
Oh,
Basically, that the Alberts are my sister's friends. That I've been at some functions with them, and the only kind of connection with the Albert family is through my sister.
And just when you say the Alberts, as far as
and remember, at this time, they're not witnesses. They're very peripheral. The conspiracy has not been concocted yet. So at this point, Colin's not a witness. The Alberts, just peripheral. It's just the conspiracy doesn't exist yet.
who specifically within the Alberts are you talking about that had a friendship with your sister?
Julie, Chris, and their son Colin.
Now, with regard to the investigation that you were conducting and the interviews that you conducted, what, if any, impact did those relationships have with regard to your interviews of them specifically, or the investigation in total?
Zero. Absolutely zero impact on this investigation.
Your Honor, may I approach?
Yes.
Yes. I assume this is his report, or I don't know. Exactly. And that's really one of the most ridiculous parts is,
Sir, I'm showing you a document. Do you recognize that?
Yes.
And what do you recognize it to be?
It's a
So Vince, you mean you like every moment they show John or Paul O'Keefe on camera, since he's always staring down Karen?
text message thread labeled Proctor Friends.
Now, over the course of your investigation, over the course of this case, are you aware that there were iCloud data that was obtained from your personal cell phone?
Yes.
Ooh,
And different
this could be the fun bit. We might be going to Scunthorpe now.
text strings from that iCloud data from your personal cell phone, correct?
Correct.
And with respect to what has just been placed before you, is that an excerpt or a piece from those particular messages?
It is.
And from the front page of that, can you tell the jury who are sort of the participants in this particular text communication?
The several numbers that aren't identified, the three that are under kind of nicknames me and my buddies have for each other.
And generally speaking, just as far as the participants in this text communication, who are these people to you, and how do you know them? How long have you known them? Who are?
The members on this text thread are close friends from junior high, first grade even.
Dante, you're from Utah. You're not supposed to get that reference.
So people you've known for years, is that correct?
Correct.
And do each of them live, or do any of them live within the general area at this time?
Some of them do, yes.
And so when some of them do, some of them do not, is that correct?
Correct.
And the ones that do not, how far away do they live?
As far away as Tennessee.
Now, with reference to this, there's an indication as far as the first message sent or last message sent.
Or Dante, was that yup about Paul O'Keefe staring down Karen Reed and not confirmation that this is Scunthorpe. So you're not supposed to spoil it, Casey. But I mean, I did spend a year in the north of England for grad school, so there is that.
From this particular text chain, correct?
Sorry, repeat the question, please.
Sort of towards the middle of the first page. I'm directing your attention to that area. Is there any indication as far as the first message sent and the last message sent with respect to this text chain?
On the first page, yes.
And what is indicated as far as the first message and the last message?
The first message is, I need to brandish a gun more often. The last is, Chip, name of that BPD cop.
No, I'm sorry, sir. If I could direct your attention to the first page in this packet, page 2527, you see conversation details. I'm sorry, may I go?
And yet, Grey Duck, the conspiracy is that Wyoming's not a real place, yet that's where I've spent at least half of my family vacations. So,
Yes.
If I could direct your attention to the rights.
Okay.
You see what I was talking about now?
I do, sir.
And from that area labeled conversation details, there's a first message sent, date and time, and a last message sent, date and time, correct?
Yes.
What is the first message sent, date and time?
It's 10/18 of 2021 at 8:48 a.m. The last message sent is 8/31, 2022 at 11:19 p.m.
Is there also within that conversation details an indication as far as the number of messages over that time frame within this communication?
There is.
And what does it list for number of messages?
It's 38,707.
Oof.
It's fair to say the packet that you have before you does not contain all 38,707 messages, correct?
That's correct.
The first message that you had, I believe, alluded to in reference to the first one listed within this communication. What date and time is that?
That was January 29th, 2022 at 10:36 p.m.
And who is that message from?
My friend who lives in Tennessee.
And what, if anything, did he send to the group?
I need to brandish a gun more often.
And if you know, what is that in reference to?
He just recently moved to Tennessee, and he was kind of, I think, making a joke as kind of.
Tennessee is a scary place. Like, did he move to Memphis?
The lifestyle down there where guns are more prominent or more common to be carried around there. So I interpreted that as a joke in that nature.
So, Sinclair Reed, Edwin's calling you out.
And the next message, sir, from that same page, 2527.
The next one is, it's bold.
And is there a name associated with that number that's in these?
No,
Do you know who that person is?
I don't.
And the next message, sir,
Well,
from 1052.
Naven, it sounds like it's a group conversation, is what it sounded like to me. So, still a lot, but it's over a long period of time between a bunch of people. Still a lot, but yeah.
PM.
Chip, name of that BPD cop.
And Chip,
Memphis is the bad one, though, Anne, the dangerous one. Apparently, it all stems from the assassination of Martin Luther King. Like, that gave Memphis a bad reputation. It precipitated the white flight and increase in crime. Just that one absolutely terrible incident ruined the city.
who is that referring to, sir?
That is one of my nicknames I've had since maybe high school.
So a nickname that would be familiar amongst these group of friends in particular?
Yes.
And this time period when these text messages begin, sometime after 10:30 or 10:50 p.m. on January 29th, where are you and what are you doing in reference around that time period?
At this point in time, on the 29th, I'm home.
And that last text message, do you respond to that at approximately 10:53 p.m.?
Yes.
And what was your response?
John O'Keefe.
And the next message down from there, also at 10:53 p.m.?
Yes. He took custody of his sister's kids.
That's your response. There's another response above that. Is that correct?
Yes.
What does that say?
How old?
And you respond as far as he took custody of his sister's kids, correct?
Correct.
Skipping down a couple, do you see an entry at 10:53:49 p.m.?
Yes.
And that's from a 617 number. Is that correct?
Correct.
And what is the response there?
Oh man, that's rough.
And following that, do you respond to the earlier query as far as age?
I do.
And what did you say?
Mid 40s.
Now, the next message below that, as far as indication of mid 40s, what is that?
His age.
No, I understand that. I'm sorry. The next message underneath that, sir.
I'm sorry. It's a Facebook link.
And do you recall what that Facebook link is to?
It's to John O'Keefe.
And is that something you sent or one of your friends sent?
One of my friends sent.
And the next message below, turning to now page 2529 at the top there, what is the next message that's sent?
What's that? Don't have the book anymore.
And as far as the book, what did you understand that to be?
Maybe a motion.
Sure.
I think we've discussed during this trial how ugly I think Graceland is. Like, it just absolutely hideous architecture. Let's skip through Jesse Weber. Almost there. I'm guessing, but as I've said, I don't know. I am watching it the first time and only time here with you. I only knew about the naughty word because of Discord, but that's not a real spoiler. The long sidebar, and I'm guessing they must have yeeted the jury. And I mean, Vince, I'm sure she did, but there's already so much perjury in that they have to charge her. They absolutely do. She just, yeah. Oh, she's awful. Ugh. And what's weird about Laura Owens is, like,
You are
Get the witness
unmuted.
back, please.
I think she's just so insecure that she thinks she has to trap a man. But she doesn't. Like, she's moderately attractive, like, certainly not ugly. Certainly, her actions are ugly, but she's decently attractive. She's well off. She could get a lot of decent guys without trapping them. But she's so insecure that she makes all this shit up, and it's terrible.
Yes, sir.
And getting the witness back.
Proceed, John.
Yes.
Trooper, if I could direct you back to page 2529 with the net packet before you.
Well, that's it. It's either perjury or she's committed a different criminal offense in not reporting a death, since they were at least long enough into the term that she needed fetal death certificates. So, yeah, there's a crime one way or another.
And below that text stating what's that, I don't have the book anymore. You respond, is that correct?
Yes.
And what is it that you say there?
This one is a nightmare. Forget about the kids. That's awful.
And sir, if I could direct your attention again within that same packet to 2532. And there's a message there sent at 10:56 p.m. Is that correct?
Yes.
Who's that from?
A friend who lives in Tennessee.
And what does he say in that text?
I'm sure the owner of the house will receive some shit.
And you respond at 10:56 as well as 10:57.
Wow. His Tennessee friend must have a crystal ball. Surely the owner of the house is going to receive some shit. If only they knew. Oh.
Is that correct?
Correct.
And what is it that you respond?
My first response was nope. Homeowner is a Boston cop too.
And what, if anything, were you saying, or what was the purpose of that text in regard to the homeowner?
I was just letting him know that essentially Mr. O'Keefe is a Boston cop and the homeowner was a Boston cop as well.
Now, if I could turn your attention to 2533. And top of the page, sir, if you could read through that page as far as who's texting and what do they say?
Again, for my friend from Tennessee and myself, I hope not, but I can't see it. I responded with, she waffled him. I looked at his body at the hospital. He was banged up.
Waffled him.
Now, as far as the next text from a 781 number, what does that say?
Did he get beat up?
And you responded to that, is that correct?
I did.
The objection is sustained as to form.
What, if any, response did you provide to that?
Nope.
Objection. The objection was to form a question and answer.
I'll strike it.
Now, turning your attention to 2534. And from this page, sir, if you could again just read through as far as indicating to the jury who's speaking and what is being said.
From the start of the first text, so the owner of the house?
Yes.
So the owner of the house was a woman cop that beat him? That's what I initially thought after talking to Can paramedic. Then I saw the guy.
And those last two are your responses, is that correct?
Yes.
Now, the following text messages are from your friends, is that correct?
Yes.
What do they say?
Here, let's focus. What does she waffle to mean? What's the story? I responded, she hit him with her car.
And the she that you're referring to there, who is that?
Miss Reed.
And of course, none of this is evidence of her guilt. It's not evidence of her guilt. The conversation between Trooper Proctor and his friend in Tennessee are not evidence of Karen Reed's guilt. They're pretty much irrelevant, except it shows that, basically it's like this is his present sense impression. This is what he thought at this time. So it's not, it can't be offered for the truth of the matter that Karen Reed killed John O'Keefe, because, well, he wasn't there, so he didn't witness it. He's not, it can't be offered for the truth of the matter asserted about Karen having killed him. But I believe the reason these are being admitted is his present sense impression. It's showing that all the way back then, well before the conspiracy, like right out the gate, this is what he thought based on the evidence. She hit him with a car. The only thing the jury can read into that is that's what Trooper Proctor was thinking about at the time. So, and Dante, it doesn't. Just maybe makes him look bad, but my understanding is it makes Jackson look even worse. And it's just the conversation between him and his friend over text. And it's, like I said, I think it's just to show this is what he was thinking at the time. This is his working theory way back in the days immediately following. So,
Now turning your attention to the next page, 2535. Again, if you could start at the top of the page and read through that page and just indicate to the jury who is talking and what is being said.
Okay. My friend in Tennessee states, okay, that's fucked up. I respond, intentional or not. Then another response, gotcha. He was frozen in the driveway and she didn't see him, question mark. That's another animal we won't be able to prove. And then I respond, they arrived at the house together, gone to an argument.
I don't speak out loud or out of turn.
If the objection's overruled.
Your Honor,
But
if I can say this, there needs to be an identifier of who's.
I understand what you think the mix-up is. So, Mr. Lally, go back.
Thank you.
Sir, if you could please, again, start at the top of the page and just indicate.
No, just after the, gotcha, he was frozen in the driveway, correct, Mr. Jackson?
That's correct, Your Honor. Thank you.
I respond, that's another animal we won't be able to prove. I follow that up. They arrived at the house together, got into an argument. She was driving and left. 781 number responds with, what's the name of the Canton cop living in Canton, the other one involved.
And how do you respond to that, sir?
There's several other messages before I issue a response.
Objection again. Bottom of the page.
So it's not an objection, but Mr. Lally, why don't you point him?
So, sir, at the bottom of page 2535, you have a response. Is that correct?
Correct. Driving and left.
So Gray Duck, it's we don't know that the defense forced this. It's this is the prosecution. So presumably he offered it up to the prosecution. I don't know how he got it. I don't know how they got access to it. It's assuming it's his personal phone, I don't know how they got access to it. I really don't. But, you know, it really could be that Trooper Proctor's like, after the conspiracy started, Trooper Proctor's like, well, I have evidence that this was our working theory right from the start. And turns this over to Lally just to do it. And that could be it too, Naven, that by turning over his personal cell phone, it gives context to the nonsense they get off of his work phone or something like that. It's just, I don't know. Like I said, I'm watching this for the first time. So trying to piece it together with you.
Objection.
So it's going to be a matter you can address on cross.
There has to be some accuracy.
So I understand. So, Mr. Lally, why don't you go point for your witness?
May I approach, Your Honor?
Yes.
Mhm.
But the question is, how would they discover it unless it's from someone in a group conversation? Because I thought it sounded like it was a group conversation. I could have misinterpreted that. But how would they have discovered it? Because the defense wouldn't have been able to subpoena Trooper Proctor's personal phone. Work phone, probably. Personal phone, no. At least not without a reason.
Okay. It's a HTML link, whiteout / Proctor iCloud / group chat Feb 2022. So you point out.
Can I see what you have for a second, please?
Yeah, sure.
But even with subpoenas, the defense wasn't getting Trooper Proctor's personal phone. There's almost no way. And I mean, it's possible the Fed investigation, but once again, without something more. The feds couldn't have got his personal phone without him volunteering it. There's no way. There's no way there's reasonable suspicion. There's no link, no nexus for them to be able to successfully subpoena his phone. It would be quashed. His personal phone. So unless someone else on the other end supplied it or he offered it up, there's just no way. So I really think Lolly has a reason for this, but I don't know.
Mr. Lally, it's on there. Why don't you go show your witness? Why don't you just read it, Mr. Lally, and tell us who you attribute it to?
Plus, you know, Jackson's really trying to keep this out. If it's his evidence, why is he trying to keep it out so hard?
Sure. So, sir, what I'm asking you about is the bottom of page 2535, 2535. You indicated Biffton, correct?
Correct.
What did you mean by that?
That Miss Rita struck Mr. O'Keefe with her vehicle.
Now, sir, if I could direct your attention to page 2537.
I think she's confused.
Now, you see a response toward the bottom of the page from yourself, January 29, 2022 at 11:04 p.m.
Yes.
And can you?
But Vince, that's only if the prosecution gets it. That's only if the prosecution gets it. So the only way I see it coming in is if Trooper Proctor offered it, because the prosecution wouldn't be able to subpoena it. The defense wouldn't be able to successfully subpoena it. It's not coming in unless Trooper Proctor puts it in.
You read that response to the jury?
Yeah, but there'll be some serious charges brought on the girl.
And what did you mean by that, sir?
That throughout the course of the day, we had compelling evidence that Miss Reed struck Mr. O'Keefe with her vehicle.
And you have two responses from friends, same friends, at the bottom of that page, 2537. Is that correct?
That's correct.
And what are those responses?
He seems to be selective in what he's trying to keep out. But you are right. He is also trying to get a complete record who said what of what comes in.
Keep your voice up loud, please. Trooper Proctor, jurors can't hear you.
Yes, Your Honor. Number ending in 5051. Got to be. I can only imagine what internal affairs of the BPD are trying to get out there. The second response, same number. She hot at least.
And turning your attention to the next page, 2538, at the top, if you could just read a number series of responses from yourself, correct?
Yes, sir.
Read from those, sir.
Yep. So these came from me. From all accounts, he didn't do anything wrong. She's a whack job. CUNT.
Objection.
So don't spell it. You have to. So these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
Cunt. Yeah, she's a babe. Weird Fall River accent, though. No ass.
And sir, what is it that you were referring to there? Why would you text that?
These were, from all accounts, he didn't do anything wrong. Is talking about the homeowner, Mr. Albert. I had mentioned the compelling evidence against Miss Reed at this point indicated that Mr. Albert had nothing to do with Mr. O'Keefe's death. The rest of the unprofessional and regrettable comments are something I'm not proud of, and I shouldn't have wrote in a private or any type of setting.
So she's a babe, though, Fall River accent, and she's from Scunthorpe. Try to keep that word off the channel. YouTube. It wasn't me that said it. It was Trooper Proctor. But yeah, for those of you who don't know, you saw it up above. But Scunthorpe, real city in Lincolnshire, but you read between the lines of Scunthorpe and it's in there. But yeah, I don't know how he got it. my understanding was the embarrassing text messages were something like, I'd like to see her naked or something like that. And that was the whole reason they had to keep Trooper Proctor off the bench or off the witness stand. That was the whole reason. The defense was like, well, if the prosecution doesn't call him, we will. And it must have been the federal investigation then. Like I said, I don't know where they got it. I really don't. But it's so, and the thing is though, this shouldn't have been discoverable. His private phone, private texts with his friends shouldn't have been discoverable. So it being put into discovery, to me, there was fuckery. Someone engaged in fuckery in order to get it. So, and that's it. They feign indignation, but they insist he says it out loud. And it's like, he's a Boston cop. What kind of language do you expect him to use with his friends? It's how they speak. I mean, Jackson would be shocked the way my law school classmates spoke. Never me. Just my classmates, never me. And I went to the University of Utah for law school. It's our liberal law school in Utah, since the other one's BYU, but it's in Utah, for hell's sake. We used a lot worse language than that.
Sir, at some point, if I could turn your attention to page 2540.
No, because I think the federal investigation is corruption on the part of the feds. And it was instigated at the behest of Karen Reed, whether it was her dad, Yannetti, whoever, but I think it's corruption, and it was to try and monkey wrench this trial. But, Judge Cannoni has read the entire report from the federal investigation, has said, I don't get it. We still have probable cause. We're still going forward. I don't understand who you guys are claiming the real killer is. It's just not there. So.
There's a photograph that's shared within this text communication. Is that correct?
Yes, sir.
And does it indicate who shared that photograph? On the prior page, possible.
The number ending in 5051.
She had that Hank Hill ass.
And who is depicted in that photograph that was shared within the group text?
It's Miss Reed being escorted out of the State Police Milton Barracks.
And these are all from February 1st of 2022, around that time frame. Is that correct?
Yes.
Now, sir, if I could direct you to page 2543. And sir, if I could direct you to the top of the page and ask you to read through that page, indicating who's speaking and what the content of those communications are.
Okay. Number ending in 4146. Question is that chick a smoke? Again, 4146 question mark. I respond EH. I respond again, nutbag, as chief would say. I also respond with she's got a leaky balloon knot, leaks poo.
Is she a smoke? I assume that means, is she hot? Couldn't remember the second part. She's got a leaky poo knot. Sorry, she's a ball bag. That was the second bit. Okay. Yeah. Balloon knot. Okay. And they're embarrassing text messages he sent with his friend in Tennessee, some of them crude about Karen, you know, alleging she's from Scunthorpe. And we still don't know how anyone got these.
Um,
And what, if anything, is that in reference to?
Again, to misread some medical conditions there. Again, unprofessional comments I should not have made, that I'm not proud of.
Wait. Referencing medical conditions. So, like, is he alleging to his friend that Karen Reed is incontinent? Like, is that what he's alleging? Like, that she's actually incontinent, not just trying to insult her, but crudely saying she's incontinent? Wow.
As far as attitudes expressed within these text messages and other text messages, what, if any, impact did that have as far as your investigation was concerned regarding this?
These juvenile, unprofessional comments have zero impact on the facts and the evidence and the integrity of this investigation. Like I said, these are unprofessional comments, but they absolutely do not detract from the integrity of the investigation or the facts and evidence of it.
May I approach this retreat?
Yes.
Of course, like, I'd take that as she's full of shit, but he said something about a medical condition, and to me, that's not she's full of shit. She's lying. When he says medical condition, I just think incontinent. And yeah, it's secondhand embarrassment, absolutely. And that's it, JT Davis. It's it takes the sting out. You bring up the bad facts, and the jury's like, yeah, hey, it is what it is. You leave this to cross-examination, and it's gonna hurt. It's gonna hurt. I mean, Jackson's probably going to really try and dig in. So what exactly did you mean here? But and that could be it. It could be colitis, not incontinence. Although colitis can lead to that, I believe. But yeah. So we'll see.
Now, Trooper Proctor, you've seen text messages amongst yourself and a variety of
and that's a good point, Vince. So I happened to watch 2 of Yellow Cottage Tales videos this weekend. Well, I watched the entire Kevin Mahoney interview yesterday. I watched a little bit, like the last half of his interview with a reporter who's been in the courtroom and said the jury skews young. Now, what does young mean? Is it 40s? Is it 20s? Probably not 60s. And female. So the female, that could hurt. But young, the crudity maybe isn't such a big deal.
Different people from that same sort of iCloud area of your personal phone, correct?
Correct.
And among those, are there communications that you had with members of the Canton Police Department?
Yes.
And how would you characterize, or what was the general content of communications that you had with members of the Canton Police Department?
One communication was to coordinate interview times for firefighters and police officers and to set up a conference room where those interviews could be conducted. Obviously, the presence of Canton detectives or any police officers are not going to be sitting in on these interviews. Another communication was to inquire of relevant security videos that are in the area. Their local department, they know the area very well, so I had reached out and asked if there's some good cameras in the area that I had of kind of interest in.
Your may approach.
Yes.
I'm showing you another document. Does that recognize that?
Yes, I do.
What do you recognize that to be, sir?
Text communications between my sister and I.
That's your sister
Uh-oh.
Courtney, is that correct?
That's correct.
And similar to what I'd asked you about the prior packet, as far as a first message sent date and time, last message sent date and time, what is indicated on this first page?
First message sent date time, December 10th, 2021 at 9:30.
So another way you could put this entire line of questioning is this is pre-habilitation.
3 p.m. Last message sent 8:30, 2022 at 8:48 p.m.
And 8:30, that's August 30th, is that correct?
I'm sorry, yes, August 30th, 2022.
And similarly to the other messages, is there an indication as far as how many number of messages were sent between yourself and your sister over that time period?
2,865.
And fair to say that the documents in front of you do not contain 2,865 messages?
Correct.
Now, just in reference to the first message on page 2662, the first page in this packet, do you see that from December 10th of 2021 at approximately 9:33 p.m.?
Yes.
And what does that indicate?
A text message from my sister.
What does it say?
I called earlier, Dolph earlier, and mom was puking in the background.
And do you recall what that was in regard to?
From the sounds of it, my mother had a stomach bug.
Sounds like mom's in on the conspiracy too. Conveniently sick.
And sir, if I could direct your attention to page 2667. And these are text messages from January 29th, 2022, between yourself and your sister Courtney.
Correct.
And if you could read from the top of the page through the end, and please indicate to the jury as far as who's talking and who's saying what.
So I texted my sister at work, "What's up?" She responds, "What? Why?" I respond, "I just found it frozen to death on a front lawn in Canton this morning. Actually just interviewed Jen McCabe, said she knows you."
And they knows you, who are you referring to?
My sister.
And how did your sister respond to that?
Cut the shit. I responded, "You." It was a typo correction with my response to you. She responded, "Yeah, she knows Jack very well. She's really good friends with Julie." My sister continues on. Her sister is married to Brian Albert. My sister asks, "You still working?" ? I said, yeah, going to be out for a while. Homicide.
And as far as your answers to those questions, or as far as your communications that you had with your sister at this time on the afternoon of January 29th, what were those in regard to, or why were you communicating that to your sister?
At that time, it was just kind of in the news. I was just kind of letting her know I was out working. She didn't share anything specific. I wouldn't share anything specific on cases of my family or anyone. It was just kind of an overall innocent conversation.
Now, turning your attention to the next page, 2669. Again, if you could read from that page as far as who was talking and what the content is.
All right. My sister starts off.
So remember, Anne, homicide doesn't necessarily mean murder or even manslaughter. Homicide is basically unnatural death. Like that's not the exact definition, but like accidental death could be classified as a homicide. It's just, yeah, death by human. So
The Canton thing is a homicide. I respond. This is at 3 p.m. on the 29th. Don't say a word to anyone. She said, "Of course not." I respond, "In the very least, it's suspicious." She responds, "This is your livelihood." And then I would never miss with that. 3:07, I respond, "Julie and Chris were at the bar with the victim and girlfriend. Got to interview them."
I can direct your attention to page 2672. These are messages from February 1st, 2022. Is that correct?
Correct.
the one at the top starts about February 1st, 5:57 p.m. Is that correct?
Yes.
And again, if you could read through as far as who's speaking and what the contents of those.
I am making the executive decision that we're going 1.5 speed because I'm fading.
Messages are.
I texted my sister, "What's up?" She responded, "Nothing. I just saw Julie, and she said when this is all over, she wants to get you a gift." And I respond, "Get Elizabeth one." Elizabeth's my wife. And my sister responds, "Because I guess her and Chris were friends with John, and she's so proud of you for leading this." And then she writes, "Elizabeth?" ? I respond with, "She's been stuck with the kids for the last 10 nights."
So it would notice when this is all over, Julie wants to get you a gift for how you've handled it. It would be ridiculously inappropriate for Detective Trooper Proctor to accept a gift from any witness during the course of an investigation. After trial, he probably still shouldn't, except if it's someone he had a pre-existing relationship with. If, you know, his wife being friends with Julie Albert, that's probably fine. But, you know, if you regularly exchange Christmas gifts, might be a good idea to skip a year. Might be, you know, make sure it's in the same standard as your usual. Like, so in my legal ethics class, the professor really tried to hammer it home. The number one fastest way to get disbarred, like even faster than fiddling with your client trust account, you know, fiddling with money, is fiddling with clients. He said, do not have sex with your clients. It is the worst thing you can do. It is the fastest way to get disbarred. And Vince is right. They are not suspects. They are witnesses, though. But barely witnesses at that, because they weren't even there. They're family of witnesses, frankly. But number one fastest way to get disbarred is having sex with your clients. And you'd be surprised how often it comes up. Not with me, but, you know, there's that whole savior complex thing where the lawyer is getting you out of a jam and you're like, you want to go to the back room? Doctors get it too. So someone raised their hand, can't remember, it might have been me, and asked, what if you're already having sex with someone when they become your client? Would you be legally obligated to keep having sex with them? Like, would breaking up with them when they become your client, would that be the unethical thing? And his response was, of course, the lawyer answer, maybe. So, like, if you regularly exchange gifts with Chris and Julie Albert for Christmas, would skipping the year be the ethical or unethical thing to do? So long as it's, you know, the same as the usual tradition. And this is a question I don't actually know the answer to. I'm just, you know, a thank you gift, probably not. Christmas gift, when you always give a Christmas gift, maybe.
My sister responded, "Yeah, but she knew what life is like married to a cop."
And sir, as far as the gift that's mentioned, as far as Julie Albert, is that anything that you have received at any point in time?
I never received a gift. I never asked for a gift. My wife never received a gift. She never asked for a gift.
How would you describe this context of this conversation or why that's being discussed at this time.
Again, I don't know the thought process of my sister and Julie as far as bringing that idea of a gift into play. Like I said, I didn't ask for one. I never received one the same in my life.
Sir, if I could
So it's mentioned, it's in writing. The idea is out there. Put it to bed before the defense can run with it.
direct your attention to page 2676. And again, if I could ask you to start at the top of the page and read through and just indicate as far as who's saying, who's speaking and what they're talking.
I start out, we write like 8 to 12 warrants on each case. My sister responded, no, I have no idea what the hell you do or how it works. I responded on the 10th at 7:36 p.m. I'm starving, but I also just want to go home. Thanks, though. My sister responds, yeah, but is dinner going to be waiting? She responded with, ha, ha, ha. And then I responded, yep. And then my sister responded with, okay, it's fine. Mom and I just don't want to go home.
May I approach, Ron?
Yes.
And the thing is, Naven, I know it's become a meme, like Attorney Tom, it's literally part of his theme song. But the answer really is, it depends. Until you get down into the nitty-gritty details, the answer is it depends. Frankly, even once you get into all the details, the answer is still it depends, because, you know, what does the jury say? So.
May I approach the witness, Ron?
Yes.
Yeah, gross. Sisters have cooties.
I'm going to document, sir. Do you recognize that?
Yes, I do.
And what do you recognize that?
This is private messages between my wife and I.
Again, what is your wife's name?
Elizabeth.
And what, if anything, does that indicate as far as dates and times and number of messages involved?
Okay, so the first message sent 5/20/2022 at 6:19 p.m. The last message sent 8/31/2022 at 9:16 p.m.
And what, if any, indication does it give as far as number of messages within that text chain?
1,632.
And of those 1,162, there's one message that's listed on that. Is that correct?
Correct.
And what is the date and time of that message, and what does it say? Who's speaking?
Yeah, my phone was blowing up this morning with a group text. My opa's birthday was on the summer solstice, June 21st. And so 11 days from now would be his 98th birthday. When we were kids, he would drive us all up to Brighton Ski Resort, and we'd hike up to Dog Lake and have a picnic on top of a rock. And so my brother's like, well, it's time to start the tradition with his kids. And so he sent a group text to me and my sister and, you know, my cousins, my dad's siblings, saying, hey, we're doing this for Opa's birthday. You're all welcome to come if you want. So my phone was blowing up as I was trying to sleep. And it's just, yeah, it can just, you can have explosions of lots of texts.
This is me speaking on June 9th, 2022 at 4:56 p.m. I text my wife waiting to lock this whack job up.
And
oh no, a
what are you
whack
referring to in
job.
that text, sir?
I'm referring to the arrest after Ms. Reed was indicted by the grand jury.
And again, as far as the terminology that you use in that text message to your wife, why is it?
Again, unprofessional messages I should not have sent. I don't have an explanation other than they're regrettable and something I'm not proud of the language I used.
May I approach the retriever?
Yes. All right, so Trooper Proctor, the jurors can't hear you. So speak directly into your microphone the way I'm doing, okay?
Yes, Your Honor.
It's, as it was explained to me, you've got to eat the microphone to be heard, at least with some microphones. I've got a nice Shure microphone, And the software you can set. Is it close? Is it far? And the far setting is like 18-ish inches, which, microphone right here at the tip of my fingers. It's the right. So I set it far with the built-in software. But lots of microphones, you really have to eat it. It's the defense picks a horrible courtroom. The defense. And that too.
Okay.
But yeah, it's, and how old is this courthouse? In fact, I'm going to Google on my phone, Dedham Courthouse. Ooh, that's an old, well, Dedham District Court is the superior court in the same building. I don't know. Looks like it. It's got a rotunda, a dome on top, sort of
Unmuted.
front portico that's, I think those are Ionic columns, so sort of a classical, either Romanesque or Georgian, depending on, with a dome on top. So it's old. They wouldn't have built this recently. So let's Norfolk Superior Court, age, I don't see it quickly. Either way, it looks to be between 100 and 150 years old. It's old. It wasn't built for sound systems. You'd think it would have better acoustics since it was built before sound systems, but it's old. It's old as shit. It's, here in Salt Lake, the bankruptcy court is old. It's fancy as shit too. It's really neat. I've mentioned before, if I ever do my court show, I'd want to film the court scenes in the ceremonial courtroom in the bankruptcy court, which was, when I entered law school, it was the federal court, but they built the Borg Cube behind it, which will tell you that was opened in 2014, and it's hideous, but like technologically, I've mentioned the federal courthouse, it has individual screens for the jurors. So they see the exhibits right in front of them. They see the documents. They're probably 20-inch screens, one for every 2 jurors. But both rows of jurors have them. And then, put on a screen for the witness. Good sound system. Good, it's really nice. It's really nice. I've only done a few hearings in there myself, usually like status conferences, scheduling conferences, but, attending hearings for my old boss's case. Matheson Courthouse downtown, that's the state district courthouse, was, I'm going to say it opened about 95, I think. So not quite as technologically advanced as the federal courthouse. No individual witness boxes, but decent sound, like I've always been able to hear. It's I'm pretty sure there are YouTube videos of it. The big YouTube videos in Salt Lake County have mostly been in the West Jordan court, which is probably newer than the Matheson. Like, that's all fairly new, I think. But the one where the guy was allegedly set up to get a warrant by his public defender and all that big kerfuffle, Natalie, lawyer chick, covered it. I think Merb covered it. A couple others covered it. I didn't know him, but I knew both sides of the civil trial. I believe the defense attorney, so for the attorney representing the public defender, was a classmate of mine. The attorney for the defendant, who became the plaintiff in the civil suit, was initially represented by my constitutional law professor, but he dropped him really quick because I think he found out he was full of it. So, yeah. And that's why I put it to 1.5 speed. You just can't send me on squirrel hunting missions. Yeah.
Now, Trooper Proctor, are you familiar with conversations that's with any same-text communications from your personal phone with colleagues of yours at the state police?
Yes.
No.
Yes.
Vince, you have sent me on more squirrel hunting missions than anyone, and then called me out for it. Vince is always the instigator, even if someone else did it. It's always Vince's fault. Even if I'm just in someone else's chat. So, like, when you chased me the other day, Vince, from Artie's Corporate Fiction to, or what was the progression? I think it was Artie to Kfar to Merb that you chased me. Anything I did in there was also your fault. No, you were chasing me. You were chasing me. Okay, that's what I thought. And you enjoy it. He's probably insulted me before too, but he enjoys insulting Darcy more. Okay, this woman in the press in the sort of olive suit jacket right behind Yannetti looks kind of like a girl that was a year ahead of me in law school. I say a girl because she was a year ahead of me, but like 5 or 6 years younger.
Thank you. Your Honor, Coach Witness.
Yes.
Another document, sir. Before I get into that, though, if I could turn your attention back to some comments on the language used in the January 29th and February 1st or 2nd text communications among your friend group. With reference to that particular time frame and the language that you used, what sort of information had you gathered to that point, and why would you say or use that particular language in your, particularly in your descriptions of the defendant?
So this is, 16, 18 hours later, and I conducted multiple interviews.
Speak up.
Conducted multiple interviews. We knew Mr. O'Keefe never went into Fairview Road. We knew there was one shoe at the scene, one shoe at the hospital. Based off Mr. O'Keefe's injuries, Miss Reed's statements when Sergeant Buchanan and I interviewed her, her broken taillight, the missing taillight, some taillight pieces found at the scene, the compelling evidence pointing directly at Miss Reed that she struck Mr. O'Keefe with her vehicle, led me to make those comments. Whether, like I said, they weren't professional comments.
I probably shouldn't have had that monologue on 1.5 speed. He laid out his case. Yeah, we had found all this evidence, and it led me to make an unprofessional comment to my sister at this point. She's going down. Because all this evidence that I've already gathered led me to believe that she was. And that she was a whack job who had performed a whack job. So, and the thing is, he didn't even ask it as, lay out your entire case in one paragraph. It was, why did you say this? Because of all this evidence. So, he did it just for you, Anne, just for you.
But based on the day's investigation, it was clear that Miss Reed had struck Mr. O'Keefe with her vehicle.
Sir, if I could turn your attention to the documents before you, do you recognize those?
I do.
And as far as the participants in that particular conversation, who are the participants listed there?
It's Trooper David DeChico and myself.
And Trooper DeChico and yourself both work within the same unit with the state police, is that correct?
That's correct.
The thing is,
the professional relationship you have with yourself, between yourself and Trooper DeChico, how would you characterize your?
The thing is, why did you do this? Is no, you can't object, and none of his answer was objectionable. It was responsive to the question. None of it was hearsay. It was just describing, yeah, we had all this evidence, which led me to the conclusion she'd hit him, and therefore I made the inadvisable comment. So it's like, why wasn't he jumping up and down objecting? Because it was coming in anyway, and you don't sometimes you want to object to break the flow. Sometimes you don't object because you don't want to draw attention to it. It's like, maybe he wasn't objecting because that statement was so damning that he's just like, move on, move on, move on. Nothing to see here. Let's keep going.
Relationship, generally speaking.
We're buddies, we go all together, hang outside of work, our kids play together, so, and so, we're friends.
Now, within
So, in our second semester of law school, we all, everyone, not just in my writing class, but everyone in all 3 of the writing classes, because first year you take the exact same classes, we had to read the book, I believe it's called The Trial. And it's about a civil trial with a contaminated water supply in Massachusetts, conveniently enough, a Boston suburb, north of Boston. The local tanning mill had contaminated the water supply, and it was giving kids cancer. Like, at a ridiculous rate. And frankly, I should have Googled the trial. Instead, I'm on Google Maps. Woburn, spelled Woburn. It's pronounced Woburn or something. Edwin, you can correct me. But in the beginning of the book, it's talking about the attorney who, frankly, he went bankrupt prosecuting this case because it was overturned on appeal, so he didn't win, and he spent so much money. Like, that's something I didn't understand before law school was, the whole, oh, ambulance chasers. It's, you can spend hundreds of thousands, even millions of dollars leading up to a trial and expenses. And if you don't win, you don't get reimbursed. So it's like ambulance chasers, they've got to pick their case as well. And this was overturned on appeal, so he was driven into bankruptcy. But in the beginning, it was talking about his mentor, and his mentor said, you object with your legs. You never object sitting down. You spring up from your chair and you shout, objection. And you object to break their flow. You object early and often, just like voting. If you fall asleep in trial, you wake up shouting objection and then figure out what you're objecting to once you're awake. So, objecting as a performance art. Yeah. But once again, sometimes, even if you can object, you don't want to draw attention to it. You do not want to draw attention to it. And that's very true, Anne, because going back to that whole legal ethics thing, we can't. You cannot take a criminal case on contingency. There are a couple of practice areas you cannot do on contingency, and criminal defense is one of them. Of course, you'd go bankrupt if you did, just because you don't win. The prosecution wins trials. So you'd go bankrupt.
If, again, as far as the first message sent, date and time, and last message sent, date and time within this conversation, if you could describe that for the jury.
First message sent, date and time, March 17th, 2022, 11:08 a.m. Last message sent, date and time, August 18th, 2022, 6:08 a.m.
And again, the number of messages listed within this text chain.
87.
And fair to say the documents before you do not contain 87 text messages, correct?
That's correct, sir.
Now, just in general terms, if you have an opportunity to just look at the first couple of pages there, fair to say those are just sort of jokes that you have going back and forth between yourself and Trooper DeChico. Is that fair to say?
Yes.
Now, if I could turn your attention specifically to page 2632.
You can, like, you don't have to take all the money up front, but you can't structure it as contingency. You might be able to say, there's a bonus there, we'll refund part if we don't win. That might, I don't actually know. But going in, you do need to have it spelled out in the contract, either your hourly rate or your fee. And you just, like, legally, you can't do it on contingency. So.
And these are text messages starting on April 28th, 2022 at 10:52 in the morning. Is that correct?
I'm sorry, what was the time again, sir?
April 28th, 2022, 10:50.
You also can't in estate planning litigation, although maybe in probate you can in some states. I realize that sounds like the same thing, but It's weird. Family law also, no contingency. Back child support, yes. But divorce can't be done on contingency. Custody can't be done on contingency.
52 a.m.
Yes, correct.
And again, sir, with reference to this page, if you could read the content to the jury and please indicate who is speaking at each respective times.
Okay.
Gray Duck, for those of you who are offended by a little blasphemy, cover your ears for a minute. But, there have been jokes that, we're going to start the discount church, save your soul for 3%, a lot cheaper than the Mormons. They charge 10, but save your soul for 3%, money back guaranteed. If you don't go to heaven, you'll get your money back. Haven't put it into practice yet, though, so.
I said without a doubt, he's got diarrhea of the mouth too. Trooper DeChico, rookie move, not going into a meeting with the ME and getting that homicide determination. I respond, Yuri and I had 2 conference calls with her, sent her numerous photos, etc. We laid out the entire case for her. Trooper DeChico responds, not good enough, should have had me or Jeff do it. I respond, if you two did it, she would have made it accidental or natural causes.
And can you explain the context of those communications, or what exactly is it that you and Trooper DeChico are talking about in that communication?
Okay, so the ME is the medical examiner. They conducted the autopsy of Mr. O'Keefe. Our office, it's kind of a little bit of block.
That sounds like they're busting each other's balls. It's a good thing I did it instead of you, because you would have screwed it up. Not the evidence is bad, therefore the better liar did it. It's talking shit among friends. Once again, shouldn't do it, because you should expect your text to end up in court. But once again, if these are their private messages, how did they get out? They're on work phones. Don't do that.
Correct.
Hold on, wait for the ambulance and then speak up. The jurors can't hear you way back where the court officer's standing.
So like I said, the ME stands for medical examiner. They conducted the autopsy of Mr. O'Keefe. Because I'll address the conference calls Sergeant Buchanan and I had with the medical examiner. The doctor had some questions as to the facts and evidence, kind of what had transpired, which is common. Even if it's a homicide, I've had many calls with.
Every time I hear them say transpired, since, as I've said, everything boils down to a South Park or Simpsons reference, every time he says transpired, I think of the sort of redneck Homer from Shelbyville. Quick, boy, there's a doings a transpiring.
Medical examiner's office, even if it's a suicide or overdose, always with a homicide, the doctor wants to know what transpired. Trooper Chico and myself, we kind of like to bust each other's chops, go back and forth. So that's what he meant by saying, rookie move, not going into a meeting with the ME.
It's because these aren't exhibits. They're not going to be admitted. I don't know that he could publish these to the jury. So that's why they're not on the projector.
And getting that homicide determination. The original determination came back.
Sustained. Next question, Mr. Melling.
Now, as far as attending the autopsy, is that something that typically someone within your office would do, within your unit would do with regard to any sort of death investigation?
Yes.
And do you know who attended the autopsy of Mr. O'Keefe in this specific case?
Trooper Connor Keefe.
And so as far as Trooper Chico's reference to you not going in, or Sergeant Buchanan not going in, is that what you believe Trooper Chico was referring to with that message?
Objection.
Sustained as to the form.
His belief
You
is
indicated that you and Trooper
irrelevant.
Chico bust each other's chops. Is that fair to say?
Yes.
And can you describe a little more, expound upon that as far as the nature of your relationship and sort of the text messages that you exchange in this and then other communications that you have?
Basically just, kind of needling each other, and him doing that is by saying, texting me, rookie move, not going into meeting with the medical examiner. So that's a perfect example of him kind of just needling me, which we do on a daily basis.
And as far as your interpretation of that, did you interpret that as a serious comment or something said in jest?
I interpreted that as a typical joke from Trooper Chico.
May I approach the retreat?
Yes.
Mayor Pro Tem.
Yes.
So another document, asking, do you recognize that?
Yes.
Do you recognize that?
Text messages between myself and Trooper DeChico.
And again, what is the first message sent, date and time, last message sent, date and time, and number of messages contained therein?
First message sent, date and time, April 28th, 2022 at 1:09 p.m. Last message sent, date and time, April 28th, 2022, 4:45 p.m.
And the number of messages, sir?
4.
And the thing is, Naven, the feds never should have been involved. To me, it's corruption on behalf of the feds, possibly at the behest of the defense. It's wrong. It's wrong. It should never happen.
And if you could read the contents of those messages contained there, please indicate who speaks.
See you tomorrow.
So I started out, of course, it's undetermined. She was a whack job. Trooper DeChico responds, "Dear God, WTF, what the hell is inconclusive about the whole thing?"
And as far as your indication there, as far as she was a whack job, who are you referring to there?
Miss Reed.
Now, as far as the undetermined of what you're talking about, what is sort of the content or the context of this conversation?
That would be the manner of death was determined to be undetermined by the medical examiner's office.
So I ask you again, as far as your reference there in the bottom of the first.
Manner of death, undetermined, doesn't mean not a homicide, just means we need more information. So it doesn't mean not a homicide.
Stage, as far as she was a whack job, who do you believe you're referring to there?
Again,
Reed or the medical exam?
Miss Reed.
Mayor Pro Tem?
Yes.
That deposition was a nightmare. If it's the one I'm thinking of. And he is the one I was thinking of. Total douchebag. No, he's a bigger douchebag than a douchebag. He's a douche canoe. Make sure they're not slipping a Mickey. Oh yeah, you know he wanted to spring this on cross-examination. His bubble has been well and truly burst. But as I said, he shouldn't even have these. So it's only by corruption he has these.
I take just a second, Council.
Oh, seriously? We'll go right there.
And you notice the documents? Do those look up when you finish? Do you recognize those, sir?
Yes, I do.
What do you recognize those to be?
Another text thread between myself, Trooper DeChico, and Trooper Kokowski.
And Trooper Kaskowski is another trooper within your unit in the state police, is that correct?
Yes.
And again, if you could read from the first message sent, date and time, and the last message sent, date and time.
Bigfoot was wearing Lexus taillight shoes when Bigfoot kicked John O'Keefe.
First message sent, date and time, 5/24/2022, 9:21 p.m. Last message sent, date and time, 8/24/2022, 4:56 p.m.
And as far as the number of messages indicated within this text chain between yourself, Trooper Kukowski, and Trooper DeChico,
494.
fair to say the documents before you do not contain 494 text messages, correct?
Correct.
Just in reference to that first page 2635, first message sent, that's May 24th, 2022, around 9:21 p.m. Is that correct?
Yes.
That's a message sent from Trooper Kukowski, is that correct?
Correct.
And what is that?
Appears to be a picture of a toy Santa Claus.
Trooper Proctor is looking very red by now.
Now, sir, if I could direct your attention to page 2644. If I could direct you to the bottom of the page, sir, and see the text from yourself at June 9, 2022 at 11:19 p.m.
Yes.
Very bottom of the page. You know, I may approach just to point it out.
Yes.
Yeah, I see it, sir. Okay.
If you could read what you wrote on June 9, 2022, around that time, sir.
If you like women who shit themselves.
And again, sir, what is it that you're referring to there?
Again, a regrettable comment I made about Miss Reed's medical condition.
Now, if I could direct you to the following page, 2645.
I really need to restrain myself from commenting that May and June must be the month for criminal defendants shitting themselves in court.
And again, if you could read from that page as far as who is indicate to the jury who is speaking and what is being said on page 2645.
I'm speaking right now. The statement she made tonight at age 7 was mental. Thank Christ it was on BWC, which is body worn camera. Trooper Kukowski responds, that's her. Smoke. Trooper Kukowski again, what'd she say? I respond, said the Alberts beat the shit out of O'Keefe, left him for dead, and that's why her taillight was cracked. She's gross. Trooper DeChico, no, fuck her, bitch.
So maybe not, I want to fuck her. I want, you know, like I said, I thought the gist of this that I had heard from pretrial was, you know, I want to see her naked. I want to see her, you know, OnlyFans or whatever, but fuck her, bitch. Meaning not, I want to have sex with her. It's, I dislike her.
Thank you, sir. Can I approach you, retrieving arm?
Yes.
And sir, with reference to that last bit, as far as June 9th, 2022, what was going on that day in reference to this matter again?
Miss Reed is being processed at the Milton Barracks.
Thank you.
So June 9th,
Let me have just a moment, John.
Yes.
or oops, June 9th is the date.
Can I approach?
Yes.
Another
I
set
mean,
of documents to recognize those?
in Australia, it's a term of endearment.
I do.
What do you recognize those to be?
Another text thread with members from my office, troopers.
And who are the troopers that are listed within that?
Trooper Chris Moore, Trooper Jeff Kukowski, Lieutenant John Fanning, Trooper David Chico, and Sergeant Yuri Kennick.
And what is the first message sent, date and time?
That would be 5/26/2022 at 8:19 p.m. Last message sent, date and time, 8/26/2022, 5:36 p.m.
And what is listed as far as the number of messages within this chain?
651.
And it's fair to say the documents before you do not contain all 651 of those messages within this chain, is that correct?
Correct.
I think it was almost another year before the Turtle Boy nonsense began. So, yeah.
Now, sir, if I could direct your attention to page 2682. You see a message sent from Trooper DeChico on August 17th, 2022 at 9:42 p.m.
Yes.
And is that an image contained on the next page, which is 2683?
Yes, it is.
And what is the image of?
That is a picture of Mr. Yannetti, appears to be from quite some time ago.
Now turning your attention to the next page, 2684. And there's a response from you, August 17th, 2022 at 9:44 p.m. Is that correct?
Sorry, so go the date and time again, please.
So page 2684, 8/17/2022, 9:44 p.m.
Yes,
You see there's like sort of three responses from you.
I have you now.
If you could just read the three responses from yourself, sir.
Okay, so these came from me. Funny,
So I'm curious about the old picture of Mr. Yannetti.
going through his retarded client's phone. No nude so far. I hate that man. I truly am.
Now, with reference to the investigation at this point, when you're talking about his client's phone, who are you referring to?
Miss Reed.
And with regards to the phone at that point, can you describe to the jury sort of what's going on during this time period of August 17th, 2022 in regard to Ms. Reed's phone?
So after obtaining a search warrant for Miss Reed's phone, we weren't able to extract any data from it until August of 2023. Troopers in my office knew I was going through the phone that evening. I was most interested in location data, text messages, Google searches. That was the update I gave the troopers in the office. It was a distasteful joke. I should have gave a proper update instead of that. I wasn't able to go through the phone as thoroughly as possible because I came across some a text between an attorney and Ms. Reed, so I had to stop going through her phone, and I made my supervisor aware of those communications.
So this is a good point to ask. So how did you obtain Miss Reed's phone? A search warrant. Did she volunteer it? No. Did she try to fight the search warrant? Yes. Did she resist giving access to the phone even with the search warrant? Yes. Would she give the code even though she'd been instructed to do so by the warrant? Yes, she resisted. So the defense has made a mountain out of a molehill about witnesses not turning over their phone lock, stock, and barrel to the defense, but Miss Reed with a warrant has resisted? Yes.
Now, just in reference to what you just said, this is in August of 2022, is that correct?
Correct.
So after a search warrant is obtained for the defendant's phone, where did it go? You indicated you gave it to Trooper Garino, and where did it go?
Trooper Garino essentially hooks it up to a device called Great Key, where it tries every possible combination passcodes in order to access the data contained in the phone.
And at that time, when you retrieved it pursuant to the search warrant, you didn't have the passcode to the defendant's phone, is that correct?
Correct.
So that device is designed to sort of go through numbers and try to find a combination to get into the phone, correct?
Correct.
And so from the time that you had seized it in late January or on January 29th, 2022, until this date in August of 2022, had you been able to get into the phone or see anything in the phone in those intervening months or 7 months between January and August?
No.
And so then at this time that you're sending this text message in August of 2022, is that around the time that you were first able to access the phone?
Objection. I'll allow it.
Yes, that was the first time we were able to have access to the phone.
And with reference to your access to the phone, were you looking for nudes or anything like that in regards to the defense?
Objection. I'll allow it.
Like I stated, I was most interested in Miss Reed's location data, text communications, Google searches, things of that nature.
Were you looking for nudes? Objection. I wanted to ask him that on cross.
More evidence contained within the phone.
And so, sir, you mentioned at some point you came across some information that caused you to sort of freeze your looking through the phone. Is that correct?
Yes.
And so as far as that specific time period in August of 2022, when was the next time that you or any troopers from your office were able to actually look at any extraction of the defendant's phone?
Wait,
So
what caused him to freeze? That's what I want to know. What caused him to freeze? Did he come across attorney-client privilege information? Did he, like, why did he need to stop searching?
once I came across that text communication that took place on the 29th between Ms. Reed and an attorney, the phone had to be sent off to what they call a taint team to remove any attorney-client privilege information from the phone. And
did the taint team find any nudes? But like I said, I didn't know, but hey, we came across a text between her and her attorney. So we sent it to the taint team. Let them give us what we can see and not what we can't see. So, yeah.
And then it would be returned to us as well as defense received a copy of that as well. I'm not positive on the time. It was quite a long turnaround for that process to have be completed.
Sometime at least in the spring or summer of 2023. Does that sound about right?
That sounds about right.
May I approach the retriever?
Yes.
No,
Yes.
nudes, naughty pictures.
Thanks, sir. I have no further questions.
All right, so I'm going to see you at sidebar so I don't interrupt you, Cross.
All right. So basically, yeah, that was an interesting direct. Like, you know, there's the whole question of, is Trooper Proctor even going to testify? Is the defense going to call him? Like, did they call Sergeant Buchanan instead of Trooper Proctor just to avoid those texts? In general, it was, you know, here's a little information, like here's the tail light, here's the security video of when they were processing the vehicle a couple days later, and here's a bunch of distasteful text messages, getting it out of the way, taking the sting out of them, making, you know, taking the shock value away from the defense. So that was an interesting strategy. That is true. It would be news. Let's see, how long is... We're getting close. We really are.
You are unmuted.
All right, so just before you start then, so we'll finish at 4. We're trying to figure out the schedule this time. I'm going to meet with the lawyers and witnesses. We're trying to work all that out, but as it looks right now, I thought it was going to interfere with another day this week. As it looks right now, it may not. At the most, it will be half an afternoon or something maybe on Friday, but it does now look good that we'll be able to continue with this. We're out tomorrow, but Wednesday, Thursday, Friday will be full days, and we'll be able to keep moving. All right, Mr. Jackson, go right ahead.
Thank you. Trooper Proctor, in the summer of 2022, August 17th specifically, you were sitting at your desk, presumably alone at your office.
Fuck you.
About 10 p.m.
Presumably
at
at
night,
your...
going through my client's
Presumably alone. Fuck you. Stop with the comments, even in the middle of questions. Fuck you.
personal cell phone, correct?
Yes, sir.
As a matter of fact, you're sitting there texting with your friends and colleagues at Massachusetts State Police about you going through her personal cell phone. Is that right?
Correct, sir.
And that included Trooper DeChico. Is that right?
DeChico, yes, sir.
Trooper Fanning, Trooper Butnick, Trooper Moore, and Trooper Kaczkowski.
Kakowski.
Tell me that again.
Kakowski.
Kakowski.
Yes, sir.
All right. All the consonants are silent. Fair enough. Trooper Fanning and Trooper Butnick are your supervisors.
Yes.
And you were bragging to all 5 of them that you were going through Karen Reed's cell phone about 9:45 at night.
Objection.
I'll allow it.
Is that right?
No, I wasn't bragging, sir.
How did you refer to Ms. Reed in that text exchange where you informed them that you were going through her phone?
I use regrettable language. I said going through his retarded client's phone right now.
You were shown a photograph of my colleague, Mr. Unetti, correct?
Yes.
Can I approach?
Yes.
Same document on you. Your Honor, I think the court has
Boy, that looks like a real angry waddle from Jackson at 1.5 speed.
the copy that I was going to use.
I thought I gave him back to you.
It's in your neck of the woods too, Dante.
You'd received a photograph.
In fact, maybe more so in yours than mine.
Actually, Your Honor, if I could, I would ask that this document be marked as next in order. Assuming the witness verifies its authenticity.
So go ahead.
Do you recognize this document?
That's my
Same document
understanding.
that you were shown, copy of the same document that you were shown by Mr. Unetti, correct?
Still Lally.
I've done that twice. Mr. Lally.
Correct.
All right. Is that a true and accurate reflection of the text messages that you were exchanging with Chris Moore, Jeff Kakowski, John Fanning, Vito DiCicco, and Yuri Buchanan?
Shocking, Ann. Shocking.
Yes.
That's Mr. Moore.
Okay, any objection?
Yes, Ron.
All right, I'll see you outside on there. Have that, please.
Oh.
You-
Objection here. Interesting. And I mean, I expected more. Once he took the stand, I expected a full day of direct. Really, I think he was called just to take the sting out of it so that the defense didn't get the first crack at him. So I absolutely expected more. I'm not complaining that that's all we got.
You are unmuted.
5, 6, 7, you're on.
Yeah, I expected more testimony from him. The contents of interviews, the who they interviewed, how he put it together, the medical examiner. I expected more, but looks like what we got from Sergeant Buchanan is basically most of what we're getting from the state troopers.
Ask you to give it back to the witness, please.
And there's, it's Trooper Proctor did this. Oh, Trooper Proctor was there. Trooper Proctor's the root of all evil. And now we saw him. It's like, yeah, I screwed up. I sent dumb text messages that didn't mean anything. And oh, he's human. He doesn't have devil horns that we know of.
May I inquire now?
Yes.
Trooper Proctor, Trooper DiCicco had sent you a photograph of my colleague, Mr. Yannetti, correct?
Yes.
Your Honor, because of the technical issue, I'm not going to display on the television. May I display this part up briefly? Sure. Thank you. You see that, gentlemen?
I do, sir.
Is that the photograph that you received?
Yes.
Is that what you referred to on direct examination with Mr. Lally about receiving a photograph from Mr. Yannetti?
Correct.
And then your response was what?
Did Mr. Yannetti used to be fat? Like, is that what that picture was? I couldn't see it very well, but it looked like maybe he had fuller cheeks. Did Yannetti used to be fat? Is that why he's embarrassed of the old picture? Uh-oh.
I hate that man. I truly hate that man.
Actually, your response was, I'm going through his retarded client's phone right now, correct?
Yes, after the picture, sir, yes.
Who's the retarded client?
I was referring to Miss Reed, again, unprofessional language.
I'm asking who you're referring to.
Miss
I know
Reed.
you got an explanation. Who was it you were referring to as retarded?
Miss Reed.
He
Karen Reed,
already
who's sitting to my
said,
left.
asked and
Yes, sir.
Subject
answered.
of your investigation as a professional, correct?
Yes, sir.
As an unbiased, objective investigator. The person that you were investigating, you referred to your bosses as retarded, correct?
Again, poor language on my part.
Poor language is one way to put it. Completely offensive
Fuck
is another way to
you.
put it, right?
Fuck you, argumentative.
I've got to sustain that, Mr. Jackson.
After you referred to my client as retarded, then you decided to make a comment about Mr. Yannetti, her lawyer, correct?
Correct.
And what did you say about Mr. Yannetti again?
I hate that man. I truly hate that man.
I hate that man. I truly hate him,
Mhm.
correct?
Correct.
You didn't say I dislike him.
Asked and answered. Stop. Start objecting. He gave you the exact answer, so you have to repeat it as a question just to rub it in. Asked and answered.
Agree with him? You said I hate him, right?
Correct, sir.
That's a visceral response to someone who's just doing a job, right?
Objection.
So when you're doing this with Trooper Proctor. It sounds to me like you hate Trooper Proctor. He's just doing his job. Just doing his job. Why do you hate Trooper Proctor so much?
Sustained. You can ask it differently.
Sure. Let me ask it this way. Were you upset or annoyed or pissed off that Karen Reed had gotten representation, legal representation, to represent her?
No, not at all. That's her right.
Well, let me ask you this. In August of 2022, you said you absolutely hate it, correct?
I don't know if he was absolutely. Yeah, I didn't use absolutely, sir.
You used truly, correct?
Truly, yes.
How do you feel about it now? Sitting right there.
I still don't cheer for him now.
I'll let it stand.
I'd say I like him even less now due to the constant harassment my family has received at his behest over the past year. That's how I would have responded. Because that would be responsive to, how do you feel about him now? That would be my response.
What did you tell your colleagues that you were looking for as you sat at almost 10 p.m. at night on a Wednesday night, August 17th, 2022, looking through Karen Reed's phone?
I didn't tell them I was looking through anything. They knew I was going through Miss Reed's phone. I provided a inappropriate joke as an update. They knew I was going through location data, text messages, Google searches, like I had mentioned earlier. I had stuff.
Except for Proctor, none of that really professional sounding stuff ended up in your
Don't
comments to your
interrupt
bosses.
him, you muppet.
Again, it was a poor joke.
Yes or no?
Did you not know?
It did not.
No,
As a matter of fact, what did you write after you talked about going through the quote retarded client's phone?
Objection.
I mean, here, like I said, we've already had all this in direct. Jackson just wants to ask it with his angry voice. Make it sound really bad with his angry voice.
Allow it.
No news so far.
No nudes so far, correct?
Correct.
And you said that to your bosses.
Yes, sir.
You were looking for naked photographs of Miss Reed on a Wednesday night as you sat in your office at 9:44 p.m., correct?
No, not correct.
Let me ask you a question. Have you ever looked for naked photos of a male suspect that you were investigating?
I don't look for naked photos on anyone's phones.
But you said you were looking for nudes of Miss Reed.
No,
I
he
said, Mr.
didn't.
Jackson, it was an inappropriate joke.
You're mischaracterizing. He didn't say he was looking for any. He just said he hadn't seen any. There's a difference. There's a difference.
Sir, this is a citizen. She's a woman. You were supposed to be objectively investigating. Does your text message to your colleagues and Massachusetts State
Argumentative.
Police
Shut
reflect
up.
an objective investigation of a citizen?
Objection.
You can get part of that question and ask again.
Argumentative.
Do you believe that your text messages were reflective of an objective investigator?
Objection.
I'll allow that. Do you believe that, Trooper Proctor?
I believe poor jokes have, in unprofessional language, have no bearing on the integrity and the facts and physical evidence of this case.
It's not that they don't have a bearing on the facts and integrity. It's that they have no place in a professional investigation because it shows bias. Right?
Argumentative.
Objection.
So I have to sustain that as asked. Go ahead and ask it differently, Mr. Jackson.
You weren't so much as objectively investigating Karen Reed as objectifying her, correct?
Objection.
I'll allow that.
Is that right?
Rephrase the question, please.
You weren't so much as objectively investigating her as objectifying her in those moments, correct?
Why not
Again,
both?
Mr. Jackson, it was a poor choice of words and a joke that I should not have texted out. But from the start of the investigation, we didn't know what we had.
And your Trooper Proctor,
Let him
your
finish,
point
you
in saying no news
jackass.
so far to your colleagues in Massachusetts State Police was to
Lolly needs to object every time Jackson interrupts. You ask a question, let him finish answering the question.
suggest that you were looking for nudes and you'd update them when you found them, correct?
Incorrect.
Let me ask you a question. Did you find any nudes of
Again.
Karen Reed?
I didn't go through the photo, sir.
Did you find any nudes of Karen Reed?
I didn't go through the photo, sir.
You were successful in your quest.
I came across
Shut up.
text messages
Stop
from Ms. Reed from another
interrupting.
attorney on
Stop
January 29th, so I stopped
arguing.
looking through her phone.
So you got sidetracked before you could get to the naked pictures of Ms. Reed. Is that what you're saying?
Sustained.
To be clear, when you sent those text messages on that group chat, those text messages included, as we said, as you said, not one, but two of your supervisors, correct?
Correct.
Were you ever reprimanded for your conduct in sending that text message?
Objection.
So that's sustained. Do we need to go to sidebar based on what you told me earlier?
We do not.
Okay, so
I'll ask it a different way.
Okay.
Did either Trooper Fanning or Trooper Buchanan dress you down in a responsive text message in that text thread for doing something so abhorrent as looking for nudes or referring to nudes of a female suspect or subject of your investigation? Did that ever happen?
Not that I can recall.
As a matter of fact, in reference to one of the text messages in the same string, your boss, Yuri Buchanan, actually responded to the photo of Mr. Yannetti, didn't he?
Objection.
I'll allow it.
But Mr. Yannetti isn't Karen Reed. It's not about nudes. It's almost like, it's his gish gallop again of back and forth between the nonsense. It's, oh, so he didn't dress you down for the nudes, did he? Not that I remember. But he did comment about Yannetti, as if that's tacit approval of the comment.
He did, sir.
After you received the photo, that's when you said, I'm, quote, funny, I'm going through his retarded client's phone. Is that right?
Objection.
Allow this, but not too many.
Sure. Is that correct? It's on the top of page
Yes, sir.
685.
That's correct.
And Yuri Buchanan liked that comment. Funny, I'm going through his retarded client's phone. Didn't he?
I see you laughed at an image here, sir. I can't tell if he liked that comment, sir.
May I approach?
Yes.
I don't know if it's just because it's faded or, yeah, my copy's faded.
Top 2685. You can use my copy if that helps.
All right. Thank you.
What do you see on the top of that page?
Sergeant Buchanan liked it.
Like what?
The going through his retarded client's phone, sir.
May I approach?
Yes.
I'll take my copy.
There you go.
So your supervisors at Massachusetts State Police not only didn't
It really
ride
is
you for making
pathetic.
comments like this, encouraged it.
Objection.
Sustained.
Trooper Proctor, this is your direct chain of command. Is that right? Yuri Buchanan?
Yes, sir.
Did you believe that your conduct was a misuse of your authority and power as you were going through her phone in August of 2022?
Objection.
I'll allow it.
No, because I was searching for location data. That's not an abuse of my power. I had a warrant to search for that location data. Therefore, the court had directly authorized me to do such conduct.
No, I had a warrant signed by a district clerk, Stone District clerk, to go through Miss Reed's phone. I don't think it was an abuse of power. I had every right to go through that phone.
Did the warrant say anything about looking for news of my client?
I wasn't
Objection.
looking for news.
Did it say anything about that?
No, Your Honor.
Okay, next question.
So that would be an abuse of the power that was given to you by the court, correct?
Objection.
Sustained.
Argumentative.
Trooper Proctor, you'd agree that the hallmark of any good investigation, as you've been taught and others in Massachusetts State Police have been taught, is that the investigation and the investigator have to be fair. They have to be impartial. Would you agree with that?
Yes, sir.
Meaning that the investigation has to be free of conflicts, right?
Yes, sir.
The investigator has to be free of conflicts.
Lawyers use gallows humor too. I guarantee Jackson has used worse language than this, talking about witnesses, both as a prosecutor and a defense attorney. I bet we looked through his texts during the Phil Spector trial when he was a prosecutor. I bet there are lewd comments about his victim. There have to be lewd comments about his victim, Phil Spector's victim, from Jackson. And CJ5, good to see you. We're almost done. Almost done.
Right?
Yes.
The investigation has to be free of bias. Is that right?
Correct.
You can't be biased against the person that you're investigating. That would compromise the entire thing, wouldn't it?
Yes.
Basically, you follow the evidence. You're supposed to follow the evidence wherever it takes you.
And
right?
that's what he did.
Good or bad, top to bottom, just follow the evidence and report it back. That's how an investigation is supposed to be run, isn't
And
it?
that's what he
Yes, sir.
did.
And these are things that you learn early on at Massachusetts State Police Academy and then in your detective training. Isn't that right?
It is.
Literally, it's part of an oath that you took at the academy that you will, quote, faithfully and impartially discharge and perform all of the duties incumbent on you as a Massachusetts State Police trooper, right?
Yes, sir.
You swore that oath.
I did.
When you start an investigation, everybody in that investigation should be treated exactly the same. Don't you believe that's true?
Correct.
Everybody, have you ever heard the phrase, everybody's a suspect until they're not? Right?
Objection.
Sustained.
It's especially important early in an investigation before all of the facts are known that the investigator is not compromised by bias or prejudice, right?
Correct.
Most important early in the investigation, because that's when the most things are up in the air. There's the cloud, the fog of not knowing exactly what the truth is, right?
Objection.
Sustained.
And how does this apply months down the road when they finally cracked her phone? How is this relevant to his lewd comments months later? It's the Gish Gallop. Throw the jury off balance.
In other words, Trooper Proctor, you don't get to pick a suspect and then try to find evidence to support your choice, right?
Argumentative.
But in this case, it's exactly what you did, isn't it?
Argumentative.
All right, Mr. Jackson, why don't we end for today?
This is
Okay.
a good place to think. Thank you.
Okay.
All right, so folks, we're off tomorrow. Those same 3 cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, read anything about the case, please disregard it and let us know. We'll see you Wednesday morning. So Wednesday, Thursday, Friday, right now, it's anticipated will be full days of testimony.
Oh, she's really fighting the smirk before the jury's out of the room. She's really fighting the smirk.
All right, so one last time at sidebar for scheduling, okay?
All right. I don't care about that. What I do care is I really hate Alan Jackson. Every cross-examination makes me like him less and less. Less and less and less and less and less. And ugh. He's just so sleazy. So sleazy. And that's it. She's got this smirk. I don't think it went as like it's embarrassing for him, but it didn't help your case at all. It doesn't negate any of the evidence against you. It's just bad. And good night. Thanks for hanging out. I know it's late, and it's late for me too. I'm hungry. So yeah, that's yeah. If you can't be good, be bombastic. And he's a shouty little balloon knot leaking poo. And on that, do all the YouTubey things, like, share, subscribe, bribe your friends and family to do the same. And I will see you on Wednesday, assuming I don't do something else tomorrow, because you never know, but probably Wednesday. So have a great night and a great Tuesday, and bye-bye.